Good morning, friends. How is everybody today? Good morning, Judy. Hey, Jennifer. Hey, Nancy. What's up? Hey, Jill. What's up, guys? Good morning. My name's Debbie. Welcome to my channel. We are watching the Michael Peterson murder trial, also known as the staircase case. Hey, Wiggles. Well, you're awake. You mean, well. Hey, Paul. Good morning, everyone. I'm glad you're all here because we're going to do something a little different this morning. However, we're going to go read Judy's trivia first. Elizabeth Ratliff passed in 1985. I guess I should put it on the screen. Elizabeth Ratliff passed in 1985 from head injury suffered from a fall down the stairs in Germany. Peterson was the last to see her alive. It was ruled an accident. The prosecution found similarities between the deaths of the two women. The Durham court ordered the exhumation of Ratliff's I always want to say Ratliff's body in order to re-examine the cause of death. The Durham ME found sufficient evidence from the results of the autopsy, along with new witness statements, to overturn the earlier findings and list Ratliff's cause of death as homicide. As far as I know, he was never charged with her death. And one of the things that happened in the documentary, I think I already told you guys, but it really stood out to me. Hey, Dave. Wiggles. Well, he wasn't her next of kin. He was just a friend, so I don't think he could have. I mean, he could have suggested cremation, but it wasn't up to him in that case. But now you made me lose my train of thought again. Let's start timing you out. No, that was appropriate. That was not song lyrics, so that was on me. That was my bad. In the documentary, he got really, not like really mad, but a little upset because he kept saying, well, they need to talk to her daughters. She has 2 daughters. Hi, Julie. Welcome. She has 2 daughters that they should be asking her about exhuming her body. And I was just like, wait a minute. Why don't you want her exhumed? Because if you exhume her body and they find out she died of natural causes, that's good for you. You only don't want her exhumed if it's gonna show that you did something to her. So why wouldn't you want her exhumed? And your daughters that are her biological daughters that you raised, they think you're innocent. They don't believe that you killed their, for lack of a better word, stepmom. So, or their biological mom. So they want you cleared. So they should be all for exhuming their mother's body to prove that you're innocent. So it's a win-win. Like, I I don't understand why you're saying, "Well, you need to talk to her daughters. Your daughters are the one that should have a say about whether or not she gets exhumed." And I was like, "What are you doing, dude? Shut up and let them do it." So, right then, like, if I didn't already think he was guilty, right then I would've been like, "Oh, yeah, he's guilty. He did both of them." But yeah, and the daughters don't even the older one might have some memories of their biological parents, but the younger one, none. She was an infant. So, his point is kind of moot because if you don't remember someone, exhuming their body's not gonna have the same emotional impact as it would if you remembered this person in life. Not that it's not that it's not still a big decision and big undertaking to exhume your loved one, but if you don't remember them in life, it's a little different, I think. I mean, I could be wrong, but so I always thought that was weird. Okay, I'm glad there are 6 of you in here because I was thinking, "Oh, goodness. What is gonna happen if nobody's here this morning? Because 'Cause we're gonna do something a little different this morning. I found this yesterday, and I was like, "Oh my god, this is the most ridiculous thing I've ever seen." And then as the video went on, it's about 17 minutes long. As the video went on, I was like, "Okay, this is bizarre, and I have got to Google this woman." And the article that I Googled, I was like, "This is a conversation point. We gotta talk about this." So, hey, Jennifer. Hey, Jill. Did I say hi to you? Hey, everybody. Okay, I'm so glad you guys are all here this morning. Okay, so this is a woman that got arrested on Tybee Island in Georgia. Um, close to Savannah. I don't want to say it. Let's just play the video. You've been there. It looks beautiful. I thought it was Florida at first. It's gorgeous. And the creator is, hang on, let me check. Ape Huncho. Here, let me put the link in. I put the link in the chat. I've never heard of this creator before. I hope they don't get upset that I'm using their video. But I saw this and I was like, I gotta talk about this with somebody. Especially after I saw the article about it. This woman either unalived herself or was red rummed 8 months after this happened, which is why it's a talking point, and we'll talk about it after the video.
2021, officers from the Tybee Island Police Department descended on Tybee Island Beach in Tybee Island, Georgia. The police had been called by a member of the public because, according to them, a woman had walked past the caller's family tent several times and eventually had found a spot a short distance away in front of it. After placing a towel down on the sand, the caller said that the woman started touching herself inappropriately. I could hear moaning. As you'll see, the woman in question appears to be confused at first, but when confronted by the claims made against her, she starts to give her version of events and tries to reason with her actions.
That looks just like a Florida beach, y'all. I was like, well, this is Florida.
Nice. How you doing, man? Monster Dollar type. Can we speak to you for a second? We'll get you over there. Go ahead and bring your stuff.
But it's South Georgia, so.
Yep. All right. What's your name, ma'am?
Chris?
Chris?
Do you have your ID on you? Yeah, can I ask what the problem is?
All right. So someone called us. We got multiple calls about you. About something pertaining on the beach.
Yes.
Were you doing something you weren't supposed to be doing?
What?
Like, what were you doing on the beach? Like, prior to coming here? Prior to coming here. Were you at the beach at some point in time?
Okay, I don't understand. There was nobody. I was just sitting on my tail. Nobody was around me.
Okay, and you were over at the beach?
Like I was near the water.
Near the water?
Yeah.
Okay. All right, well, like I said, someone called and they saw you doing something you weren't
I
supposed to be
didn't.
doing.
No, that's not true. Okay, look, is this something that my phone should be off for or on for?
You can, whatever you want to do. It's your right. If you want to record this conversation, you can. But we are also recording, so you know.
Okay, can you show? I mean, who did I offend? I don't understand. What did I do? What did I do?
So apparently you're masturbating on the beach.
Who saw that?
I mean, a couple people.
No, they
families.
didn't. That's not true.
Why would they call us?
Okay, because I was by myself. Now I will tell you this: the only way that somebody would have called you is if it was a military operation. They're fucking doing this.
Military.
Never mind. Okay, so nobody was around. Was it an anonymous call? Is this one of my buddies? Okay,
No,
one of my buddies.
No, it's not one of your buddies. It's a family.
Okay, look, let me show you what I did.
Okay.
Okay.
Is there anything in the bag?
No.
Is it all right if I look through it? I mean, if you can open it and can I see the contents inside the bag?
Yes.
Okay.
I don't really understand what y'all are.
We're just here because someone called and we're very concerned. Okay.
This is really highly offensive to me.
I got it. I got you. And that's why I'm trying to figure it out.
It's my
It was highly offensive to the family that saw you.
And I just okay. Do I get a ticket?
So you did have a vibrator.
Listen, I was sitting on the water like this, and I just put it in there, and it was covered up, and I just had an orgasm. I'm sorry, I was stressed out.
I got you. Okay, just hang tight for me.
I'm sorry, nobody saw me. I was in the water. Okay, so if this is anonymous,
Okay. I mean, yeah.
People did see it. We didn't get a call for no reason.
I swear to God, I was sitting in the water. Nobody saw it.
I got you. Well, I mean, if nobody saw it, then they wouldn't have called, right?
Nobody saw it.
Man, please, don't do this to me. Are you serious?
You want to take my hand?
They not only saw it, they videotaped it and showed it to the cops.
I'm on it to take it since he's talking.
Okay, I got you.
This is ridiculous. What am I being arrested for?
Indecent exposure.
Indecent exposure.
No, but I didn't have any of my body
Someone
parts
called.
out.
It doesn't matter. A family saw it. They had kids.
What? There
That's
was
why they
nobody around me.
So.
Nothing in here that shouldn't be in here?
No.
Okay.
Well, I'm just going to throw this in here, okay?
We'll go through it at the car.
Yeah.
Is this yours, man? Full service?
Yeah.
I'm hoping this is Jesus Christ. Because it's not, this is not very well.
And the first walk through the restaurant. I kind of feel bad for her. Like, she's not a master criminal.
All right, awesome. Oh, it's right here? Sweet, thank you so much. What's your name? Ambrose? Yeah.
Yeah, she brought equipment.
Yeah, that's fine.
Thank you. Confirmation.
Ma'am?
Hey, Debbie. Debbie's about to say, what test did I look into? I'm so glad he has gloves on.
You got our ID yet?
No, we haven't gotten ready yet. I still have it in the bag. $15's heavy. Can you run a Georgia 27? Okay.
These are all broken up into half pills.
Okay.
Boiled peanuts. Use track.
Oh, Jesus. She said there's a vibrator in there.
Yeah, she thinks it is.
So,
No.
oh, nice. It's a bullet style. That's what they call it.
I sound up in your office.
Oh, Jesus.
Did he say bullet
You don't
style?
You logging everything.
Yep. The code book seems
Okay. I mean, and she admitted to it. And she said she had an orgasm on the beach and all that other good mess. So
She's
Yeah.
confusing
Alright,
that
cool.
with sex on the beach. That's
it's 6
weird.
o'clock. Alrighty.
That's
What's that?
called sex on the beach.
Mm-hmm. Gotcha.
I knew it.
I got you. And I mean, to be completely honest with you, I really don't care what you did, you know. But again, someone saw it, so that's why we're here, you know. I mean, if you're gonna do something like that, you know, don't get caught. That's all I have to say, you know. So I mean, I got nothing against you, you know.
Uh-oh.
34-year-old
Oh,
Christina
I fucking
Ashley
shut
Revels
down.
Glick was arrested
That's
and
the minute.
charged with indecent exposure and disorderly conduct. If you're not familiar with this story, then you may be thinking to yourself, well, that's the end of
pretty.
it. She went through the legal process and received her punishment. In the state of Georgia, a first offense of indecent exposure is classed as a misdemeanor, so you'd be right to think that she got a slap on the wrist. But what if I told you she didn't even make it through the whole legal process because she passed just months after her arrest? But the circumstances surrounding her death aren't as straightforward as you may think. Christina's life leading up into the beach incident had been a quote, wild one, according to one unnamed relative. And although there isn't much information about her early life, we do know that the beach incident wasn't her first run-in with the law. She got in trouble, got herself arrested. She went to prison in Florida. It isn't entirely clear why she specifically went to prison, but we do know that she had been arrested on a handful of occasions. In 2018, she was accused of stealing a car, and in that same year, she was arrested a handful of times for public drunkenness. Her life prior to the 2018 arrests was far from stable. You see, she had two sons with two different men, a 19-year-old from a relationship way back in the day, and a 15-year-old from a marriage that ended in divorce in 2015. Although the divorce went through in 2015, the marriage had broken down years before. Just 6 months after the 15-year-old was born, she left the family home to go on her own journey in life. The child was left with his father. Over the years, she had little contact with either of her children and their fathers, but on at least one occasion, she and her at the time husband rekindled. After she spent time in jail, her husband took her back, but she was wild. A short while after they got back together, she fell in with a real bad crowd. She was drinking and taking drugs. By 2020, Christina had made her own way in life once again, and she had been living at a property in Hinesville, Georgia. I'm not judging, but there were a lot of men, and we heard she worked at a strip club too. She was always nice to talk to, always smiled, said hello to our kids when she was coming in and out. She always paid her rent on time. In that sense, she was a model tenant. Then came March of 2022. On the 19th, landlady Felicity Rollins contacted police to request a welfare check on Christina. She had missed her latest payment for rent. A couple of weeks had gone by and Felicity couldn't get hold of her. When police arrived, it was reported that, quote, negative contact was made. Then they left. Remember, Ashley wasn't considered a vulnerable adult in the eyes of authorities, and there were no reports to police that she could be in any sort of danger, so there wasn't much they could do about it. Over the next 12 days, Felicity continued to try and reach out to Christina, but all attempts failed. Then, on the 31st of March, 2022, Felicity and her boyfriend decided it was for the best to enter the property to see what was going on for themselves. It was then a gruesome discovery was made. I was sitting waiting in my truck when Felicity and her boyfriend came down and said, "Something's wrong. We think there's a dead body in there." They pretty much turned straight around when they opened the door. I didn't believe it. I thought they were messing, so I went up. When Felicity's family friend, Gareth White, entered the apartment, he knew straight away that someone had died. The smell alone was enough to tell him that. And so there she was, Christina decomposing on the floor in the property. She had been dead for roughly a month. After an investigation, detectives concluded that she took her own life for reasons unknown. But people connected to the incident don't really buy into that story and want police to explore the possibility that she may have been murdered. After the discovery was made, Felicity asked her sister Whitney Phillips to act on her behalf moving forward, as the incident was too much for her to handle. When Whitney entered the property, she noticed that there was blood in every room. Not only that, but there was other evidence to suggest foul play. There was blood in every room in the apartment, but there were other things like unopened packages, things for the apartment, like she was expecting still to do things. Why would she be ordering stuff for the house? Why would she still be paying her bills if she was planning to end it? She was never late on rent. I didn't sleep right for a week after seeing the inside of that apartment. You could see the marks on the wall where her body had been, and on the carpet where it had laid. To me, it looks like she was panicking, trying to get...
You gotta admit, if somebody shoots themselves, there's not going to be blood all over the place. There's not going to be bloody handprints on the wall. So that is kind of suspicious. Uh-oh. Darn it, I said the word. Oh. I said, don't be suspicious. No, don't be suspicious. 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 Don't be suspicious.
John Ralphio?
Kom! Kritiken stannar så! Kom grabbar! Kritiken stannar så! Kritiken stannar så!
away, trying to save her life. Why would she be moving through the house like that? That doesn't make no sense. Jonathan Johnson and his wife Jasmine, downstairs neighbors, think Christina was murdered too. The Johnsons believe they had the actual murder taking place but didn't want to intervene because they weren't too sure. They say a man who Ashley had been seeing needs to be taken in for questioning. I believe that dude killed her. We had a lot of commotion that one night, then we never saw her or heard her again. I asked, should we call the police? But you're not too sure sometimes. Like, if you get involved, maybe you'll get hurt too. That guy was there all the time and his car was over there that night. When we came out the next day, it was gone. That night, it was like a lot of heavy walking and moving around going on. After that, it was just silent up there. And so, it's been well over a year since police reached their conclusion. We can't rule out that they'd ever change their theory and investigate the possibility that Christina was murdered, but we can say, for at least now anyway, that they don't think she was.
Okay, so that was the video. Now, the article why is this here? The article was on Beach Grit. The tragic life and death of Christina Revels Glick, named and shamed after performing a sexual act with a vibrator on Tybee Island Beach, has some of the same quotes that was in the video about her being wild or whatever, but they're saying that she took her own life because she was humiliated by the arrest after what happened. Support for Christina Revels Glick has emerged as a crucial part of advocating for privacy rights. Now, if you're doing something in public that should be done in private, I don't think you have privacy rights because you're in a public place. A Tale of Two Americas, where a glamorous brunette faced severe backlash for a personal moment of pleasure with a battery-powered tool on Tybee Island near Savannah, Georgia. This incident reflects a broader cultural conversation about sexuality and public decency. But does it? Does it really? They arrested the wrong person. The focus should have been on the individual who violated her privacy by recording the incident instead of on Christina, who was simply caught in a vulnerable moment. What do you guys think? I mean, if I had seen that, if I had been vacationing there and I had small kids and whatever, and maybe it's my generation because we didn't have cameras in our pockets, I would have covered my kids' eyes or turned them around, and we would have gone up the beach, back to our hotel room, whatever. We would have left the area. There were kids. There were kids. She said there was nobody near her. She was all by herself. She said it was impossible for anybody else to have seen her. But there was a family, a husband and wife and kids. She just didn't see them. They were close enough that they got video of her. So the one article was saying her privacy was violated by the other people. Yeah. Oh yeah. But the article is saying her privacy was violated by the people on the beach. No. That's a public beach. You're there with your kids having fun. You don't want to watch a woman with a vibrator getting off. I mean, you don't do that on the beach. You do that at home. Yeah, exactly. Right. Yeah. Yeah. Her privacy wasn't violated. What was violated was this was a family probably on vacation, minding their own business, and then this woman is doing something inappropriate on the beach. Right, Debbie, there's no expectation of privacy when you're in public. That is why you're allowed to film in public. You know, you see these Karen videos where they're like, don't film me, don't film me. You're in a public place. Anybody can film you out in public. It's not against the law. I don't either. I think she was murdered. I think it's just a coincidence that it happened before this case had been resolved. Because if you yourself, you're not going to have bloody handprints on the wall. Yeah, I would have just, covered my kids' eyes, turned them away. I don't know that I would have called the cops. I would have probably just let it go and just, shuffled my kids away where they couldn't have seen it. Like I said, different generations. We didn't have cameras in our pockets. We didn't think to just grab our phone and record everything. Yeah, but she was in public. You should know better. Absolutely, you should know better not to do stuff like that. You have no expectation of privacy. It's just, but I saw that and I'm like, because when after the body cam part, when they started telling her story, I was like, why have I never heard about this? I was like, oh my God, I have to Google her. And I Googled it and I found that article and I was like, wait just a minute. And regardless of her past, regardless of anything she's done before, that she stole a car or whatever, and she was in prison for a while, it doesn't matter. Forget all of that stuff. Just forget it. She was in a public place doing something that should have been done in private. She was seen by people. What she did was illegal. And it was a misdemeanor. Like, it was going to be over and done with. And she could probably get some type of deferment where it could be expunged. But in her case, if she did have a criminal record, it didn't really matter because she already had a criminal record. So, can you imagine? I'm sure it was embarrassing. I'm sure it was very embarrassing. But yeah, exactly. Exactly. That's what it was. I don't think that she unalived herself because I'm sure she was embarrassed. But I don't think that's what happened. But when I read that article, I was like, "Oh my god." But that's the mentality nowadays. It's just like, let people do whatever they want. No. No, 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 no. Okay. Now we're going to go back to Michael Peterson. This guy, forensic, this still makes me laugh. These two words should not go together. Forensic meteorologist. That cracks me up every time I see that. And it's outside the presence of the jury. And I think the reason it's outside the presence of the jury, it's probably because Rudolph has a problem with this guy. Why do they need a forensics meteorologist? It was inside. Like, do we need to know the temperature or something? Why do we need a forensic meteorologist for this one? Hey, Robbie. Yeah, it was a fun rabbit hole, wasn't it? Saw that yesterday and I was like, I gotta talk about this. Like, I have got to talk about this. If anybody missed it, go back to the beginning and watch because that was good. Oh, wait. People are still talking about the video. Hang on. Well, I'm not, like I said, I'm not quick to just flip out my phone and start recording stuff. I still, oh God, he started already. I don't know why my dog has started just barking for no reason. He used to do the cute little whimper thing that Judy calls squeaks. Doesn't do that anymore. He just barks all the time and drives me crazy. I still have a hard time when I'm live streaming at Disney because, like, I don't want to get anybody on. Like, when I'm in line for a ride or something, you'll see the wall or so whatever because I don't want to be recording people. Even though at Disney you have no expectation of privacy at all whatsoever. I still don't want to get a bunch of people in the video because I never know if someone's going to turn on me and be like, "Why'd you have me on video?" So, yeah, it is dicey. I would never just grab my phone and record somebody unless they were threatening me or something like that. That would be I thought that was just for sound though, Judy. I thought actual video with no sound you could do. I don't know. I'm not a lawyer, so I don't know. Nancy. Oh, Nancy. Nancy won best comment. Oh my god, best comment of the day, even though it's the first thing in the morning. It's still, I don't think anybody's gonna top that comment today. See, that's what I think. Like, you can say, Alexa, talk like Yoda, and she'll say something with like out of order, like Yoda talks. So I don't know, that was good, Nancy. Don't um so I told my cousin who's a big Star Wars fan, I'm like, tell Alexa to talk like Yoda. And she goes, I don't use Alexa. She's a spy. I'm like, what do you mean she's a spy? And she goes, she'll listen when you don't want her to. She spies on you. And I'm like, so? I don't have anything to hide. What difference does it make if she spies on me or not? And my cousin was like, oh, I don't like it. She listened, and then she tells me all these stories about weird things that Alexa does. I'm like, so? If I don't have anything to hide. Oh, and there was a Super Bowl commercial too about Ring Doorbell has this new thing where it'll help, like, if you lose your dog, it'll help you find your dog. I forgot what it's called, but there's some new thing you can activate on a Ring Doorbell camera that will activate the other Ring cameras in the neighborhood to look for your dog. And I was like, that is so cool. But people are freaking out about it. I'm like, why are they freaking out about it? That's a good thing. And then if they can make it where it can find missing people too, that's an even better thing. Like if somebody's missing and all the Ring cameras in the neighborhood can activate, like use facial recognition to find somebody that's missing. How is that a bad thing? If you don't have anything to hide, why are you afraid of being recorded? But that's my opinion on that. Yeah, like, if you go in a store and they have recording, like Walmart, you can look up and see yourself on the screen where they're recording you, but there's no sound. So I always thought the consent thing was sound only, but like I said, I'm not a lawyer, so I don't know. Oh yeah, that's true. Oh yeah, what? Jill, what? Oh, who was it? Jill was sending me pictures of somebody the other day. William Shatner. Believe it. Jill sent me some pictures of William Shatner the other day. Why am I frozen? Oh, there we go. That was a bad freeze. And now I'm getting stuff on my phone on my Google feed about William Shatner. That was in a private DM. She was sending me pictures of William Shatner. So, spooky. And it's happened before when we've been talking about something that it started showing up in my feed. And that's a private DM feed between me and Jill. So, Jill, we're being spied on. We need to be careful. Okay, so back to the forensic meteorologist. So it starts off outside the presence of the jury, I think, because Rudolph is probably going to want to voir dire him as being an expert. Hey, We miss you too. Where have you been? I was thinking about maybe doing this, maybe not every morning, but maybe once or twice a week. I know, like sometimes that happens occasionally, and that has to be a coincidence. I always say I don't believe in coincidences, but that one has to be because there's no way AI is reading my mind. Or is it? Okay. Sex on the beach is a really good drink, though. I haven't had one of those in, gosh, 30 years? 25 years at least. The last alcoholic drink I had was blue milk with rum at Galaxy's Edge, which is the Star Wars world at Hollywood Studios. I said I always wanted to drink blue milk when I was a kid because Luke Skywalker drank it. But now I'm an adult, so I can drink it with rum in it. It's really good. It's really expensive. It's like $20. And the glass is like literally that big. It's like it's not a big glass. It's like that. For $20, but it's good.
Yes.
Why don't you state again for the record what your objection is, sir?
Yes, for the record, our objection is we've been given, it's not yet marked as an exhibit, but it's a single page chart that appears to be a graph of temperatures. It says Raleigh, I think it's RDU, during December 8th and December 9th of 2001. Our objection is that there's a green band that appears in that chart that says DOE winter comfort zone at 95% RH.
I know.
I'm assuming that the state is going to try to argue that that is somehow a zone of comfort.
They have green milk too, but I don't want it because I've seen where it comes from. The blue milk, I've not seen where it comes from, so I'm cool with the blue. But I don't even want to try the green.
Which would be relevant to whether somebody, in fact, would be comfortable being outside at a given temperature. We've not been given this before today. Apparently, this witness is going to be tendered as an expert. We've never been told that before today. We were given the underlying temperature data, but we weren't given any indication there was going to be some kind of expert testimony about what I'm assuming is a Department of Energy winter comfort zone. So we've had no time to research that or prepare for that. In addition, the jury is perfectly capable of reaching their own conclusions about what a given temperature is comfortable or not. Expert testimony is only permissible if the expert can have information the jury couldn't reach on their own. And whether a given temperature is comfortable is something that's clearly within the province of the jury to reach on their own without any expert telling them what is a proper comfort zone. So that is the nature of our objection, and we wish to be heard on the nature of this comfort zone and what it's based on and the meaning of it.
Mr. Harden.
Well, Your Honor, I did inform them that we intended to call a meteorologist, and certainly we're in the process of doing that. So the fact that they're now saying that we did not inform them of that is not accurate. They were provided the data from the U.S. Department of Commerce that supports this chart. The term comfort zone, it is my understanding, is a term that is used in the field of meteorology, and it's the state's view that this forensic meteorologist, as he will be tendered, can define that. He can describe what it means in terms of meteorology and in terms of human comfort. That's something that would be within the purview of an opinion that he could give, and we'd ask that you allow us to do it in that form.
Well, because the defendant has indicated that they haven't seen that particular chart, I will allow them to conduct a voir dire so that they can have some understanding as to what that chart means. at least in the eyes of this witness. So why don't you go ahead and conduct your voir dire, Mr. Harden? He needs to be sworn.
Does the court wish for me to go through the entire voir dire as it relates to tendering as an expert and to all the issues that he will discuss, or just as it relates to tendering him as an expert and as it relates to these particular concerns expressed on this diagram?
Well, for sure, I want him to explain the exhibit because defense counsel has indicated they haven't seen it and they don't know what those things mean.
Yes, sir.
Had they had the chart, they would have prepared at least beforehand to deal with the cross-examination. Now, Mr. Rudolph, Mr. Maher, I'm not sure what other issues you want him to address during the voir dire.
I don't know what other opinions they're going to offer. And just so the record's clear, at least I was informed yesterday that we would have a meteorologist today to put in what I understood to be the underlying temperature information. We have no objection to the factual information that it was 52 degrees or 53 degrees Fahrenheit, and that's not an issue. You don't need an expert for that. You just need the underlying data. I'd like to know in advance of any opinions that this witness is going to offer as some kind of expert on what the significance of those temperatures or other weather conditions are. All we've got right now is this comfort zone. If there is opinions beyond the comfort zone, then I think we need to know what those are so we can explore whether they're reliable and if they're admissible.
Mr. Hart, I think you should conduct your voir dire, including any opinions this witness is going to give.
Yes, sir.
All right. He'll need to be sworn, Mr. Hart. Ms. Hart.
Sir, if you please stand, place your left hand on the Bible and raise your right. Raise your right. Raise your right hand.
Raise my right hand.
I'm sorry. You solemnly swear the testimony you're about to give the court to be the truth and nothing but the truth, so help you God.
I do.
Maybe we need another clerk. I don't know.
For the purpose of this hearing, please state your name.
My name is William H. Haggard.
And Mr. Haggard, if you would you describe exactly what your field of expertise is?
I'm a certified consulting meteorologist, and for the last 27 years, I've specialized in forensic meteorology.
Will you take just a moment and describe, if you would, all your educational background and training as it relates to the field of forensic meteorology?
Surely. I have a Bachelor of Science degree in physics from Yale University in 1942. I have a certificate of professional meteorology from Massachusetts Institute of Technology, also in 1942. I have a master's degree in meteorology from the University of Chicago in 1946. And I have a year of graduate work sponsored by the U.S. government at Florida State University in meteorology in 1958-59. I served 2 tours in the military as a meteorologist. The Navy called us aerologists, but it was meteorology. And I've worked for the federal government for 32 years as a professional meteorologist, a forecaster and analyst, a research meteorologist, the director of the National Weather Records Center, which became the National Climatic Center, from which I retired in 1975, and I formed Climatological Consulting Corporation, which specialized in expert testimony and litigation where weather was a factor. So
if you could speak up just a little bit or come a little bit closer.
Surely. I'm sorry, Your Honor. I hear myself so loudly in my own ears. I apologize. I retired from the federal government in 1975. I formed Climatological Consulting Corporation in 1976. I sold it in 1999, but have remained as a consultant to it. And during those 27 years, I specialized in retrospective reconstructions of weather to assist the court in trials where weather was a factor.
On how many occasions approximately have you been qualified as an expert in the field of forensic meteorology?
Something over 200.
Would that be in the state and federal courts?
Yes.
Now, with respect to your field of expertise, were you asked to do a reconstruction of the climate and weather and temperature as it related to the area of Durham, North Carolina between December the 8th and 9th of 2001?
Yes, sir.
If you would please describe how you went about that process.
You had provided me with several days of data from under Department of Commerce Blue Ribbon and Gold Seal for the Raleigh-Durham Airport. to make sure that that was descriptive of the weather in Durham. I obtained weather data from a number of other stations. I reviewed the weather maps for the 2 days, and I reviewed the hourly data observed at Danville, Virginia, Greensboro, North Carolina, Raleigh, Durham, Goldsboro, Fayetteville, and Rocky Mount. And I constructed graphs of those and compared them, determined that while the temperatures were different in the easternmost ones because a cold front had passed during that 24 hours, that the temperatures at Danville, Greensboro, and Raleigh, Durham were so similar that they were representative of that entire area of the state, including Durham.
Now, based upon, well, let me back up. Why did you choose to look at all those various locations when you were really just concerned about the area of Durham as well as the temperature and climate?
We didn't have a complete weather station in Durham. The nearest one was at Raleigh-Durham Airport. If the situation was one where there was a large gradient of temperature, big differences from one location to another, the Raleigh-Durham data might not be representative of those in Durham. So I looked at the entire area to determine the homogeneity of it. And while it was not similar to that in Goldsboro, Fayetteville, and Rocky Mount, all of which were warmer, because Raleigh-Durham airport is east of Durham and the other stations are west and northwest of Durham, and their data were so similar, then I determined that the Raleigh-Durham data were representative of the Durham area.
Now, based upon the information that was provided to you by us, that being the U.S. Department of Commerce data and the data that you collected on your own, did you then prepare a chart describing temperatures at the Raleigh-Durham area on 8 and 9 December of 2001?
Yes, I did.
May I approach witness, please?
Yes.
Let me show you what is marked as States Exhibit 138 and ask whether you recognize that.
Yes, that's the chart that I prepared.
And you prepared it based on the data that you accumulated?
Yes, I did.
Okay. With respect to the diagram, if you would please just generally describe what information is contained on it and why you chose to place that data on this chart.
Across the bottom of the chart are hourly marks. It's a time graph that runs from midnight on December 8th to midnight of December 9-10. And on the vertical scale on the chart are temperatures in degrees Fahrenheit. A red line simply denotes the hourly values of temperature in degrees Fahrenheit. There's a vertical yellow bar which says at pool, which goes from 11 p.m. on the 8th to 2 a.m. on the 9th. And I was told that that was the time of particular interest and that an individual had been seated near a pool during that time. And then there's a horizontal green bar, which is a representation of the comfort zone at 75% relative humidity in the winter Department of Energy comfort zone. A comfort zone is that zone of temperature and humidity at which ordinary people are comfortable.
All right. Now, how is that specifically defined?
Well, there are two definitions. There's one in the definition in the glossary of meteorology, which is the standard for meteorological terms. It's a rather long one. It says comfort zone, the range of temperature, humidity, and air movement under which most persons enjoy mental and physical well-being. As represented on comfort charts of the American Society of Heating and Air Conditioning Engineers, comfort zones are areas bounded by curves of the effective temperature and the relative humidity. The limiting conditions vary somewhat according to season and to the native climate of the persons or group. In the United States, the comfort zone with normal ventilation lies between air temperatures of 17 to 24 degrees Celsius, 63 to 75 degrees Fahrenheit, at a relative humidity of 70%, and 19 degrees Celsius, 67 degrees Fahrenheit, at a relative humidity of 30%, giving an effective temperature, and it goes on and on and on. The the one that I used was not quite the ASHRAE, American Society of Heating, Refrigerating, Ventilating Engineers one, but one that was taken from one that's generated by the Department of Energy, and with very similar values. In this case, their winter comfort zone at 75% relative humidity is from 67 degrees to 72 degrees.
All right. Now, with respect to that terminology, what significance does that have to a forensic meteorologist?
Well, it determines the question was, would a normal person, normally attired, be comfortable in the temperatures that occurred at the time? And if the temperatures were very slightly outside of the comfort zone, the answer would be probably so. If they were far outside, the answer would be probably not.
All right. Now, with respect to the temperature between the period of 11 o'clock on the 8th and 2 o'clock in the morning on the 9th, what would those temperatures have been?
They fell gradually during that time interval from 55 degrees Fahrenheit to 51 degrees Fahrenheit.
And what was the relative humidity, if you know?
It was mostly over 85%.
And if you would please define what humidity is and what 85% relative humidity would mean.
All right. Very dry air has very low relative humidity, and very moist air has a very high relative humidity. The relative humidity is the amount of water vapor that's present in the atmosphere in terms of the maximum amount of water that the air could hold. So at 100 degrees, 100% relative humidity, the air is saturated, and any more moisture will cause condensation, either as dew or fog or some other form of visible moisture. At very low humidities, it's quite dry.
Okay. And what would the humidity have to do with an individual's physical comfort?
Basically, if the temperatures are very high and the humidity is very high, it inhibits your ability to sweat, and you feel hotter than you would if the humidity were low. If the temperature is low and the humidity is high, you feel colder than you would if the humidity were low.
You know, that's essentially all I'll ask.
Any questions? Yes, Your Honor. Let me begin with a little bit about how you got involved in this case. My name is Tom Maher. I'm one of Mr. Peterson's attorneys. When were you first contacted by anyone for the state to do work on this case?
I don't have the precise date before me, but sometime in the order of a month or so ago, Mr. Sachs telephoned me and asked.
I didn't mean to cut you off, but did you know whether the trial had already begun? I'm trying to get a time.
I have no idea.
Okay. And did you prepare any kind of written, other than this one chart we've seen, have you prepared any letters or reports or other charts or graphs?
I sent Mr. Sachs a number of graphs, one for each of the stations that I mentioned.
Okay, go ahead.
And I have copies of the daily weather maps for the 2 days. And I have a different graphic which shows temperature versus relative humidity and the Department of Energy comfort zones with the temperature during this at pool time marked on that.
And you have material that you've prepared or relied upon with you here today?
I beg your pardon?
The material you're describing, the various charts you've been on, you have that all with you here
Yes,
today?
I do.
Okay, and I'm going to ask in a moment to look at that. Did you prepare any kind of written report or letter summarizing the work you've done and the conclusions you've reached?
No, I did not.
Okay, and are you being paid for your time in working on this?
Surely.
And how much are you charging?
Well, the company pays me a lower amount than what they charge, but they charge $160 an hour for my time.
160?
Yes.
And then are you paid by the hour in turn for your work by
Yes.
the company, and how much are you paid?
$128.
Okay. I'm going to ask in a moment to
How many hours?
ask in a moment to look at the materials you have up there. Let me ask you, have you kept track of the time you've spent on this case so far?
Yes, I've turned my time in on each day that I did any work on the case to my secretary, and she summarizes it and sends it to the company, and they prepare a bill and send it out.
And do you know, as of today, how much time you've put in?
No, I do not.
Do you have those bills available somewhere?
Not with me. I haven't submitted any for this month. I think I submitted a bill to Mr. Hardin's office, or I sent it to Chronological Consulting Corporation, which I presume sent it to Mr. Hardin for last month's work.
Okay, and have you submitted bills to your company for this month's work?
For what?
For this month's work, have you been sending bills to your
No,
company?
I'll do that either when I complete the work or at the end of the month.
Okay, and you have notes about the work you've been doing? In other words, on a given day when you do work, you take notes of what you're doing and what you're spending your time on?
No.
And how do you keep track?
Well, I put down what I did. It was acquire data, review data, plot data.
Okay, and do you have those notes available?
No.
And where are those? At your office?
They would be in my office or in my secretary's office.
Okay, and the chart that you talked about with the green stripe, when was this prepared?
A few weeks ago.
And when was it provided to the state?
At the time that I prepared it, I sent them a fax, not this color, but a fax of this.
Okay, and so the state has had this chart for several weeks?
Probably 2 weeks.
Let me understand, if I can, on the Department of Energy Winter Comfort Zone, is that based on some kind of study that the Department of Energy conducted?
Yes.
And you were not involved in that study?
No.
You've never done any research on your own into how people, their comfort level at various temperatures or humidities or things of that nature?
Well, as a matter of fact, I did, because I was a subcontractor to a consultant to ASHRAE, the refrigerating, ventilating, air conditioning engineers, on a number of major projects that they did to create the amount of energy that would be required for air conditioning in different climate zones in North America.
Okay, in terms of the Department of Energy study, you were not involved in that?
No.
Okay, and the study that there was another study you mentioned with another organization that is not reflected on this chart, correct?
The definition that I read is based on the ASHRAE, ASHRE work. The Department of Energy graph I got from a course program at Louisiana State University.
Explain that to me. What do you mean by a course program?
Well, they have for their people in natural resources a series of courses to make them understand a whole variety of things, one of which is the question of the comfort zone, the relationship of temperature and humidity to human comfort in a calm wind circumstance. And I obtained the graphic, not this one, but the values, a graphic from which the green bar values were taken from the LSU material.
Have you reviewed the actual research that led to this particular graph?
No.
So you don't know how the Department of Energy conducted its research to come up with this particular graph of comfort zones at 75% relative humidity?
I was not a party to it. I understand the dynamics of what was done, but I was not a participant in the study.
But did you review the study itself?
No, I reviewed the results and compared them with my knowledge from the ASHRAE work.
You don't know, for example, how many people were included in the study that the Department of Energy conducted?
No, I don't.
You don't know how they measured whether somebody was comfortable or not at a given temperature?
Not specifically, no.
You don't know the demographics, for example, of the people that were included in that study.
That's true.
And it's true, is it not, that the concept of comfort is a subjective concept?
Yes.
Different people will report comfort at different temperatures, correct?
That's true.
And one factor I think you mentioned is it may depend where they've lived at various times.
That's correct.
Their metabolism or their body heat may affect how comfortable they are at a given temperature.
That's correct.
Their age may affect how comfortable they are at a given temperature.
True.
Will their sex affect? The gender, will that affect?
I've never seen anything pertaining to gender.
Okay, and are there differences between various ethnic groups or racial groups in terms of what is a comfortable temperature?
Sure. An Eskimo is comfortable at a different temperature than a Tahitian.
Okay, and you don't know what the Department of Energy's definition of a normal person was that is the basis for this green stripe on this chart.
I'm sure it was from a demographic study, and it may well have been taken from the ASHRAE work, though their values are slightly different than the ASHRAE values.
Well, sir, you didn't actually review this research.
An Eskimo.
Correct?
That's correct.
An Eskimo. Isn't that like not politically correct anymore? Isn't it Inuit or something like that? But aren't they just Native Americans too? Right? The Inuit people? Because I don't know. Forget I said anything. And also, it's Inuit. Okay. Well, no, because no, they're not just in America, so it wouldn't be Native America because they're like all over the place, right? Inuits are Canada and other places besides America. Yeah, this is true, Nancy. He uses the old terminology. Yeah, Inuit. Yeah, that's what I thought. Also, his dentures don't fit and it's driving me crazy. I don't know if you guys can hear it, but I used to work in geriatrics. It's a pet peeve. His First Nations people. Oh, okay. I'm sorry. I wasn't trying to be offensive. I just forgot that, yeah. So they're like northern states and Canada. Are they in the northern? I'm thinking Alaska. That's what's throwing me off. I don't know. I live in Florida, y'all. The heat has fried my brain. First Nations. Okay. I was trying to be politically correct and I probably did the opposite there. I'm sorry. But his dentures, you guys hear the whistles and the clicks, or is that just my geriatric nurse ears picking that up? It's driving me nuts.
So you don't know how they define a normal person.
That's true.
And you don't know how they subjected people to different temperatures and then gauged how comfortable they were.
I do not know the specifics of the study. I accepted it as a government report, which seemed reasonable in relation to previous work that had been done by the heating and ventilating people.
And as a researcher, you're familiar with the fact that there are people, for example, who would report being comfortable at temperatures outside this zone. This zone doesn't cover all the temperatures everyone reported being comfortable at.
That's true.
So some percentage of people reported being comfortable at lower temperatures, correct?
That's possible.
And you don't know what percentage of those people for this Department of Energy study reported that, do you?
No, I don't.
And do you know whether that study produced results at different relative humidities?
Yes.
Okay, and do you have that with you?
Yes.
Okay, so for example, at a relative humidity of 85%, do you have the figures for the Department of Energy study?
It's beyond their graph is temperature versus humidity, and it encompasses an area, and 85% is beyond the area.
So you don't know what their study would show at an 85% relative humidity.
It shows it further outside of the comfort zone than that 75%, and I used the 75%, even though that was lower than the Durham relative humidity that night.
But I'm asking you, did the Department of Energy study produce a result at 85% relative humidity?
It has, it goes on up past 85% relative humidity, yes.
Okay, and did they come up with a range of temperatures at 85% relative humidity?
No, it's beyond the zone, beyond the area of their graphic.
Okay, and relative humidity can make things feel either colder or warmer depending upon how you react. You know, on a hot day, a humid day feels hotter than a dry day.
That's true.
But then on a really cold day, are you saying a dry day may feel colder or warmer?
A cold day feels warmer. A dry day feels warmer on a cold day.
And is there research that shows where that break point is, where it makes things feel colder as opposed to making things feel hotter?
It's on their graphic, which is not
But you have
in use at this. I have it, yes, but
you have it with you?
Yes.
Okay. Now, I want to understand, does this chart that you prepared reflect the temperatures as they were reported at Raleigh-Durham Airport?
Yes,
And those are reported in centigrade?
that's correct.
It appears from looking at the chart, you have a copy with you, let me just ask you, that the time period from midnight through each of those little hash marks is 1 hour.
Yes,
It appears that the temperature is dropping during that time period. There's kind of a consistent downward slope.
yes.
Let me take a look here. You have in front of you the underlying data.
Yes.
Let me approach and see if I'm reading this correctly.
Well, I say yes. I have to look.
I'll show you the page I have.
Okay,
You can
sure.
tell me if I'm reading this. Is this the chart that you based? In other words,
This
you've
is
got
for the night.
0051, 0151, 0251.
Yes.
Okay. And for 0051, which is not quite 1 o'clock, it's 11 degrees Celsius.
Yes.
And then for 0151, it's 11 degrees Celsius.
Yes.
And for 0251, it's 11 degrees Celsius.
Yes.
So according to this, it hadn't dropped at all between 1 o'clock and 3 o'clock.
All right. If we go to the second part of the
I approach like this what he's referring to.
during those 3 hours that you spoke to me about, so the temperatures were 11.1, 10.6, 10.5.
She couldn't hear you.
During the 3 hours that you asked me about, the temperatures were 11.1, 10.6, and 10.6.
So there was a half a Celsius drop
Yes.
from 1 till 2 and no drop at all from 2 till 3.
Well, 3 is really 0251.
Well, I'm around from 151 to 251. There's no drop at all.
That's correct.
And there's only a half a Celsius degree drop from 051 to 151.
Yes.
But the chart shows a consistent drop, doesn't it, in that time period?
Fairly consistent, yes.
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 Now, let me go back. I think you mentioned that you were involved in a study or some study that was it ash ram or
The American Society of Heating, Refrigerating, and Ventilating Engineers.
Okay.
ASHRE.
And are these folks involved in the heating and air conditioning industry?
Yes.
Okay, and so their job is providing either heating or cooling inside a home.
Yes.
And the purpose of their study was directed towards their work in terms of air conditioning and heating, correct?
Yes.
And when was that study done?
Oh, it was done over a number of years. Most of the work that I was involved with was done in the period 1979 and 1984.
Okay, and who funds that organization?
The various companies that manufacture heating, refrigerating, ventilating equipment.
So the groups that sell us our air conditioning commissioned a study about what a comfortable temperature would be.
Well, their objective was to design equipment which would produce comfortable temperatures.
But the group that commissioned this study is a group that sells us heating and air conditioning equipment, correct?
They were the funding organization to their professional society.
Okay, and so their professional society is not financially independent from the industry that markets and sells air conditioning and heating, correct?
Well, that's true.
And you have a copy of that study with you?
No.
And
Is it published?
has it been published somewhere, by the way?
A series of studies were published
By whom?
by the society.
Okay, do they have a journal in essence that they put out, the society?
Oh, they had a journal and they had a series of technical reports.
And were they published in the journal?
At this moment, I don't know.
Is it at that point was a journal peer reviewed?
Certainly,
Okay, were the technical reports peer reviewed?
I don't know.
And you don't know whether they were published in a technical report or the journal.
Where is these available?
Are they available to somebody who wanted to get them?
I'm sure they are. Yes,
And how would one go about getting them?
I would contact the American Society of Heating, Refrigerating, Ventilating Engineers and ask them for their documentation, which is voluminous.
And it would take some time, I take it, to go through and determine how they had done their research and what the basis for their conclusions were.
I presume to an uninitiated person, it would take a great deal of time, yes.
Such as a lawyer?
Beg your pardon?
Such as a lawyer?
A person uneducated in the techniques of heating, refrigerating, and ventilating.
And you know, in the department, I take it from the Department of Energy study that you haven't read, you don't know what kind of clothing or people were wearing or what activities they were engaged in?
It alluded to normal clothing for the season.
Do you know what that was at the time?
No, I would infer that in the summer it was light clothing and in the winter it was warmer clothing.
Okay, but other than inferring that, you don't actually know what how the study
No,
did that.
I do not have those specifics.
And you know what activities were measured in terms of how people were comfortable?
No.
And you know whether they took into account whether people had recently eaten or consumed alcohol or medications?
Well, I'm sure that they used a large number of people and that the statistics were grouped. So they included a variety of individuals.
Was there any aspect of the study that measured whether the consumption of alcohol affected how people perceived temperature?
Not that I'm aware of.
Was there any aspect that measured whether having recently eaten or not recently eaten affected how people perceived temperature?
I do not have a document that specifically addresses that.
What about the study by the society relating to air conditioning and heating? Did they measure whether alcohol affected how people perceive temperature?
I doubt it very much because they used a very large sample of people under a variety of conditions. And I'm sure that some of the people had imbibed alcohol and some had not.
Well, would you assume that they would have kept track of that so that they could in fact analyze whether it had any impact?
I don't think that was their objective.
So as far as you know, they didn't take that into account.
I'm not cognizant of those level of details.
Your Honor, I'm going to ask to take a look at what he's brought with him, but there's obviously a number of things such as these studies that apparently are the basis, or at least one of them is the basis for this green band, which apparently is not here. We would ask for time to look at that because as I understand it, what we've got is a green band based on a study, and whether that study is in fact reliable and relevant has to be determined before the jury should be given any information about that. What I'm going to argue to the court, and I don't know if there's any other further questions that Mr. Hardin has of the witness, but I just wanted to let the court know that I'm going to ask to look at the material and be provided further material. But I also believe, based on what we've heard, that it would be appropriate to take this green band out and not have the jury subjected to that opinion. It does not add anything that a jury on their own wouldn't understand. There's no basis shown here that it's in fact even reliable study that takes into account factors that would be relevant here. What we'd ask is that that be stricken. If the court's not going to strike, what we'd ask is that we be given time to review all the material, review the studies. If there are, after I've looked at the study, if there's further issues that need to be explored, that we do that, and that we have this witness return. The state apparently has been given numerous, or at least a number of other graphs, other weather stations that were looked at. We were never provided that. They knew that he was relying on studies. We weren't given any advance notice. We never heard, no offense to the witness, of him before today in terms of his background. And we're entitled to all that information rather than having a witness sprung on us.
Mr. Hart, I don't wish to be heard, Judge.
Do you have any further questions?
No, sir, I do not.
Well, Mr. Maher, it is going to be the court's position that what this witness has to offer to the jury is relevant and it is helpful, even though it may be the defendant's position that the jurors won't benefit from this witness because anyone can determine whether they are comfortable. I do think that he could be helpful to the jury. What I'm trying to figure out now is whether or not the defendant has been prejudiced by this in some way. I mean, you've had a voir dire. He told you what he used in his examination. I will consider allowing you some time before he testifies in front of the jury to consider some of these documents. I mean, a lot of that I think goes to the weight the jury gives his testimony and not the admissibility. Once again, as the court is very familiar with your ability to cross-examine, you have cross-examined this witness in a superior manner with very little time. So,
well, also with very little information. Quite frankly,
I'm finding it hard to believe, even if you don't know every little study that he may have used that.
I don't know the main study that's represented by a green stripe. Yes. What I know is that I don't know a lot about it, and apparently the witness has only the most general sense that there must have been a lot of people asked about how comfortable they were. That is going to be a meaningless cross-examination. I can't represent to the court what further information I would get because I haven't seen the study, but the study may show a wide.
I disagree with you. It would be meaningless, as I have indicated. I thought you'd done.
I would hope it would be much more meaningful if I had the underlying study. And I think, the state has had this chart for weeks.
Yes.
This represents the result of a study. If we had been given even a couple days' notice, I suspect I could have gotten the study from the Department of Energy and read it and been prepared. Instead, I was handed this after lunch. Well, and to put the results of the study.
As I've indicated, my tendency is to let this witness testify. So you tell me what you need to prepare for his cross-examination.
I need a day with the studies. I can read them and get ready in a day, but I need the studies.
Mr. Hardin, what is the availability of your witness?
Your Honor, he's here from Asheville. I did not anticipate that he would be in Durham beyond this afternoon. He's the only one that can answer that.
Well,
if you'd like me to inquire,
you need to ask him since he's your witness. No?
Yes, sir. Your Honor, could I have just a moment to do that then?
Yes.
May I approach the witness?
Yes, sir.
Mr. Haggard indicated that he does have some scheduling issues, but if he's required to be back, he can do that any day of the remainder of the week.
In what? I didn't hear the last part.
he could do that any day the remainder of this week.
Okay.
Today's Wednesday. So
Yes.
what we would need time to review is the studies. If he can give us copies of the studies, that would expedite it. If not, we would need the specific citations so we could find them ourselves. Copies, apparently there are other material given to the state, other charts from other weather stations, which I think the witness may have. We would need copies of those. And then his bills and notes that show when he did the work he did. And I assume that those could be provided, but we're going to need a specific identification of the studies or a copy of them so that we can obtain those. If we can obtain those quickly, I'm happy to spend an evening getting ready and doing a cross-examination, but we've only got 2 days left this week. And unless the studies can be provided tonight, I'm not going to be ready to do a cross tomorrow. We would need them tomorrow to do one on Friday.
Well, we can do it any number of ways, including doing his direct today, Mr. Harden, since since the defendant knows what his direct is going to be, if it is similar to what has happened in the
Well, I would object to the jury being left with the direct and then days later hearing the cross. I think they're entitled to hear them both at the same time. If he's coming back anyway, and the whole testimony probably isn't going to take, it's going to take less than an hour, I would object to the jury hearing this. And because we haven't been provided notice.
They're not entitled to hear him at the same time, but it does make sense.
And, it's not as if we failed to get prepared having been given the material. So I think what would be fair is to have the direct and cross happen at the same time, us be given. I'm only asking for a day with the material. I'm assuming that in a day I can at least get up to speed on it, and that we would then conduct a meaningful cross at that time.
Ms. Hart.
Your Honor, he's indicated to me that he does not have a copy at hand of the specific study that.
Well, I think Mr. Maher said if he didn't have it, maybe they could get access.
Well, that's what I was leading to, and I did not.
How is doing direct now going to affect his cross? I mean, it would be optimal to do direct and then cross. But if there's scheduling conflicts and you need more time, it would be easier to do the direct and then you do your cross after you review whatever you have to review. Because this guy came, I don't know, same state, but I don't know how long he had to travel. I think they keep wanting more time for stuff. I think they're just stalling.
Did not ask him that specific question. I'm assuming, Mr. Haggard, that you have that citation so that it can be resourced by.
I have the citation for the source that I got it from, and I have that citation with me because it's on the graph that I alluded to that you have not asked about.
Yes, sir. Then that would indicate to me that we could resume with Mr. Haggard on Friday morning.
We'd also ask, apparently there are other studies by, and this engineering group, we'd ask for the sites of those other studies, which apparently he used in determining that the Department of Energy numbers were reasonable. I assume he would have the sites or copies of those studies that he also testified about during his testimony.
It's your witness. I don't know what he has.
Mr. Haggard, do you have copies of those other studies?
I can probably obtain copies of some of the ASHRAE studies. I do not have a full file of them in my office.
Do you have the citations where they can be located?
I believe I could locate those.
Okay. And you can provide those to us?
Yes, it might take me a day or two.
Yes, sir.
I guess what I would suggest, as soon as we've got that, and I've got the studies, that he can come back the next day. And if that doesn't work for schedule, some other day, so that we can proceed in orderly fashion.
Okay, but look, y'all need to figure out when he's coming back here and when he's testifying. So y'all figure it out now.
I don't know how we're going to figure it out unless we know when we're
You
getting.
got to figure it out because if Mr. Harden is going to bring him back, Mr. Harden has got to know when he's coming back. That's all I'm saying.
Well, I guess what I'm suggesting is Mr. Harden and I will know when I've got the information I need, and then any day after the day I've gotten it is fine by us, and the state can work with their witness on his schedule. It may be that we're not going to be able to do it tomorrow, obviously. It may be Friday. I suspect not, but if it is, I will get out the material tomorrow. If I get it Friday, then they know any day after next Monday would be fine, and I assume they can work with their witness and fitting him in, and we'll get him in and out in one day.
I don't know about that, Mr. Hart.
I'll do whatever the court tells me to do.
Well, I can appreciate the defendant's desire to have every bit of information that this witness went over. I don't think that's what the law requires.
Well,
So,
yes, sir. And I agree. And quite frankly, I mean, I've received some information from reports from various experts. Now, if we take the approach that they're taking here today, I'm going to be entitled to every single study or manuscript or treatise that any of these experts that they intend to call would have used to formulate any aspect of their opinion. If we want to take this to its logical extreme, because that's where we are.
I think the defendant has a right to know what the opinions were that this witness is going to give, and he has that. And I think he should have a reasonable basis to prepare. But, you know, weeks to bring this witness back to testify, that's something that you have to deal with, Mr. Hart. I'm willing to give him a reasonable amount of time to review that information. I don't know what they're going to make out of the information. As I indicated, Mr. Maher did an excellent job of cross-examining this witness with no preparation. So I don't know that he needs quite the amount of time that he wants to feel secure with to prepare for this cross-examination. But let's figure out a reasonable time so we can deal with this issue.
Well, it will be the state's position that Mr. Haggard provide them with the citations that he has available and that he come back on Friday morning. That'd be the state's position.
Assuming that the citations are such that I can get my hands on copies of the studies so I can read them tomorrow, I have no problem with them coming back on Friday. But I need to actually get them. Citations may get me the studies. They need to get me.
And all I was meaning to indicate to you is I want a concrete day. I mean, we can do this on Friday, fine. If we can't, let's be heard on Friday as to why you can't do it. I just don't want to leave it up in the air, because what happens when you do that is that Mr. Harden, you know, he is trying a case here, a murder case. He's got other things on his mind. He got other witnesses to deal with, and it becomes very difficult to get people back on schedule. And I just don't want to do that.
And I understand I'm only asking for 24 hours.
I understand. All right. So we're going to resume with this witness on Friday morning, 9:30 or whatever. Okay. Do you want him to come down then?
Can we just take a quick break and let him gather his thoughts and provide the citations, and then I'm trying to figure out where we are next, Judge.
You mean with the next witness?
Yes, sir.
Okay, well, it's 10-2 now. How long a break you want?
If I can have just a couple of minutes with him before, I mean, he's got to go back to Asheville tonight or this afternoon, and I prefer that they have that information before he has to do it.
Right. We also have a jury in the back. I mean, I can send the jury on a break, and we can all come back and see where we are. 2:15?
Yes, sir.
All right. Won't you come down? Won't you come down off the stand, and we'll just send the jury on a break.
Well, that didn't last long.
For the record, please state your full name.
My name is Lieutenant Connie Bullock.
How are you employed, sir?
Employed as Assistant Commander for the Durham Police Department Criminal Investigations Division.
How long have you been employed with the Durham Police Department?
Approximately 21 years.
Will you please describe to the jury what your educational background and training has been as it relates to your profession as a policeman with the City of Durham?
My training has been first basic school, which was 6 months. Actually, I had a 4-year degree before that.
And where is that 4-year degree?
UNC in Chapel Hill.
And is it in a particular field of study?
It's in business administration.
All right. Go ahead and go from there and describe what your education and training has been as it relates to your profession.
I've also had training in homicide investigation, had training, and I don't recall the number of hours for all of these, instructor certification, defensive tactics, physical fitness instructor. And it's been multiple. I just can't recall all of them at this point.
Any of that training relate to crime scene management?
Yes, sir, it did.
Go ahead.
Some in basic and some follow-up schools. I would say 3-day schools, 2-day schools from time to time.
If you will, from the point that you graduated from University of North Carolina, please describe the various roles that you have played in the department. Describe what the job was and generally what the time frame was when you held it.
Repeat that question for me, please.
From the time you graduated from University of North Carolina coming forward,
yes, sir.
Describe what your jobs have been within the department.
My first job responsibility dealt with uniform patrol. Also, I was a school liaison officer in the Lowe's Grove Middle School. In addition, I've served as training sergeant for the training division for 5 years. I was an assistant district commander in East Durham for 2 years. And I've been in criminal investigation for the remainder of that time, 2.5 years.
Now, during the period of December the 9th of 2001, how were you assigned with the department exactly?
I was assigned to the criminal investigations division.
In what capacity?
As the assistant division commander.
And what rank would you have to hold in order to perform those responsibilities?
A police lieutenant.
All right. If you would, please take a moment and describe what the command structure is at the police department during that time period as it relates to the interaction with CID and uniform patrol and any of the other divisions at the police department.
The criminal investigation division is responsible for investigating all felonies. The first responders being uniform patrol. In the event that uniform patrol arrives on a scene and determine that a felony has been committed and it needs further investigation, they will summon CID, and CID will respond to the scene.
Okay, and at some point, there are going to be various supervisors that are involved in that process and take control of that scene. Is that right?
Yes, sir.
Exactly how would you, as a lieutenant, be involved in that process at a particular crime scene?
It would depend on who has responded prior to my arrival. The first officer, obviously, who is on the scene is in charge until a higher ranking officer could respond and actually take charge, or the initial officer could retain control of that scene. Once the uniform patrol higher ranking officer, which is usually a sergeant, responds, that's usually the incident command, unless it's going to involve multiple agencies and those type situations. That sergeant or that incident commander will determine who or what other resources are needed or what other personnel may be needed. They will in turn, if the criminal investigation division is needed, then they will summon or call the CID.
All right. And at that point, then you would get involved as CID lieutenant. Is that right?
Yes, sir. If it's a major, when I say a major incident, such as a violent crime or homicide, the commanders will be called and we're required to respond to those scenes.
Okay. Now, again, focusing back on December the 9th of 2001, did you have the occasion to be called to a scene at 1810 Cedar Street here in Durham?
Yes, sir, I did.
If you would, please describe for the jury how that happened and what you did.
I was paged by Sergeant Borden at 4:44 in the morning. He indicated that he had a death scene on Cedar Street, 1810. And it was automatic for me to respond to that particular one.
And why would that be?
Because it was suspicious circumstances at that time when he called me.
Okay. Now, you say you got the page at 4:44?
4:40, yes.
When you got that information, what did you then do?
Well, I proceeded once I got ready, I proceeded to the scene.
Okay. Did you communicate with anybody with respect to the information that you had received?
I called Major James as a point of information.
And why would you do that?
That's normal protocol to notify the upper command of major incidents such as this.
And is that typical? Would you, as a lieutenant, notify the upper echelon of the command that something of a major nature had happened?
Yes, sir. It will be my responsibility to notify my supervisor, who in turn would notify his on up the chain until the chief was actually notified. And in certain circumstances, perhaps even the city manager and the mayor.
Okay. Now go ahead and describe, if you would, what you did after you got your page and prepared and then left your residence.
I believe I called Major James before I left my residence. And I proceeded to the scene, got there at the Cedar Street address approximately 5:35 in the morning. At that time, I was asked, and I believe it was Sergeant Pascal and Sergeant Borden, to basically brief me as to what we had at that particular point in time, what the status was, and they did that.
Okay. At that point, what did you do once you received that briefing?
Pretty much just held everything as it was. In other words, we took no further action. I also had been informed that a search warrant was in the process of being obtained. And under those circumstances, we just pretty much wait until the search warrant is in hand at the scene to be executed.
At that point, had you gone into the house?
No, sir.
Now, you say you were waiting at the scene for the search warrant. Where did you do that?
At the mobile command station.
And where was that located, if you recall?
It was on Kent Street.
Who are the other persons there at the mobile command station during the time period that you were there, if you remember?
I believe Sergeant Borden was there, Sergeant Fran Borden, and Sergeant Pascal. Major Pettiford was there. And if you don't mind, I need to refer to my notes. Sergeant Wilkins and some other District 3 and District 4 officers.
All right. And if I understand correctly, then from the time period you got there after you were briefed, you were kind of in a holding pattern waiting for the search warrant.
Yes, sir.
Once the search warrant got there, what did you do?
I pretty much, there again, I stood by because our normal protocol is for the forensic technicians to actually do what they do, which is pretty much photograph and video things as they are. Okay. Before we begin to collect any evidence.
Okay. And with respect to your responsibilities, if you would please describe exactly what they are to the jury during that process.
I'm sorry, I didn't understand the last part of your question.
During the point after the search warrant's executed, what are your responsibilities after that is initiated?
My responsibilities in this particular case was as a support for the team.
Okay. Now, if you would please go ahead and describe to the jury what you saw and what you did once the search warrant arrived. And who brought that, by the way?
Investigator Holland.
Okay. Did you speak with him about the search warrant prior to its execution?
I don't recall if I did or not.
Okay. Again, go ahead and describe what you did and what you saw as it related to the execution of the search warrant and the surrounding area.
Once the search warrant was about to be executed, we actually met with the forensic team, the investigators, talked about what was contained within the search warrant, the kinds of information and evidence that may be vital to the investigation, what we may be looking for, and that particular kind of information. We knew once forensic had their briefing that they would actually, enter the house, enter the residence, take photographs, do videos, and they would process the scene from that point on.
Okay. And you were part of that discussion?
Yes, sir.
And is it typical for a lieutenant to be part of those discussions?
Yes, sir.
Now, Sergeant Pascal had indicated that once he got there, and in essence, command was passed to him as sergeant of the homicide squad, that he basically retained command of that scene. Is that your
Yes, sir, that is correct.
And why would that be? Why would a sergeant maintain command even though there are other higher ranking officers in the area and providing some assistance?
The sergeants actually will be the incident commander because they're going to be more intimately involved in the investigation. They're going to be closer to the investigation, and they can direct their personnel as to where they need them. The people who is on this unit, all the other investigators, the uniform patrol persons who are actually on the scene, they will be in charge of the personnel who are on the scene.
Okay. Now, once the briefing occurred between you and the others that you just described a moment ago prior to the execution of the search warrant, what did you do once that briefing was completed?
I pretty much just stood by waiting to see if there was any major decisions that needed to be made or any support personnel that were needed to be summoned to the scene or to be I guess summoned or called or sought advice from.
Now, did you remain at the scene there for some period of time?
Yes, sir, I did.
If you would, please go ahead and describe for the jury what you did while you were there and exactly what your role would have continued to be.
As I mentioned, my role primarily was there as a support person, which means once the incident commander advises me of a person or I guess materials or whatever they might need, my role will be to secure that for them.
Okay. Now, at that point, was a decision made that you needed to take whatever time was necessary to secure the house and to collect evidence and to process that scene and to do that for whatever period was required?
Yes, sir.
And based on your memory, how long were you there during that process?
Approximately 2 days.
Okay.
With intermission or intervals, I think the first day we were there till about 11:30.
Okay. And you stayed there the entire time?
Yes, sir, I did.
Were you involved in the decision to secure the location at that 11:30
Yes, sir.
time?
That was my decision.
Okay. And why did you choose to take an intermission at that point, for lack of a better phrase?
One, I knew that the personnel could actually only do but so much, and people had been there ever since very early that morning.
Okay.
And they need some rest.
All right. And how did you go about securing that area?
I think I contacted whoever was in charge of the uniform patrol, asked them to have a specific number of officers to actually come to secure the scene.
To your knowledge, was that done?
Yes, sir, it was.
And for what period of time did you direct that the scene be secured before additional search of the area could be conducted?
Until 6 o'clock the next morning.
Okay. Now, were you involved in any other aspect of securing that area or the search the following day?
Yes, sir, I was.
If you would, please describe for the jury how you would have been involved in that.
My role, actually, I didn't get to the scene until sometime later that morning. We briefed at headquarters. We acquired or asked for additional personnel to provide search teams for the premises at 1810 Cedar.
Now, you say you asked for additional personnel for search teams. Who actually set up the search teams?
I did.
If you would, please describe generally to the jury how you went about that process.
I asked for officers and investigators from other divisions. We assembled in the conference room at the CID. After I found out and knew exactly how many persons I had, I divided it up into, I believe, 5 teams, assigned specific areas for each team to actually be responsible for as far as the search.
And then did you provide direction on how the search was going to be conducted?
Yes, sir, I did.
Once you provided that direction, what happened?
The teams responded to, because the assignments were actually made before we left headquarters. They were directed to respond to a particular location at the scene. I don't recall exactly how the quads were set up, but they were set up in quads so that each team would have a specific area to search.
Okay. After you directed that, were you directly involved in the search of the premises, either inside or out?
I was not directly involved.
Okay. Once you set up these teams and the search began, what did you do? What did you observe?
Well, I observed, obviously, the teams executing their searches. There were some areas once one team had completed the area that they were assigned, they actually were reassigned to a second area. Once a team completed their search of and this was all exterior, once they completed their search, they reported to me at the mobile station, and I redirected their assignment. Once the entire outside perimeter was done, I released some officers and I reassigned some to the interior of the house.
Okay. And once all the search was conducted on the outside, and then you reassigned officers to conduct a search of the interior of the residence, what did you do?
I pretty much stood by while they conducted the search.
Okay, so you didn't directly involve yourself in the search?
No, sir.
And why would that be?
If I'm involved in the search, I can't really assess the other needs that are necessary for a crime scene.
Okay. Did you stay there during the entire time that the search was conducted that next day?
My recollection, yes, sir.
Do you recall approximately what time the search was concluded?
Marty.
I do not.
Well, was it in the afternoon or evening, or?
It was in the evening.
A period is all we get for a hello this morning?
And I don't have that time recorded, I'm sorry.
Okay. Were you involved in making decisions about whether to involve other agencies?
I was.
Would you please describe for the jury what your experience was there and what you did?
And I assume when you say other agencies, not so much law enforcement agencies, but other, such as the SBI.
Sure. Any other agency outside of which you would have had control?
Yes, sir. I was pretty much made aware of other personnel at other agencies, such as the SBI, that could enhance the investigation or could aid us in the investigation at this location. The ultimate decision was mine, obviously, but I was pretty much informed, and I said, go ahead.
Okay. Did you directly speak with anyone from another agency to request assistance for the search of this area or in any aspect of the processing of the scene?
Was I directly involved in that decision?
No. Did you ask anybody else?
I talked to, I want to say, Melinda Collins.
And who is she?
She's with the SBI.
And do you know what her job was at that time?
I'm not real sure exactly what job description, but she was providing me information regarding computers.
Okay. Now, with respect to the conclusion of the search on the 10th, best of your recollection, as you described it, was in that evening.
Yes, sir.
Were you involved in any other search after the evening of the 10th?
Yes, sir.
If you would, please describe for the jury how that happened and what decisions you made and what directions you gave.
Subsequent to the 10th, and I wanted... I want to say it was December the 12th. Actually, December the 11th, I believe it was. I was involved in a meeting to discuss, I guess, merits of the case and exchange information. And it was determined that based on what we've already had obtained as far as the case, that we needed more information.
All
and we
right.
needed to execute another search warrant.
Now, specifically with respect to the residence and the 12th of December, were you involved in a search warrant that was executed on that date?
Yes, sir, I was.
If you would, please describe for the jury what your involvement was in that process.
Pretty much my involvement on that particular date was to respond to the scene, and I stood by the main entrance of the residence while the actual search was going on.
Were you involved in the decision-making process to conduct an additional search on that date, the 12th?
Yes, sir, I was.
If you would, describe for the jury how that happened.
It was pretty much a discussion, I believe, with your office and investigators from the police department who were actually involved in the case to determine, and we determined that there was some information that was lacking as far as tying all the pieces together that we needed to look further in the house to see if they were there.
In particular, what types of things were you looking for?
I believe more computer or a computer and computer records, and I'm not I only received some information regarding the letter. I'm not really intimately involved in exactly what a letter was about.
Okay. Now, I think you'd indicated that Melinda Collins was involved in some discussions with you about the computers. Was that in any way part of the decision-making to execute an additional search warrant?
Yes, sir, it was. We knew that Ms. Peterson computer at work had an enormous amount of oil. I really didn't know, but felt that it would be vital to the investigation.
Okay. And were you aware of other computers in the residence?
Yes. One that was I believe it was classified as a study.
All right. And was it one of the objects of the search warrant to gather those computers so that you could conduct an analysis of those?
Yes, sir, that's correct.
Now, when was that search warrant actually obtained? Do you know?
When was it obtained?
Yes.
Sometime in the afternoon of the 12th. I'm not sure exactly what time.
Okay. What time was it executed?
Approximately 1800 hours or 6 p.m.
And why was it executed at that time?
We were, I guess, trying to be a little less intrusive as far as the family was concerned. We figured there may be family members there prior to the visitation. And we wanted, I guess, pretty much be less intrusive for them and consideration for them. So we wanted to execute it during the time of the visitation.
So you're aware that there was a visitation for Ms. Peterson during that time period?
Yes, sir.
And you specifically took that into account when you executed the search warrant?
Yes, sir.
And exactly why would you have done it during that time?
As I mentioned, to be less intrusive and a little bit more sensitive to the family. And normally when we execute a search warrant, everybody who's in the building or in the house, residents, we have to secure them. When I say secure them, they cannot be on the premises or should not be on the premises, and will be less intrusive to the people who were at home at the time.
All right. Based upon your memory, were there items seized out of the residence on December the 12th?
Yes, sir.
Generally, based on your memory.
I do remember a computer. I don't remember other articles that may have been seized.
Okay. After that search warrant was executed, did you have any additional direct involvement in this case as it relates to a search of the premises or anything of that nature?
After the execution of that particular search warrant?
Yes.
I don't recall that I did.
Okay. Did you have any other direct involvement in formulating how the investigation would go as the lieutenant in charge of CID?
I had some part in that, yes, sir.
Okay. Would you generally describe for the jury what that would have been?
Well, part of my role would be to, one, to ensure that there were adequate investigators to help or assist in pulling together the information to, I guess, tie this case together. When I say tied together, there were a lot of loose ends from pieces of information that had been obtained from various locations. The other role that I had, I actually did go to the medical examiner's office and discuss.
Okay, guys, I just found something. I don't know if you guys would be interested or not. Because I Googled who killed Elizabeth Ratliff. Just out of curiosity, because I was wondering why he wasn't ever charged. And it happened in Germany, but I think they lived on base. I'm not positive about that. So therefore, the military should have been the one to investigate it if it was a crime. But I think they're still going by the original autopsy findings. I don't know. Anyway, David S. Rudolph has a website, davidsrudolph.com. And he has written like a little mini booklet on there about the staircase. I think the documentary. It says, this is when you click on the little menu thing, it says the staircase inside view, then my journey, then why I do this, then American Injustice, then Contact, and then RTG. I don't know what RTG is. Okay, Carla. So I guess this is the trial or the documentary from David Rudolph's point of view. I came across it on accident. I don't want to read it. But so some of these articles look pretty interesting. Raleigh News and Observer, or the News and Observer. Peterson trial, slain woman's 1985 death after night out with Mike Peterson. No accident, pathologist finds. This one, Attorney at Law magazine. Michael Peterson. What happened in that trial could not happen today. Which I agree with that. When, Judy? When it happened? Was it I can't talk right now. Investigated. Was it investigated as a homicide at the time or as an accident? I'm gonna have to read these articles. Hell. Peterson is bisexual. During the trial, Assistant District Attorney Frida, her name's Frida, I've been calling her Greta. Frida Black showed the jury photos of a gay man Peterson met online but never in person. She called the photos filth, pure filth. And this is what Michael Peterson had to say. What happened in that trial cannot happen today. It's just simply not possible for Hardin and Frida racing around showing these pictures. He's guilty because he's bisexual. Try that one today in court. It's just not going to happen. You can't shame anybody out of anything. And the one that I blame is Judge Orlando Hudson, who is a good liberal Democrat. I'm a good liberal Democrat, but I spent 8 years in prison because that a-hole did not make correct judicial decisions. In 2006, a new North Carolina Court of Appeals rejected Peterson's claims that he did not get a fair trial because of repeated judicial mistakes in admitting evidence. Did Kathleen know you were bisexual? Kathleen and I never talked about my bisexuality, but there was a silent understanding. What? Okay, so it was investigated when it happened, and it was determined to be an accident at the time. And it was only ruled a homicide after the exhumation. Yeah, but that's what I mean. If it was ruled a homicide, there's no statute of limitations on murder. So if it was ruled a homicide, they were just like, okay, well, it's a homicide. Let's put her back in the ground and forget about it. See, it bugs me, just like Wendy Adelson bugs me. You can't just let it go. If you know somebody killed somebody, you can't just let it go. I don't know. Maybe my worldview is too black and white. I don't know.
As with them, I guess their findings as far as preliminary information as far as the autopsy was concerned.
And with whom did you speak at the medical examiner's office, if you recall?
I remember Dr. Snell and Dr. Radish being present. And I believe there was a Dr. Natalie Smith and a Kevin Garrity and a Dr. Thomas Clark that were present.
Okay, and how long was that discussion?
Roughly an hour, I guess.
Based upon that discussion, what did you do?
Yeah, me too. I don't know how that would work.
We determined, based on that discussion, that perhaps a new search warrant should be done for Miss Peterson's body.
All right. With respect to information that they would have provided to you, well, strike that. At the conclusion of the execution of the search warrant on the 12th, I think you'd indicated that you didn't go back and search at that residence, right? You weren't involved in any process there.
Yes, sir.
And after that point, you were trying to provide resources for the officers to conduct their investigation.
Yes, sir.
Is that right?
Yes, sir.
Other than that, did you have any additional direct involvement in this investigation?
I can't recall that I did, not directly.
Your Honor, we don't have any other questions of the witness at this particular time.
Cross-exam.
Yes, sir, thank you. Lieutenant Bulk, my name is Dave Rudolph. We've not met before, I don't think. Did you say during your direct examination that you were referring to some notes?
Yes, sir.
Are those handwritten notes or typed notes?
They're typewritten.
All right, let me just show you what I've got. Now approach, Your Honor, just make sure that I've got the same thing you've got. I've got this supplement.
They're all the same. It's yours is broken up in pages. And
yes, sir. Is there a date on here? Oh, there it is. Okay. And then I've got this one right here.
That's December 10th.
Okay. So yours is just one continuous document. I just have it broken up on separate.
Yes, sir.
Okay. Now, I noticed that this thing was prepared on March the 12th. Is that right? Of 2002?
Yes, sir.
And you seem to have some pretty detailed times and information in here, right?
Yes, sir.
And was this based on handwritten notes then?
Yes, sir.
And where are those notes?
They're in the steno pad that I usually keep.
And where is the steno pad?
I have it with me today.
Okay. And have you given a copy of that to the district attorney prior to today?
No, sir, I don't believe so.
Ms. Marks. Let me show you what I've marked as Defendant's Exhibit 103. I'll ask you to take a look at that, if I could.
Okay.
You recognize that as an order signed by Judge Height on February 4th, 2002?
Yes, sir.
And it orders all detectives and other law enforcement personnel to preserve all rough notes and to provide all such material to the district attorney, does it not?
It does.
Were you aware of this order?
I was aware of the order to preserve the notes and all of that, and it didn't get copied or provided to the district attorney.
Were you just not aware that that was part of the order?
Preservation was, but presentation not. Yes, sir.
In other words, you were aware of part of the order, but not the whole.
Yes, sir.
Is that right?
Yes, sir.
Okay, but you do have those notes with you?
Yes, sir.
Your Honor, may I ask that they be produced, and Mr. Maher perhaps can take a look through them while I'm conducting my examination.
Approach the bench, please.
By the way, was this written type supplement you have up there, was that the only supplement you ever prepared?
Was it the only one I have ever prepared?
On this case?
Yes, sir.
Let me show you. What I've now marked as 104. This should right now marked as exhibit 104. I'm going to ask you if you recognize exhibit 104 as some handwritten notes from Art Holland.
I don't recognize writing.
You don't recognize Investigator Holland's writing?
Yes, sir.
Did you ever give him a supplemental report on 12/31/01?
I could have, but I don't recall it.
Okay. Now, when you were paged at 5:35 in the morning, one of the first things that you were told was that the deceased was the spouse of Michael Peterson, correct?
It was in that conversation. It was not the first thing that I was told. And it was at 4:44 in the morning.
4:44. I'm sorry, you arrived at 5:35.
Yes, sir.
So in the conversation before you even got there, you were told that the deceased was the wife of Michael Peterson.
Yes, sir.
And that wasn't a lengthy conversation, was it?
No, sir.
A minute? 2 minutes?
Probably.
All right. In any event, so in that 2-minute conversation, one of the facts that was mentioned was Michael Peterson's involvement, right?
The wife of, yes, sir.
And when you got to the scene at 5:35, I think you said Pascal was there.
Yes, sir.
And Major Pettiford.
Yes, sir.
Sergeant Borden.
Yes, sir.
Sergeant Wilkins.
Yes, sir.
A number of District 3 officers.
Yes, sir.
A number of District 4 officers.
That's correct.
And what you were told when you got there at 5:35 was that Miss Peterson had fallen down a flight of stairs and died as a result of the fall, were you not?
Yes, sir.
And that was pretty much the summary that you got when you got there, right?
Pretty much so.
And indeed, one of the things you wanted to do at some point was to examine Michael Peterson for evidence, right?
Yes, sir.
And you called up the police attorneys, didn't you?
Yes, sir.
And they told you didn't have any probable cause.
Objection.
Do you want to be heard? Yes, sir. All right, Mr. Deputy takes the jury to the deliberation room. Yes, sir, Mr. Hart.
I think the area that he's getting into relates to a portion of Lieutenant Bullock's report, and it says, I called attorneys Herring and Smith to ask if we had probable cause to obtain a non-testimonial order to examine Mr. Peterson for evidence. Now, whatever they told him is hearsay. So, they can't, I don't think that Ms. Rudolph can elicit from this witness what the content of that conversation is, even though he's done it with this last question. Second of all, it's not relevant as it relates to a non-testimonial order. It either was obtained or it wasn't.
And this officer's knowledge of it, based upon a conversation with attorneys Herring and Smith, would not be relevant to whether it was obtained or not. He was obviously working and operating under the theory that they were giving him legal advice as police advisors. So I would indicate to you that, number one, it's hearsay, and number two, that it's not relevant for any inquiry other than to attempt to establish with this jury that the police didn't have probable cause to do all the other things that they did, when all the question should be directly relating to is whether they had probable cause to execute a non-testimonial order on it.
All right. I think I specifically said whether he called asking for guidance about searching Mr. Peterson's person. I think that's what I asked him. I didn't use the words non-testimonial identification order, but I used the description of what they were going to be or what he wanted to look for. What happened at that point was they didn't get one because of what he was told. And so I think in explaining his lack of action at that point, again, Mr. Hardin's gone into all the things he did do. I think I ought to be permitted to go into the things that they didn't do and why they didn't do them.
Yeah, I just want to make sure, and I think you have stated as the court recalls your question, just that sometimes the jury doesn't know these distinctions between probable cause for what, and
I'll try to go back and make it clearer, but I mean, that's what I was asking about.
It's overruled. Let's bring jury back. All right, members of the jury, there are matters we'll have to take care of outside of your presence. It's the end of your day anyway, so I'm going to go ahead and send you home. Remember the instructions I've given you throughout the course of this trial. Keep an open mind. Don't talk about the case. Don't read about it. Don't watch TV about it. Don't do any independent research. We'll see you tomorrow morning at 9:30.
Lieutenant Bullock, yesterday I think you said on direct examination that the reason you went to execute this search warrant for Mr. Peterson's home on December 12th was precisely because you knew that they had a wake scheduled. Is that right?
No, sir, I did not.
Oh, I'm sorry. I thought you said that the reason you scheduled it for between 5 and 8 was to try to be less intrusive.
Oh, okay. We did schedule it for that particular time to be less intrusive, but we did not go for the purpose of going because they were at a wake. The timing was scheduled for that purpose.
Okay, and it would be less intrusive. Why?
On the family and the family members.
How so?
Because it's my anticipation, it was my anticipation that family members from out of town or family members would be at the residence at that time.
Would be? I'm sorry.
Would be at the residence prior to a wake or visitation.
All right, and so your expectation was when you went there, no one would be there?
Yes, sir.
So you were going there in the hopes of finding the house empty?
Or not having to displace people.
Well, when you say not having to displace people, you're talking about finding no one there, right?
When we execute a search warrant, any resident of the house that will be present will be secured by the police, meaning either they would have to be held up in a particular location or escorted out of the residence.
Well, the truth is what happens is you can ask them to step outside while you conduct the search, right?
Yes, sir.
That's what usually happens, right? Right?
Yes, sir.
You don't normally detain people in a house while you're conducting a search if they're simply a visitor, right?
That's not necessarily true. Sometimes we do.
I said normally.
Yes,
normally
sir.
You don't.
No, sir.
Now, were you expecting Michael Peterson to be there when you got there?
I had no earthly idea who would be there.
All right. And how were you going to get into this house if no one was there?
If no one was there, Constitution and the search warrant would allow for forced entry.
Forced entry. And did you think it would be less intrusive and upsetting to Mr. Peterson to come home from a wake and find out that the police had rummaged through his house?
Objection to the phrase.
Overruled.
Did you think that would be less intrusive?
I didn't know whether it would be or not.
Well, you said you were concerned about not being intrusive, right?
I understand, but I did not say that it would. I don't know. I don't know if it will be more or less upsetting to Mr. Peterson. I don't know.
Well, I thought that was part of your thought process about going there on that day, wasn't it?
It was to be less intrusive to the family.
Oh, not to Mr. Peterson, to other people.
To the family.
Well, what about Mr. Peterson?
He's included in the family.
Right. Now, do you have any idea how many family members were staying there?
No, sir, I did not.
Did you know if any family members were staying there?
No, sir, I did not.
So who are you trying to be less intrusive towards?
For anybody or any family member that may be present or may have come to the residence prior to going to the visitation.
Did you know that most of the relatives had been going over to Mo Berry's house and that Mr. Peterson had been over there a lot?
No, sir, I did not.
Now, if I understand you correctly, if Mr. Peterson had already left for the wake, what you all would have done would have been to break into his house, right?
Objection.
Overruled.
Right?
Make a forced entry.
Well, that's a break-in, isn't it?
A forced entry.
And he would have come back from the wake and found out that, at least initially, he would have noticed that somebody had been in the house, right?
Perhaps.
He might not have known who it was at first, right?
First impression, perhaps.
2 or 3 days after his wife dies in the house, what he finds is that someone, at least initially, someone, he doesn't know who, has been in the house and maybe rummaged through it, right?
That's correct.
And your view was that that was less intrusive than simply coming to his house, say at 1 o'clock that afternoon, and knocking on the door. The main thing you wanted to get were the computers at that point, wasn't it?
And some other information, yes, sir.
Mostly the computers.
Yes, sir.
Knocking on his door and showing him the warrant and saying, "Excuse me, but we have a warrant for some computers. Would you mind if we came in and took the computers?" That was available. That option was available to you, wasn't it?
I don't remember the timing, exactly what time the actual search warrant was obtained. So I can't tell you if it was available to me or to us earlier in that day or not.
Well, it could have been gotten earlier in the day. There's magistrates available 24 hours a day for search warrants, aren't there?
I'm just not aware of the time.
Well, assuming that there was a magistrate available to issue a warrant, say at 1 p.m. as opposed to 5 p.m., you certainly could have gotten the warrant, gone to his house, knocked on the door, asked him if you could come in to take the computers, asked him if he wouldn't mind stepping outside by the pool area while you conducted whatever other search you conducted. That was all an option available to you, right?
It was an option.
And what you all chose to do instead was to come to his house at the very time that the wake for his wife was scheduled, correct?
Yes, sir.
And as a result of that, because he chose to, he was put in the position basically of choosing between going to the wake right then and there or sticking around and seeing what you guys, or at least trying to figure out what you guys were doing in his house, right?
I can't answer that. I'm not sure what he was thinking.
He stayed there while you were conducting your search, didn't he?
Yes, sir, he did.
He didn't have to, though.
And he didn't get to the funeral home until after the visitation was over, did he?
I don't believe it did.
Now, you mentioned on direct, I think, another search that you were part of, right?
I'm sorry, but they have Prosecco at Epcot in the Italy little kiosk where they sell food and drinks and stuff. I'm very tempted to try it, but it's expensive. It's like $12 for a little bitty glass. He didn't have to be there. If my spouse died and I was suspected of the red rum and they were to come and search the house and it was stay and watch them search or go to the wake, the viewing, whatever. If I was innocent and didn't do it, I'd be like, sure, search the house. I'm going to my husband's wake. Is it really, is it a red wine? Because I don't like white. I gotta try it. Every time I see that sign where it says Prosecco, I think of you. I'm like, I really need to try it because Judy talks about it all the time. Caitlin was Kathleen's only biological child and Michael's stepdaughter. She sided with the prosecution. At the very beginning, she didn't. And then she changed her mind. And the other two girls said that they felt like they lost a sister and a mom. And then, of course, a dad when he ended up going to prison. It's whitish. Oh, well, it won't hurt to try it at least once. I'm not a big drinker, so I don't know. Is alcohol really that expensive? It's hard to gauge prices at Disney because the prices are so elevated. But like the blue milk drink I was telling you guys about with the rum, it's $20. But the blue milk by itself without the rum is $9. So I don't know how to gauge if that's like the real price of alcohol or not. Like I don't go to bars and stuff and order drinks. So I don't know. Close my eyes and pretend it's red. Okay. But sure, I might try it. She was the only one of the couple's 5 children to say that she believed Peterson had murdered her mom. Until later, when Todd did. And I don't know about the other. I don't know if the other 3 changed their minds, but I know Todd did.
One on the 11th of December.
I don't recall the date.
Well, what happened was that Miss Peterson's body was brought to the Houghton Funeral Home, right?
Yes, sir.
And it had been embalmed, correct?
I don't believe it had been at that point.
You're saying that on the 11th day of December, it had not yet been embalmed?
I don't know.
All right. In any event, you all wanted to do a vaginal swab of her body.
Objection to the relevance.
Yeah.
Overruled.
What?
Didn't you?
We were to do a sexual assault kit, yes, sir.
And the people at the funeral home said, we're not going to let you do that unless you go get a warrant. Isn't that what happened?
Yes, sir.
And they called Mr. Peterson to tell him. And you all were now wanting to take a rape kit from his wife.
How does that work?
Didn't they?
I was told that he was calling.
Of a bottle. Never pay that for
And then you all actually went and got a
12 bucks per glass.
warrant, and that was done to his wife's body, wasn't it?
It's my understanding it was.
And that was the day before you all went to his house, right before the visitation, wasn't it?
If it was on the 11th, yes, sir, it was.
Well, let me mark this just so we're clear. By the way, the police had access to Kathleen Peterson's body at the medical examiner's office, didn't they?
I can't answer that because I'm not sure what the police are allowed access to when the medical examiner is performing an autopsy.
Well, you know, a police officer goes, or at least in this case, I think it was even Investigator Holland went, or maybe another officer went and was present during the autopsy.
Oh, wow.
You knew that, didn't you?
I knew that an officer was going, yes, sir.
A loud pen. You guys know how I hate loud pens. Right? Quieter.
And the medical examiner didn't do any kind of rape kit, right?
It's not, I don't believe so.
Let's mark, please. Approach.
Yes.
Let me show you what's been marked. 12/11. I'm sorry. Defendant's Exhibit 105, which is a search warrant dated December 11th, 2001. Time issued 7:45 p.m. on the application of Art Holland for a search of Kathleen Peterson's body. You see that?
Yes, sir.
And does that refresh your recollection as to the date that all happened?
Yes, sir, it does.
And it was on December 11th?
Yes, sir.
Now, I got a copy of those notes, which I appreciated. Thank you very much. And I had a chance to go through them last night, and I noticed that they seem to end no entries after December 10th of 2001. Is that correct?
Yes, sir.
But now in your supplements that were done in March, you talk about events that occurred on the 11th and on the 12th as well, right?
Yes, sir.
And do you still have the notes that reflect the entries that you put in about those dates?
No, sir, I don't.
Do you know where they are?
No, sir. Could not locate them.
Well, again, getting back to my point from yesterday, you did know about that court order that you preserve all the notes.
Yes, sir.
But the notes from the 11th and 12th are simply missing?
Yes, sir.
Now, in your notes, I did see that you had a conversation. Well, let me ask you this. On December 11th, December 10th of 2001, your position was as what exactly?
Assistant Commander, Criminal Investigations Division.
Okay. And were you then over the Homicide Division at that point?
Yes, sir.
And in terms of your day-to-day functioning, how much interaction would you generally have on a particular homicide, given your overall role?
If I were to state it in a percentage, maybe 5-10% of my day.
Okay. And would it be fair to say that, generally speaking, once a lead investigator was assigned from homicide, that person would be the person to be doing most of the nitty-gritty work on the case?
Yes, sir, that's correct.
You would be more in the role of contacting him, the lead investigator, or her, making sure that they had what they needed. I think you said yesterday, right?
That primary function would be with the supervisor, the unit supervisor.
Okay. That would be, at that point, Sergeant Pascal?
Yes, sir.
All right. So would you then be more in the role of sort of strategy or, gee, have you thought about this or are you doing that on a particular case?
Perhaps more a role of support and resource.
What do you mean by that?
If an investigator or the sergeant would indicate to me that they needed to either purchase something or make a trip, then we would try to make that happen.
Okay. In other words, logistical support.
Yes, sir.
Okay. And so when you say you spend 5 to 10% of your day on specific cases, it would be more in the sort of logistical support realm?
Yes, sir.
Okay. Now, in this particular case, with regard to Kathleen Peterson's death, it went quite beyond that, didn't it?
For the initial couple of days, yes.
Yeah. For example, you don't normally have direct contact with the medical examiner's office on a specific case, do you?
No, sir.
But in this particular case, you did.
I did.
You don't normally call up, say, the medical examiner who indicates that a death may be accidental at the scene to talk with him about that particular finding, do you?
No, sir.
But in this case, you did.
Yes, sir.
You knew that Dr. Snell, do we have that? You knew that Dr. Snell had been out at the scene, right?
Yes, sir.
You were there when he was out there.
Yes, sir.
And you knew that he was shown Kathleen's body, right?
Yes, sir.
That he examined the wounds on the head, right?
I knew he did an examination.
And you knew, did you not, that his findings written in, you're familiar, maybe we mark this. Do you know what's called a report of investigation by medical examiner?
No, we will check this process here, so.
Over 106. Yes. Yes, that's 106. I'm sorry. Let me show you what you marked 106 and ask you whether you recognize that document as, just in general terms, not this specific one, as something that's called a report of investigation by medical examiner.
I've seen them before.
Okay. What happens is when a medical examiner goes out to the scene, for example, he fills out a report with regard to what he observed, right?
Yes, sir.
And it includes things like means of death, right?
I'm not familiar with all the blocks on there, but I would assume so.
Hold on. It has some blocks for means of death.
Yes, sir.
Activity of decedent and premises just before.
Yes, sir.
And description of the body.
Yes.
Place for narrative summary of circumstances surrounding death.
Yes, sir.
And indeed, on the front page, probable cause of death.
Yes, sir.
Now, you knew, because you were there when Dr. Snell came out to the scene, that his findings suggested that Kathleen...
You know what this suggested?
That's your question. You knew that his findings there at the scene suggested Kathleen Peterson's head striking the stairs at least twice with scalp lacerations and avulsions, and that his findings suggest accident. You knew that, right?
No, sir, I didn't know that.
Well, do you see where he says here, discuss my opinion with Durham PD?
I see that.
Are you telling this jury that he discussed this opinion with the Durham PD, but that you never heard it that night?
I didn't.
Well, did you know, or did you find out at some point that on December 9th, may I approach her? Dr. Snell had listed under probable cause of death, closed head injury due to blunt force injury to head due to fell down stairs. And he signed it and dated it on the 9th of December. Did you know that at some point?
I knew that he had indicated that it could have happened by falling down the steps.
That it was the probable cause of death?
No, he said it's possible.
He didn't say it was suggestive of accident?
No, sir. My recollection of what he said was it's a possibility it could have happened that way.
Well, in any event, the next day you called Dr. Snell, didn't you?
Yes, sir, I did.
Because you weren't very happy with him maybe saying it was an accident, were you?
What we discovered was inconsistent at that time, and we were furthering our investigation.
And you knew that if the medical examiner's office stuck with an accident, that would be a real problem for your case, wouldn't it?
As I mentioned, the evidence and what we had found was inconsistent at that point.
Well, they're responsible for looking at the body and making a determination from the body, right?
Yes, sir.
And Dr. Snell had seen the stairway, right?
Yes, he had.
And the various things within the stairway, like the chairlift, right?
Yes, sir.
And the medical examiner's office is not supposed to be an arm of the police department, is it?
I don't understand what you mean when you say an arm of the police department.
It's supposed to be an independent agency that comes to its own conclusions, right?
Yes, sir.
And you don't have any training in medicine, do you?
No, sir.
But on the 10th of December, the day after Dr. Snell indicated in this report of investigation that the probable cause of death was fell downstairs, you were on the phone to him, right?
On the 10th?
Yes, sir.
Yes, sir.
At 4:36 p.m.?
Yes, sir.
And you also spoke with Dr. Butts, right?
I believe I talked to Dr. Snell.
Well, may I approach? Let me just show you where I am. And I've got your handwritten notes here. It has Dr. Butts' name and Dr. Radish.
Yes, sir. But I actually talked to Dr. Snell.
Okay, well, why is Dr. Butts' name here?
If you read further, it indicated they were there, and I was indicating names of people he would call him.
Okay, so Dr. Butts and Dr. Radish were there at the autopsy.
Yes, sir.
All right. And it was during this conversation with you, according to your notes, that Dr. Snell said something else other than the stairs caused that amount of damage, more trauma than 2 stairs?
Yes, sir.
He told you, though, that there were 4 main injuries, didn't he?
Yes, sir, he did.
3 parallel, 1 horizontal.
Yes,
right?
sir.
Did you discuss with him the possibility that you could get 2 injuries, say a parallel and a horizontal injury from a single fall?
No, I didn't.
Did you even think about that?
No, I didn't.
Did you think about the possibility when you were talking with him or discussed with him the possibility that you could get 2 injuries, say, 2 parallel injuries from a single fall?
No, sir. When Dr. Snell informed me that something other than the stairs caused that amount of damage, that was conclusive to me.
That was it for you?
Yes, sir.
That's what you wanted to hear?
No, sir, not necessarily. I wanted to find out what his findings were.
Did you ask him anything about the blood on the bottom of her feet?
I did not.
About whether that might indicate that she had stood up at some point?
No, sir, I did not.
Weren't you interested in that?
I didn't ask Dr. Snell.
About whether if she stood up and fell back down, that could account for one or more of these injuries?
No, sir, I didn't.
Did you talk with Dr. Snell about the fact that there was no skull fracture?
I did not.
That there was no subdural hematoma or hemorrhage?
No, sir, I didn't.
No contusions on the brain?
No, I didn't.
No swelling of the brain?
No, I didn't.
I think if somebody gets hit with a blow poke, you saw that thing, right? That blow poke thing?
I've seen it.
I think if somebody got whacked across the head with that, it might cause at least a linear skull fracture of some sort. Well, did you consider that possibility when you were talking with Dr. Snell?
No, sir, I didn't.
Have you talked to Dr. Snell since that day?
I've talked to him.
About this case?
No, sir, I haven't.
Next time. That's all I have, thank you.
I have defendant's exhibit.
Yeah. 105.
Oh, there's some redirect. Now, let's clear up the preparation of your report, if we could. Let me show you a couple of things. Your Honor, may I approach witness? Let me show you what's marked as State's Exhibit 142. I think you talked with Mr. Rudolph a little bit about that, but we haven't actually entered it into evidence. Do you recognize what's shown here in State's Exhibit 142?
Yes, sir, I do.
What is it?
That's my supplemental report.
And if you would please describe for the jury how this was prepared and based upon your memory when it was prepared.
It was prepared shortly after the investigation was over. I would say, I don't remember the exact date, but I know it was prepared in December. It was prepared in Microsoft Word.
This was?
Yes, sir.
Okay. And why would you have done that?
That was the laptop computer or the computer that I was using at the time.
Now, Mr. Rudolph showed you a notation in Investigator Holland's notes where Investigator Holland received some type of report from you on December the 31st of 2001.
Yes, sir.
Do you know what he was referring to?
My supplemental report.
That would be what's marked here as State's Exhibit 142?
Yes, sir.
We've also got what's marked here as State's Exhibit 143, which, at least reading the text, appears to be the same text as what's marked as State's Exhibit 142.
Yes, sir, it is.
But it has a date of March the 12th of 2002 on it. Can you describe or tell why there's a difference in the time period between preparation of this report and the generation of this computer report?
Yes, sir. The supplemental report that was submitted December the 31st was actually composed by me in Microsoft Word in the computer with the capabilities of downloading it into the other format, which is what we call the S400 computer system, which is records keeping. My computer had some problems, I was not equipped with the program in order to download it. I called information technology. They weren't able to get to it right away. And it subsequently, once they got my computer up and running, actually I was able to download it into the AS400 system, which explains why it was done March 15.
So the March date is when it's actually put into the database?
Yes, sir. It's the very same report.
And are all the reports at some point put into the database?
Yes, sir.
And that would be regardless of when they're prepared?
Yes, sir.
Okay. Now,
Y'all look. Look at this poor starving dog. He's wasting away. He never gets fed. Look at him. He's so skinny. He never gets fed. Look at how little. And my floor is filthy. I need to mop the floor. My dogs don't like the camera. There. That's how I can get rid of him when he's bugging me. Just turn the camera on him.
when you initiate your first search warrant at the home on December 9th, that early morning, y'all were there until about 8 o'clock the next evening. Is that right?
Yes, sir.
And y'all took a lot of evidence from that home, didn't you?
Yes, sir.
When you're in the process of executing a search warrant, would it be the practice of the Durham Police to take things that they think may be relevant to an investigation?
Yes, sir, that's correct.
Everything you take every time, is it always relevant to an investigation?
No, sir, it's not.
But you do the best you can trying to figure out what you think you may need in order to find out what the truth is, don't you?
Yes, sir, we do.
Now, with respect to the sexual assault kit that was prepared for Ms. Peterson, I think you indicated that you weren't aware that the medical examiner's office had chosen to do that. Is that right?
Yes, sir.
And do they always do that?
Unless it's requested.
Okay, and at that point, y'all hadn't requested it?
No, sir, we had not.
Let me show you what we'll mark as State's Exhibit 144. The front of it is what is marked as State's,
Yes.
Exhibit 105. You've seen 105, right?
Yes, sir, I have.
All right, and that's what Mr. Rudolph showed you?
Yes,
as
sir.
it related to the search warrant of Ms. Peterson's body on the 11th
Yes,
of
sir, it is.
December?
Yes, sir.
In State's Exhibit 144, is that page plus several other pages, is that right?
Yes, sir.
Just a moment.
Yes.
Mr. Rudolph showed you what's marked here as Defendant's Exhibit 105, which is the front of the search warrant on the 11th of December.
Yes, sir, he did.
But there are other pages attached to it, and I think you'd indicated that you were aware of that. If you will look at the probable cause affidavit that is attached to what's marked as State's Exhibit 144 and read that section that's marked in the third paragraph of the search warrant.
The entire paragraph?
Yeah, just read that.
After the applicant executed a search warrant of 1810 Cedar Street on December 10, 2001, this investigation revealed what appeared to be a used condom in the victim's bedroom and towels that appeared to have semen stains on them. We believe that with this finding, a sexual act took place.
Okay. Now, was the execution of this search warrant
in direct relation to that finding in the news comment?
Yes, sir.
And that's the only reason you got the search warrant?
Yes, sir, that's correct.
Now, you had indicated to Mr. Rudolph that you had some communication with Dr. Snell.
Yes, sir.
On a couple of occasions.
Yes, sir, I did.
All right. Now, with respect to the communication at the scene, if I'm, may I approach the witness, please?
Yes. I have questions. God.
Hold on, Mr. Harm. Mr. Harm.
Lieutenant Bullock, are you aware of what Dr. Snell said to Investigator Holland about his observations of Ms. Peterson in what might have been her cause of death at that scene on the 9th of December?
I object to the form of that question. I don't object to the question about what Art Holland told him Dr. Snell said.
Sustained.
Are you aware of what Dr. Snell told Art Holland about his observations of Ms. Peterson?
Same objection.
At the scene.
Objection is...
I think you need to reverse the order.
What did Art Holland tell you that Dr. Snell told him about Ms. Peterson and the potential cause of her injuries?
And the potential cause of her injuries?
Mm-hmm.
I don't recall exactly what Investigator Holland told me about Dr. Snell's conversation.
Okay.
Generally, I do remember, as I've mentioned before, that it could have possibly been stairs, but it was so much blood, something else probably caused that amount of damage.
Okay. Did he, based upon your memory, did it indicate to you that he was going to withhold his official opinion until an autopsy was conducted?
First of all, objection to the leading. And second of all, we're now back into Dr. Snell as opposed to what Art Holland may or may not have said to him. So on both those grounds, I object.
Well, I'm not sure, Mr. Harden, who the he was you were referring to.
Dr. Snell.
Okay, sustained.
Do you recall anything else that Dr. Snell told you about Ms. Peterson and the autopsy process?
I do not.
Okay.
That could have been there. Like, he could have had a thing with a escort at his house when Kathleen was at work. Or, like, why would he use a condom with his wife? And if he did SA her before he red rummed her, why would he use a condom? So why did a used condom lead them to believe she was SA'd by her husband before he red rummed her? That, I don't understand how that got them a search warrant. Like I said, I'm confused. That, like, seriously, I want to see the search warrant. What are they searching for? If they've already found the condom, then they don't need the search warrant. Wait, this wasn't the search warrant for the house. This was a search warrant for her, right? So how, I don't get it. How does a used condom form the need for a search warrant for an SA kit when it's a husband and a wife? Like, are you gonna, if you're gonna SA your wife, are you gonna wear a condom? So, no, Nancy, that's what I'm thinking. That's what I'm thinking is that, oh, I knew it would. I knew it would. That's why I wanted to watch it. But that's what I'm thinking, Nancy, is like he had a thing with one of his escorts while she was at work. Because why would he need to use one with his wife? And what, are you going to like get mad at your wife, throw her on the bed and grape her, but you're going to grab a condom first? Like...
It's 106, I think. You have 106?
No.
I got it right here.
Down, make what's in this. Well, let me show you what's marked as Defendant's Exhibit 106. I think you were asked about that a few moments ago. So I'm assuming that you still recognize it.
Yes, sir.
All right. Now, with respect to the notation here that indicates probable cause of death, what does that say? If you can read it.
It looks like closed head injury, and it's a BFI. It looks like BFI to head and fell down. I'm sorry. Closed head injury. Looks like BFI to head. I really can't tell what it is. And the third one is fell downstairs.
Now, is there a mark through that indicating that that's not intended in the report?
Yes, sir, it is.
Now, on the other side, where it says OCME review, what does that say?
Multiple blunt force impacts. I guess that's to the back of the head.
Okay. And then number 2, what does that say?
It appears to be beating.
Okay. And at the bottom, there are several indicators which can be selected to describe what the opinion is of the medical examiner as to the type of death. What does it indicate?
All right. It says indicates homicide.
And is that signed by Dr. Snell?
There's a signature there.
Okay. Does it appear that that was done after the autopsy was performed?
It does appear.
Now, in fact, after the autopsy was done, as you indicated here with Mr. Rudolph, you did call Dr. Snell.
Yes, sir.
All right. Now, may I approach the witness one more time? I'll show you what's marked as State's Exhibit 146. Let me show you what's marked as State's Exhibit 146 and refer to the bottom half of the document. You were answering some questions with Mr. Rudolph about it, and I think you indicated this appears
at least in your handwriting, to be notes that you made. Is that right?
Yes, sir, they are.
Now, is this based upon an actual conversation with Dr. Snell exclusively, or did you talk with Dr. Butts or Dr. Radish, or all three?
I talked to Dr. Snell.
Okay. And based upon what he told you, was he present during the autopsy?
Yes, sir, he was.
Okay. And with respect to that, it's in your handwriting. Go ahead and describe to the jury what all that handwriting is exactly.
Had a conversation with Dr. Snell. I indicated ME to indicate that's who I was talking to. My question is, or he indicated to me, it is a homicide. That was at 4:36 when I called at 4:36 to the ME's office for Dr. Snell.
On what date? Is it in the other part of the notes?
Yes, sir. It's on the 10th.
Okay, all right.
And he indicated to me that something else other than the stairs caused that amount of damage. He indicated there were lesions on the skull. There was more trauma than 2 stairs. There were 4 main injuries, 3 parallel and 1 horizontal.
Did he talk about any other injuries that you recall?
I don't recall at this point.
Okay. May we approach the bench, please?
Yes. All right, members of the jury, we'll go ahead and take a break at this point. Remember the instructions I've given you throughout the course of this trial. Keep an open mind. Don't talk about the case. Stay clear of the parties. Don't read or watch TV about the case. Let's take a 15-minute break. I'll see you at 1:45. All right, further questions?
At this point, we would move into evidence of what is marked as State's Exhibit 142, State's Exhibit 143, and a photocopy of what is marked as State's Exhibit 146.
It's allowed.
In the interest of time, I'm not going to ask at this point that they be published to the jury. I would like to do that later in this session later today after some other witnesses have taken the stand due to some time constraints.
All right.
Otherwise, we have no other questions of the witness at this time.
Further cross?
Just a little bit, thank you, Your Honor. Just want to get to 2 items, Lieutenant Gold. This condom that was found, you did a walkthrough of the scene with Holland on that first morning, did you not?
No, sir, I did not.
Okay, you didn't do any walkthrough at all?
No, sir, until afterwards.
To your knowledge, did Investigator Holland do a walkthrough?
I believe he did.
And no condom was noted at that point, correct?
I can't answer that.
Okay. Do you know what time this condom was found? What date and time?
It was found the first date. I cannot tell you what time.
Well, if it wasn't found until 12:10 at 12:23 p.m., does that ring any bells for you?
If that time was noted, then that's, but I can't attest to that time.
That would have been more than 24 hours after the police took control of the house, correct?
I can't answer that.
Okay, sir. Police took control of the house at about 2:40 a.m. on the 9th, correct?
Yes, sir.
And by the way, that condom was sent off to a laboratory, was it not?
I believe it was.
And there was no semen found on that condom, was there?
I don't know the results of the lab report.
Sir. Let me show you Defense Exhibit 107. And ask you whether you recognize that as a laboratory report prepared by the State Bureau of Investigation.
Fire today.
Yes, sir, I do.
And showing you, does it appear to be a laboratory report that deals with this condom?
Yes, it does.
And just showing you the second page of that, does that refresh your memory at all about whether or not the testing done by the SBI revealed any sort of semen?
It does not.
Okay. Now, with regard to Dr. Snell, may I approach, Your Honor? Yes. The notes have been marked now as State's Exhibit 146. Those are the notes we're talking about that you took with regard to your conversation with Dr. Snell?
Yes, sir.
And at the very top of that, what it says is, M.E., is it a homicide? With a question mark. Isn't that right?
It does.
So that wasn't what Dr. Snell told you. He didn't say it is a homicide. That's what you were calling up to ask him, right?
That was a note to myself, to the ME, to ask if it was a homicide.
Right. And what he told you, the two things he told you, according to your notes, is something else other than stairs caused that amount of damage. Right?
Yes, sir.
And more trauma than 2 stairs.
Yes, sir.
And in fact, in terms of the amount of blood there, on the 9th, what he had said in his notes was that the blood spatter appears to support the accident. Isn't that what he'd said?
I didn't read his notes from the night.
Did you ever hear him that he had said that to someone?
A general statement, yes, sir.
Anything else, Tom?
To your knowledge, Dr. Snell is not an expert in the field of blood spatter or blood stain analysis, is he?
To my knowledge, he is not.
No other questions.
Anything else, Mr. Rudolph? All right, you can come down.
That Kathleen Peterson died intestate without a will, and from a documentary perspective, in order to demonstrate that, the state at this point would tender into evidence what is marked as State's Exhibit 140.
Your Honor, we do in fact stipulate as to her intestate status at the time of her death and have no objection to Exhibit 140.
All right, members of the jury, a stipulation is an agreement by both the state and the defendant that a certain fact exists and no further proof by either side is necessary to establish this fact. All right, Mr. Harden, you have document?
Yes, sir. At this point, we would call John Huggard as a witness.
All right.
Sir, if you place anything on the Bible, raise your right. Solemnly swear the testimony you're about to give the court and the jury in the case now being heard to be the truth and nothing but the truth, so help you God.
I do.
Please proceed.
For the record, sir, please state your name.
My name is John Huggard.
And how are you employed, sir?
My primary job is I teach full-time at North Carolina State University in the Department of Business Management, where I teach finance and law.
And with respect to any other responsibilities or duties that you might have as it relates to practice of law, do you have those as well?
Yes, I am a senior partner in a Raleigh law firm where I've practiced for almost 30 years. We have a mixed practice. My primary responsibility is anything having to do with estate planning or financial planning.
Now, if you would please describe for the jury what your experience and what your education has been as it relates to the field of study that you teach, which you indicated was finance and business law, and also as it relates to your practice of law.
Okay. My educational background is that I am a graduate of the University of North Carolina, Chapel Hill, where I received an undergraduate degree in economics. I received my master's degree from Duke University.
In the interest of time, we'll stipulate this witness is an expert in the field of estates and is qualified to describe the various rules that relate to intestate succession, if that would help in all terms of time matters.
Thank you very much. I would take the opportunity to abbreviate some of his experience, but I appreciate that stipulation. All right. If you would please abbreviate a little bit and just generally run through the experience.
Received my law degree from the University of North Carolina, Chapel Hill. From the time I graduated until today, I've been involved in teaching at the university or practicing law.
Now, do you hold any particular certifications or specializations in any areas of the law?
I'm certified by the North Carolina State Bar as a specialist in probate law and estate planning. I do have other certifications such as CFP and Chartered Financial Consultant to deal more with financial planning rather than estate planning.
All right. Have you written any text about the practice of law or as it relates to financial planning and financial matters?
I've written 2 or 3 books, 3 that I can recall, 1 on trust and 2 on estates administration in North Carolina.
Any articles?
Yes, I've written articles for financial magazines before. They would deal either with trust, probate matters, or occasionally financial matters.
Your Honor, with the stipulation, I understand that the court's going to accept Mr. Huggard as an expert in the field of estate planning.
All right, sir. He's accepted.
Now, Mr. Huggard, did you have the occasion to evaluate a series of assets that were held by the Petersons at the time of Kathleen Peterson's death?
I was given a list by the district attorney's office indicating what the assets were at the time of death, yes.
All right. With respect to that, were you aware that Ms. Peterson died without a will intestate?
That is my understanding from looking at the court documents from the probate clerk's office that she did die intestate.
Your Honor, may I approach the witness, please?
Yes.
Let me show you what's marked as State's Exhibit 140 and ask whether you can identify that, please.
Yes, I can identify the document.
What is it?
It's letters of administration, apparently from the Durham County probate clerk's office, indicating that the estate of Kathleen Peterson is an intestate estate.
And exactly what does that mean when one dies without a will intestate?
When one dies without a will, we say they have died intestate. It's simply a fancy word meaning that we do not have a will to direct how their assets will pass or who they're to pass to. In that case, we go to our general statutes and essentially leave it to our legislators who have created the intestacy statutes, and then they determine where assets will go.
Now, with respect to dying intestate and the distribution of the property, if you would please describe what that process is like so the jury has a general understanding of it.
What essentially happens when one dies intestate, it's a little bit more complex than most estates because all of the property that's considered intestate property has got to pass through probate. So it's a little bit slower, a little bit more cumbersome, maybe a little bit more expensive than property that doesn't pass through probate. But essentially what happens is whoever the executor or the administrator of the estate is will follow the North Carolina intestacy statutes and divide up the net estate after all debts have been paid. We only divide up the net estate after all debts have been paid. But by following the statutes and depending on the number of children the decedent had, which is the primary criteria of how you divide an intestate estate, we would then divide the estate based on that. In other words, the children are going to get a certain portion, the spouse will get a certain portion, sometimes even the parents will get a certain portion. It just depends on the beneficiary beneficiaries that are left and how closely they're related to the decedent.
Now, typically, when property is distributed, what kinds of property will be defined and distributed out of an estate?
The only property that passes by intestacy in North Carolina is what we call probate property. It means property that is essentially solely owned by the decedent. There are certain types of property that would not only not pass by intestacy, but they would not pass by will, even if they were addressed in a will. Some common examples that most everybody would know would be life insurance. Life insurance passes to the named beneficiary. Retirement accounts, IRAs, 401ks, things like that, if there's a named beneficiary. Another very common one is houses. Most houses in North Carolina are owned jointly between spouses, and the minute one spouse dies, the other spouse owns that property by statute. That would not pass through probate, and again, it wouldn't make any difference whether there was a will or not. There's just certain types of property that pass by statute outside of both intestacy and outside our testate statutes.
Now, with respect to the person that actually presents to the clerk and goes through the probate process, what is the name of that person?
We would generally, if we're talking about an intestate estate, we would refer to that person as an administrator.
Are you familiar with who is the administrator or administratrix in the estate of Kathleen Peterson?
It is my understanding that it is her, I believe it is her daughter, Caitlin.
Will you generally describe the process of how one would qualify to be an administrator or an administratrix for an intestate probated estate?
Yes. When you have an intestate estate, the person that is entitled to be the administrator of the estate is set out statutorily. Again, if you use just a little bit of common sense, you almost know what the statute's going to say. The first person that's entitled to be the administrator of an intestate estate would be the spouse of the decedent, assuming that the spouse comes forward and says that they want to do it. Sometimes that doesn't happen. If for any reason the spouse does not qualify, or for any reason the clerk does not qualify the spouse, then we go right down the list. And again, it should not surprise you. Next on the list would be very close heirs or beneficiaries, which would usually be adult children. And then the list would go right on down. It would actually go down as far as interested creditors. But typically we would have a close family member, at least in name, act as the administrator of the estate.
All right. Now, with respect to your analysis of at least aspects of this estate, did you have the opportunity to consider how personal property might pass?
Estates are broken up into essentially three broad categories. When people die, they leave personal property, automobiles, clothing, jewelry, etc. They will leave real estate in many cases, and they will leave what we call non-probate assets, insurance, joint ownership of houses, things such as that. And that usually makes up the estate. And what we do is each one of those are treated differently under our intestacy statutes as to how they pass. So the answer to your question is yes, I took a look at the personal property. I was given a figure as to what that personal property was.
All right. Now, if I may, may approach the witness, please. Let me show you what's marked as Defendant's Exhibit 44 and ask whether you can identify that.
I can identify the document.
What is it, sir?
It is a declaration page from an insurance policy. The declaration page tells me it's either an HO2 or an HO3 policy. HO means homeowner, so it's homeowners 2 or homeowners 3. They're very, very similar in nature. It insures a house at 1810 Cedar Street, owned by Michael Peterson. The first thing that it tells me whenever I look at a declaration page is, and the important thing is what we call the A coverage or the dwelling coverage. And in this case, we have a house valued at just slightly more than $1 million that is fully insured under this policy with USAA.
Now, in the coverage and limits and liability section, it looks like you're referring to that. Would you go ahead and go down the various sections there and describe what they mean?
The next item is what we call C coverage, personal property. And personal property coverage in North Carolina under virtually every policy written is always a percentage of the dwelling coverage. Generally, among insurance professionals, we refer to this rule as the 70-20-10 rule. And what that means is personal property is going to be insured at 70% of the value of the house. 20% of the value of the house will cover your loss of use, and 10% covers what we call B coverage, which is outbuildings, detached garages, things such as that. So in this case, if you take 70% of that figure that's just over $1 million, that comes out to precisely $719,600, which is 70% of that figure. What that shows is the maximum amount of insurance that the insurance company carries, or liability. If your property is more than that, you're simply not covered. If it's less than that, you're covered if you can prove to the insurance company, to their satisfaction, that you did have whatever the value of that property was that was destroyed.
Now, with respect to the personal property coverage indicated here, that being $719,600, then does that actually reflect what the value of the personal property is?
No, not only does it not reflect it, it would be very, very rare, very, very unusual in a policy sold in North Carolina that somebody would have the amount of personal property that is covered under the policy. To give you an example, typically in North Carolina, if you have a $300,000 house and it's insured for $300,000, then your personal property coverage.
Object. This goes beyond the scope of his expertise as expert in estates. He's now talking about the average amount of property people own, so I'd object to that.
Start. Your Honor, I'm in the process of getting ready for him to describe what the personal property is and the fact that there are no riders to this as it relates to unusual personal property, such as art, antiques, jewelry, those kinds of things. And
Right, well, his objection is sustained. You can continue with your examination.
now, with respect to this figure of personal property that's shown here on the document, would it include all the personal property?
No. On a basic HO2 or an HO3 policy, that figure is personal property, what we typically in the insurance business refer to as normal personal property: bed, sofa, refrigerator, TV, stereo set, etc.
Jack, he's an expert on estates, not.
Would a policy such as this include additional coverage for unusual types of personal property?
Deliberation. Mr. Maher, why wouldn't he know that information from his experience as an estate expert?
I'm not sure. Why would an estate lawyer know how insurance companies deal with personal property? Because the estates deal with the value of property at the time of death. Insurance value doesn't determine property at the time of death, and it would be beyond any expertise this witness has been shown. In addition, to talk about averages, when we have pictures of the house that contains art, they've had access to the house, to suggest that somehow we should assume that the average is relevant when we've got specific information about this house is irrelevant.
Are you saying he wouldn't know, just as part of his expertise, what the insurance coverage would be? He probably deals with that all the time.
We didn't object to him describing the general rules, but now we're getting beyond that and talking about whether this insurance policy would cover specific items of value that people would normally have in their homes, and going far beyond that. The jury's already heard his testimony that the 700 figure is a 70% figure, but we're now going far beyond that, and there's no showing that he would have any expertise in that. In addition, it's not relevant when we had the actual pictures of what was in the house. To suggest that we should.
Mr. Hart, I'm not exactly sure what it is you're trying to elicit from this witness.
Well, through this document, with nothing else,
the defendant has put to this jury that there was personal property in that house evaluated to $719,000. And from our perspective, that may or may not be the case. This witness can talk about that. He can talk about the fact that he doesn't see any riders to this because those riders would address the antiques and art that the defendant claims exist in the house. We've not heard anything about the value of them. But as far as this jury is concerned, this document right here has been presented to them, demonstrating to them that the personal property was $719,000. And if he had chosen to do it, Mr. Peterson could have sold all of this to keep himself financially afloat.
Well,
so they have given a misimpression.
The only question I have, Mr. Harden, is whether this is within his expertise.
Well, it is, but if you take into consideration, he is board certified as an estate planner. He is a certified financial planner. He is a certified financial consultant. He deals with these things every day, all day long. That's what he does. He is very familiar with his policy. In fact, when I ask him about it, he says, I keep a copy of this in my office.
Or anything else, Mr. Maher, on this issue?
The point the state believes they're entitled to make, which is the policy doesn't prove that there is in fact exactly $700,000 worth of insured, has already been made. The question is we're not going well beyond that. And I don't believe it's relevant in this situation or that there's been a foundation for his expertise. And so we object to any further testimony about values of property in general in people's houses or the value of the insurance policy.
All right, in the court's discretion, the objection is overruled. All right, objections overruled.
Now, we were at the point, Mr. Hubbard, of talking about personal property that's not covered by this percentage of the value of the house, or at least what the house is insured for. So let's go back there. If someone were to claim to have antiques and artwork and exceptionally valuable pieces of jewelry, would it be covered under the personal property section in this declaration page?
It would not be. The typical HO2 or HO3 policy covers, again, as I testified to a moment ago, what we call normal personal property, bed, sofa, refrigerator, TV, things such as that. In North Carolina, if you have antiques, if you have anything that qualifies as an antique, anything that is artwork, collectibles, rare firearms, things such as that, they are not covered under the basic HO2 or HO3 policy. They must be scheduled separately with the insurance company, and they must be insured separately, and they would be insured under a rider for most policies.
Would value have to be assessed as it relates to those individual items in order for insurance coverage to be had?
Absolutely. What's typically done is, say somebody has a Picasso that they want insured under their policy, they would call the insurance company up, let the insurance company know that they had a valuable Picasso. The insurance company would want to come out and make sure that they did have it, that it was real. They would attach a value to it, and then they would insure it. And there would be a separate premium for that single painting. The insurance company, in many cases, will sometimes come back and add additional requirements to the insurance. For example, somebody would have to have a burglar alarm, fire alarm, things such as that.
Okay. Now, with respect to the personal property that's indicated on this declaration page, did you do some general calculations as to the distribution of the property? And some various scenarios based upon your understanding that there's, according to this, is at least $700,000 worth of personal property in that house.
Based on that figure, and I use the figure roughly $700,000 because it's easy to work with mathematically. And what I did is something we do typically in a lot of estates. When one dies, we're really not sure initially what personal property they own, what personal property their spouse owned. It's very difficult. If you can imagine, if, for example, if you see a sofa in a house, you don't know, did the husband buy it, did the wife buy it, did they buy it together? So one of the things we do to kind of get a gauge on this is we will assume that the decedent owned all the personal property. And then we'll do a calculation based on intestacy doing that. We will then assume that the surviving spouse owned every bit of the property and the decedent owned none, and do a calculation there. And then we'll do one or two calculations in the midpoint to kind of get a range of what would pass to beneficiaries, whoever those beneficiaries are.
Now, giving the defendant the benefit of the doubt on this form, and the declaration that there's personal property of $719,000 plus in the residence. Again, did you do some calculations with that figure outlining what percentage would have gone to whom upon Kathleen Peterson's death?
I did.
Your Honor, could the witness step down before the jury and describe that on the butcher block paper?
Yes.
Mr. Huggard, again, if you would, use $700,000 as general baseline number of personal property for the residents at 18 Hempstead Street. And if you would, please go through your various scenarios describing what would be distributed to whom.
Okay. Let's start with the first one. The first parameter would be to assume that the husband owns the entire $700,000. That's an easy one, because if we assume the husband owned the entire $700,000, the decedent owned nothing. And therefore, at her death, that $700,000 belongs to the husband because it's his outright, so he's entitled to it, and so he would have the $700,000. The far end of the spectrum would be to assume that the wife had the entire $700,000 and none of the personal property in the house would have belonged to the husband. In that case, we have to come back and do a calculation based on our intestacy laws. And the way we would do that in North Carolina is we would take the first $30,000 under our statute. The first $30,000 always goes to the surviving spouse, regardless of the value of the intestate estate. I think that would bring us down to $670,000. This would go to the husband. And then the intestacy statutes in North Carolina tell us that once we've done that calculation, we would come back and divide this property in two parts if the decedent had one child. Now, if the decedent had more than one child, we do a slightly different calculation. Using the facts of our case, if we divide that, we would come up with $335,000 if we divide that in two parts. And one part would go to the husband, and we'd have $335,000 would go to the other beneficiary. In this case, that would be the daughter. I believe her name is Caitlin. And then we would come back and add to this the $30,000 that the statutes gave the husband. So if we use this hypothetical, we come back and it looks to me like, if my math is right, the husband would get $365,000 of that $700,000.
So let me stop you right there because I want to make sure I understand it. If under your scenarios, the husband owns all of it, he takes all of it.
It's his property.
If he owns none of it at her death, he takes $365,000.
Correct.
Would you have circles around this one? Okay. Now, were there other calculations that you did as well as?
You can take any midpoint you want, and I look at as many as you want. I took a couple that I think were reasonable. The next one I did is I just simply had the husband owning a little bit more than the wife. And the figures I used, I think, if my math is right, I assumed that the husband owned the lion's share of it, $550,000, and the wife would own $150,000. Again, we go back and do the exact same calculation because nothing's changed. We take the $150,000 belonging to the decedent. The statute tells us to take 30 from that. That brings us down to 120, and we would then divide this by 2. The husband would then get 60, and he would also get the other 30 the statute gives him. He would get 90 of this. The daughter gets the remaining 60 of this. That would give us that 150 figure. And so the husband in this case would get 90 from the estate, and he already owns 550 himself. So I guess if my math is right, I believe when all the dust settles, of that money, I think $640,000 would pass to him.
All right. Now, this is your third scenario. Is that right?
Yeah.
Would you mark a 3 right there and circle that for me, please? And I think you said you did another calculation as well.
I reversed this one to get the same idea. I came back and said, we'll have the husband with $150,000. We'll have the wife with maybe $550,000. And again, I went back and did the exact same math. Again, nothing different. $550,000. The statute tells us to pull 30 out, brings us down to 520. So 30 is going to go to the husband over here by statute. What's left, again, we divide by 2, and that gives us, again, 260. He would then pick up 260. The daughter, in this case, the other beneficiary, would also get 260. But up here, the husband would get 290. He also owns 150 in his own right. And so again, he would walk away again when all the dust settles. Of that $700,000 based on this scenario, he would walk away with about $440,000.
Okay. And are those all the scenarios?
I believe those were all the scenarios. Again, I could go back and we could do this all afternoon, changing the figures. But the reason we do this in our office when we have a case like this is to let beneficiaries know a range of how much they might get. And we'll do that. We'll assume the decedent known at all, the decedent known none, and pick several mid-ranges based on the information we have. And that way we have a range. And that usually satisfies folks.
When you do this, that presumes that there hasn't been an accounting of all the personal property. Is that right?
That's true.
So the accounting is actually what you would use to put the real numbers to the paper to determine actually what was going on.
Absolutely. We'd have to use the final accounting, and we feel more comfortable when we have an accounting with an estate of this size. There's almost always going to be a formal inventory done by a professional where it's actually inventory, and so we would use that. And the figures can change dramatically. The percentages will never change, but the figures can obviously change almost from day to day.
But we still have your outside parameters of the first scenario.
Yeah, based on $700,000, we do have the outside parameters. Yeah.
Okay, so we've got this range right here, so it's got to fall between that.
It's got to.
Okay. Now, did you conduct an analysis of the real property that was owned in the Peterson household at the time of her death?
I reviewed about.
Let's pick that up after.
Yes.
After lunch. All right, members of the jury, we'll go ahead and take our lunch break. Remember the instructions I've given you throughout the course of this trial. Keep an open mind. Don't talk about the case. Don't read about it. Don't do any independent research. Don't watch TV. We'll see you at 12:45.
Now, just before the luncheon recess, we were going into another subject, but a related subject. And I was asking you whether you had gone through the analysis of the real estate that was owned or that Kathleen Peterson had some ownership interest in at her death. And I think you indicated that you had done that. I'd ask if you would please to describe for the jury what analysis you went through that related to each of those individual pieces of property.
There were approximately, as I recall, maybe 6 files, give or take one. Each file dealt with a certain piece of real estate that the decedent would have had some interest in, either with her husband or with other individuals. And what I did in the analysis is I took each type of property, determined how it was held. Each of these pieces of property are maybe held in a different manner, either tenants in common, tenants by the entireties, or what have you. And then based on how it was held, I then applied our intestacy statutes to determine who would be entitled to that property at the decedent's death.
Yeah, before you get into the specifics of it, what does tenancy by the entireties mean?
We can hold real estate in different ways. Tenancy by the entireties is a very, very common method of ownership. Tenancy by the entireties means a piece of real estate is owned by a husband and wife. It has a particular statutory significance in that if a husband dies, the wife instantly owns the house and vice versa. That's one way of owning real estate.
All right. Okay. And with respect to tenancy in common?
Tenancy in common is a little bit different. Tenancy in common would indicate that two or more people own a piece of real estate jointly, but it does not have the survivorship aspect that tenancy by the entireties has. In other words, each individual owns their share without any rights of survivorship. They can leave it to whomever they want. It will pass by intestacy. They can sell their share. So it's slightly different, but it is still a form of co-ownership of real estate.
If you would, please take this marker and the books block paper and describe the analysis that you conducted with respect to those various pieces of property.
Okay, I'm going to need to use my notes.
Yes, sir.
Okay, the first piece of property that we had, I'll just number them, but the first piece of property that I looked at has an address of 1910 Ward Street. And this was a piece of property that was owned by the decedent and Mr. Peterson in this case, and it was tenants in common. As I mentioned to you a minute ago, each one of them owned a half. So I'll put over here tenants in common. Each one of them owned a half of this piece of property. Under our intestacy statutes, if there's no will, the way a piece of property that's held tenants in common would pass on these facts would be at death, obviously, the husband would still own his one half. He's always owned one half, so he's going to have that. The other half belongs to the decedent, and we would just divide it by the laws of intestacy. And we do it just like we do personal property with one exception. There is no $30,000 threshold, so we can eliminate that. It makes it fairly easy. We'd take the other half, and one half would pass to the decedent's spouse by the laws of intestacy, and then 1/4, being the total one half, would then pass to the daughter. So as to the property at 1910 Ward being tenants in common, after the death of the decedent in this case, the husband would then have an ownership interest in that property that would amount to 3/4 of its value, with the daughter owning the other 1/4.
And with respect to the next piece of property, how would the ownership, what is the name of that?
The next one is, if I can read my writing, I'll put down, I think it looks to me like 2352. 2352, right here on. This piece of property is a little bit different, as I mentioned to you, and I'll put a note out here. This is tenancy by the entirety. As we mentioned a minute ago, when the husband and wife own a piece of property, tenancy by the entirety, immediately upon the death of either spouse, the other spouse owns the property outright. So on the day that the decedent died, in this case, the title to this piece of property passed to the surviving spouse, Mr. Peterson in this case, and following death, he would own 100% of this property.
Okay. And did you conduct a further analysis of other property as well?
Let's see. The third one is 1908 Ward. And I believe here we get a slight variation. This one is a little bit unusual in that it was owned by the decedent in this case, along with one of the sons of Mr. Peterson. I believe his name is Todd Peterson. So it was owned tenants in common, but in this case it was owned by the decedent and one of the sons of Mr. Peterson. But still, it's tenants in common, and so we would have that ownership. Again, the way it would pass is 1/2 of the property always belonged to, and always would, to the son. I'll put his name down here, Todd. So he has half of it. At the death of the decedent, we take her half and divide it up according to the laws of intestacy. And again, we have 1/4 passing to the husband, and we'd have 1/4 passing to the daughter.
Is this tenants in common, you said?
This one is tenants in common. It's just slightly different than the other tenants in common in that It's between two unrelated people, whereas this one was related. As to the division, it's identical. We'll make no distinction.
So in this particular instance, he owns 1/4 interest in this
He
property.
would own 1/4 interest. The daughter would own a 1/4 interest. Sorry.
Can you please describe the next piece of
I
property?
think the next piece I've got down here at 1406. Lakewood. And this one again is a little bit different. This one was owned by I'm sorry, this one's the same as the last one. This one was owned tenants in common between the decedent and Todd. So again, we're going to get the exact same result. After the death of the decedent, 1/4 of it would pass to the husband, 1/4 goes to the daughter, and the remaining 1/2 always belonged and would continue to belong to Todd. So the breakdown would be as follows.
And this is tenants in common here.
Yep, this one's tenants in common.
Now, were you requested to look at any of the values of any of these properties?
Not really. It would not change this. This does not change. The values might change. In other words, this property might be worth $50,000, and then later on we might find out it's worth 60 or 42. It doesn't matter. This is always going to remain constant.
So in terms of your calculations, whether there's an appraised value or tax value, it's irrelevant?
It does not make any difference. I did mine based on fractions or percentages.
Okay. I understand there's other pieces of property as well.
We have a fifth one down here that I looked at. The fifth one is 1008 Sycamore, and this one is slightly different. This is tenants in common with the decedent and a second son of Mr. Peterson. I believe his name is Clayton. So again, we're going to get the exact same result up here. All we're doing is changing the interest that another individual would have. So in this one, we'd have 1/4 going to the husband. We'd have 1/2 pass, or 1/2 is going to belong to Clayton because it was his property. And then by our intestacy statutes, 1/4 of it is going to pass to the daughter.
All right. Were there other properties as well?
Those were the only properties that the decedent had an interest in. Now, there were other properties that were in the name of Mr. Peterson at the death of his wife, and she does have a statutory interest in those pieces of property. It is not an ownership interest.
Would you explain that, please?
It's kind of difficult, so I'm going to do as best I can. North Carolina has a statute that allows a spouse at the death of their spouse as an alternative to taking under a will if there is a will, or as an alternative to taking under the intestacy statutes, the right to take what we call an elective life estate. They have the right to go back and find all the real estate that was owned during the marriage, whether it's still owned or not, it's immaterial. Whatever real estate was owned during that marriage, the surviving spouse has a right to come back and take a 1/3 interest in the property. And it is free and clear as a general rule of all claims, all mortgages, and things such as that. There is a variation of this elective life estate. If the surviving spouse elects to take her or his share in the last marital dwelling, then the 1/3 rule kind of goes out the window and they're entitled to the entire thing. The reason for the statute, I'll give you an example of why we have the statute. Let's just say a husband dies, and because of bad business ventures or whatever, he dies essentially penniless. And the only thing he had at the time of his death is the house he lives in, and it's in his name. If we go in and sell that house off to pay us debts and obligations, then the estate may go down to zero and we have a spouse on the street penniless. So North Carolina has a statute that would allow the wife to come in my example, and say, I want to live in the last marital dwelling for the rest of my life. I get all the contents of the house, and I do not have to pay the mortgage. So that's essentially how the elective life estate works. At the time of the decedent's death, in this case, there were 3 pieces of property. They were all held in Mr. Peterson's name. But again, all 3 of these pieces of property were subject to the statutory right that the decedent would have had.
If you would, please, would you outline that analysis on this closure block paper for those 3 pieces of property?
Okay, there is no analysis other than I can put down the 3 pieces of property. We need to know that, I think.
Yes.
The ones that I found that were subject to the statutory right, there's 1810 Cedar. And I believe that's the main house where Mr. Peterson and his wife lived. There was another piece of property, 2601 Stewart. And then there was a third piece of property, 1632 University Drive. So these three pieces of property are clearly in the name of Mr. Peterson. The wife does not have an ownership interest, and to my knowledge, never had. What she did have at the time of her death, or at least when she was alive, was the statutory right to make an election in any of those pieces of property.
All right. Now, with respect to these three pieces of property in Mr. Peterson's name, if these properties were mortgaged or sold, what interest would Kathleen Peterson have had in affecting that change in the title?
Well, there's a couple of problems. The first one, if we just take them one at a time, for purposes of sale, it's going to be virtually impossible to sell this property. It's just simply not going to happen. If somebody were to go to a real estate broker or a real estate attorney and say, I want to sell this property, even though it is in the name of the husband only, this property could not be conveyed because the wife has that statutory right. And it carries over even if the property is sold. So the problem we have is if this piece of property were sold without the wife's written permission, essentially what we call a waiver, then whoever buys this piece of property would always run the risk that the seller, the husband, could die, and the wife would then show up and say, I want to take my elective life estate. And so because of that, there's no lender anywhere in North Carolina that I'm aware of. There's no real estate lawyer that would ever pass title to their client without getting at least one thing, and that is the signature of the spouse. The signature of the spouse on the deed would be her waiver. Then the property can be passed free and clear. We would not have that problem. We run into the exact same problem with attempting to go out and get a line of credit, a mortgage, or a loan on the property. Again, if a bank were to lend money on any of these three pieces of property, and then down the road the husband dies, the wife can come in and say, I want to elect my life estate in that piece of property. And the statutes are fairly clear in North Carolina that she would not have to pay the bank as long as she lived in that property. If she's 45 years old, this could go on for 40 years. The bank would just hold their mortgage and not be paid. What banks do when they lend money to, say, husbands that own property in their own name is they're glad to lend it to them, but they always say, bring your wife with you and have the wife sign the mortgage or the deed of trust. And that would be her waiver, and we would not run into that problem.
Just for sake of brevity and understanding, then would Kathleen Peterson have had to give consent for any of this property to be sold or mortgaged?
Yes.
Okay. Now let's reverse it.
Yeah, okay.
Say she wanted to sell or mortgage any piece of this property. What would the interest be there?
It would be the exact same thing. The same rule applies. If, for example, the wife said, let's sell this piece of property at all. If the husband said, I think that's a good idea, and they both go down and sign the documents, then the property can be sold like any other piece of property. But if the wife says, I'd sure like to sell this piece of property, and the husband comes back and says, I won't sign, then we're in the exact same situation. It works both ways. That property is not going to be sold or encumbered.
Right. Okay. Now, with respect to, with any more pieces of real estate?
Not that I could find, but those are the only pieces of property I was aware of.
Okay. You can take a seat. Now, I think you also indicated that there was a third type of property that would be dealt with at the death of an individual, and I think you described it as non-probate assets.
That's correct.
Were you made aware of some non-probate assets in this particular situation?
When I reviewed the documents that were given to me, I found about 4 or 5 classes of property that very commonly would make up non-probate property. Again, non-probate property passes to surviving spouses, children, beneficiaries, what have you, based on the designation and not based on what might be in a will or in the laws of intestacy. Again, insurance being a primary example, tenancy by the entirety's property, retirement accounts, IRAs, things such as that.
Your Honor, may I approach the witness, please? Now let me show you what is marked as State's Exhibit D8.
Is anybody else having problems with the word intestacy? I don't like it. I don't like that word. It's grossing me out because it reminds me of intestines. Intestacy. Intestines. Intestacy. I don't like it. Y'all, this is why you watch me. You like me because my brain is weird. Doesn't it though? Intesticles, intestacy, intestines. I don't like that word, intestacy. It is. It's a weird word. Thank you, Nichelle. It's a weird word. I don't like it.
Have you seen a smaller version of it?
I have indeed, yes.
Now, with respect to non-probate assets, there's evidence before this jury that Kathleen Peterson had a 401k plan at Nortel and that Mr. Peterson was the beneficiary. To whom is that money going to go?
That would clearly pass entirely to the husband, Mr. Peterson.
All right, and it doesn't go through probate at all.
It would not go through probate.
Okay.
Actually, I'm not so bad with moist. I don't know why that bothers people the way it bothers people. Like some people were like, no, do not say that word. And like if it just comes up in conversation, I'm okay with it. I just like cringe because like you threw it out there as that word. But like if you just say it in conversation, like I'm okay with it. But like why don't people like the word moist? Like it means wet, damp. But intestacy, that's a weird word. What's another word? There's another word. Is it panties? I think it's panties that people don't like. But that's like a private word. Like you don't generally talk about panties. Great. I just screwed up because now you guys are going to be thinking of all these weird words are going to start popping up in my chat. Like with the fish that day. You guys just started naming different kinds of fish. So that's why I love my chat so much. Now you guys are just going to be, oh, Marty. Oh my God, what have I done? Oh my God, what have I done? Oh, yeah. 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 I can see that. I can see that. Nancy, I'm going to delete that one. Oh, well, if it'll let me. Because I know. Because Nancy, I deleted that one because you can. Just not on the beach. Or in line at Disney.
And with respect to a pension plan that Kathleen Peterson had at Nortel, there's evidence before this jury that she had that, and Mr. Peterson was designated as a beneficiary for the pension plan. What would that situation?
It would pass entirely to Mr. Peterson as non-probate property. It would not go through probate. It's not subject to probate.
All right. Kathleen also had deferred compensation at Nortel. and had designated Mr. Peterson as the beneficiary in the deferred compensation. What would the situation be there?
With a deferred compensation package, whether it's qualified or not, it's going to pass to the named beneficiary. So in this case, it would pass entirely to Mr. Peterson. It would be non-probate property as long as there's a named beneficiary.
Did you also look at the insurance designations?
I did.
And what would that indicate?
To the extent that you have a named living beneficiary on insurance, it's non-probate property and would pass to the named living beneficiary, whoever that might be. I'm assuming that the beneficiary in this case was Mr. Peterson. If so, he would receive not only the basic life insurance policy, but it carried a double indemnity rider. He would also be the beneficiary of those riders.
And assuming the math's correct, does it add up to $1.8+ million?
Somewhere in excess of $1.8 million, if your math is correct, yes.
Now, you're also aware of some bank accounts that were owned by Mr. and Ms. Peterson?
In reviewing the documents, I do remember.
I don't think that had anything to do with the motive. I think they were a perfectly happy couple until she found his gay porn on his computer. I think she went to get that email from her coworker and didn't have her computer, so she had to use his. And she found his gay porn and confronted him, and that they started a fight. And I think that's, so that would be, they charged him with first degree, but I think it was second degree, because I don't think he did it for the money or anything like that. I think it was a spur of the moment. She found my porn and we had a fight. But we will never know.
I've seen a couple of what I would call small bank accounts, yes.
Were you asked to determine precisely what the ownership interest in those bank accounts was?
I was not.
All right. But you're aware of that?
Oh, yeah.
Let me show you what's marked as State's Exhibit D9. The last notation here with respect to bank accounts, and that indicates that there's just a little under $43,000 in the accounts.
That's correct.
Can you give some opinion on how that money would have been distributed to heirs?
Yes, we would have to know how those bank accounts are held. At last count, I can think of at least 4 or 5 different ways bank accounts could be held. If this bank account is held entirely in the wife's name, then it becomes personal property, and we would do the distribution we made a moment ago. It would be part of that where we would deduct the $30,000. So if it belonged entirely to the wife, that's what we would do. If it belonged entirely to the husband, then it's his money and he would get the entire amount. Anywhere between those two figures, they would divide it up somewhere between those two figures. If the account was held, and a lot of bank accounts today are held by husbands and wives jointly with rights of survivorship. Mm-hmm. Again, that would mean when a wife dies, the husband gets it instantaneously, or if the husband dies, the wife would get it instantaneously. These accounts are fairly commonly held with what we call a POD or a TOD designation. POD meaning pay on death, TOD meaning transfer on death. It's a very common type of bank ownership. And again, it would be very similar to a joint account. On the death of either spouse, the other one would be entitled to the entire thing.
But you weren't asked to specifically look at every account, were you? Okay. You also weren't asked to look at any particular values as it related to real estate interest and any personal property. You didn't look at any appraisals or anything like that?
Until an estate is absolutely closed out and the money distributed and taxes paid, those figures can actually change almost on a daily basis. So to try and do a calculation based on a set dollar amount would be very difficult. And that's why we use percentages or fractions. They never change. We would just apply those to whatever the net amount was at the end.
Right. Now, given that there is some range of what Mr. Peterson would have taken at Kathleen's death with respect to the value of the property, assuming it's $700,000, and based upon your description of how the real estate would pass and how the non-probate assets would pass. Do you have a general opinion as it relates to the amount of the entire estate that would have passed to Mr. Peterson upon Ms. Peterson's death?
Jeff.
I do.
Yes, sir. What is that opinion?
Generally, it would be a significant part of the estate. Each asset would be different, and we would have to know values. But for example, the non-probate property is the easiest one. 100% of that passed to the decedent.
And that's the $1.8 million.
That was the $1.8 million figure. The real estate is a little bit more difficult. The only thing I can say is in some cases, he got all the real estate. In other cases, he may have only gotten 1/4 of it. But again, we don't know the values. If one of those houses was worth $200,000 and he got a 1/4 interest, then he might be getting more than where he might have gotten 100% of a house that was only worth $40,000. But in each one of them, he did range anywhere from 1/4 to 100%.
And when an estate is settled, would the persons conducting that settlement typically obtain appraisals for real estate and personal property so that the estate could be settled and cleared?
In some cases, it's absolutely mandatory. For example, if there's a death tax return due to the federal government, then it's mandatory. You must do that. If there's no death tax return required, then a lot of law firms, depending on the size of the estate, will either go out and hire an independent appraiser, or they might go out and get appraisers for things that they might not be familiar with, like artwork, antiques. But the general rule is most estate planning firms, when they're dealing with estates of this size, would probably consider doing something like that. The estate pays for it, so and it's a good way of being able to determine what the value of the assets are for several reasons: current taxation, as well as taxation down the road when the asset's sold.
Yes, sir. I have just a moment, Your Honor, please. We have no other questions of the witness at this point.
Thank you, Your Honor. Good afternoon. My name is Tom Maher. I represent Mr. Peterson along with Mr. Rudolph. Let me ask you, when were you first contacted by the state to do work in this matter?
Objections
I would say it would have been last week sometime, maybe Wednesday is the best recollection I have. It would have been, I can tell you this, it would have been the same day. I think there was an SBI agent that testified, and I remember reading about that in the newspaper, and that was the same afternoon that the district attorney called me. So I'm guessing that would have been the middle of last week.
So nobody had even asked you about how intestate succession would affect any of these assets until this SBI agent had already at least begun his testimony.
Well, again, the first time I had any real awareness of the case or what was going on was last week, about midweek. And again, the district attorney just asked me if I could come to court and explain to the jury the laws of intestacy and how various types of property would be divided up.
Okay, but did he also ask you that, tell you that he was going to show you an insurance form and ask you about personal property insurance and how property is treated under insurance contracts?
No, as a matter of fact, he didn't do that. The way that came about is, as I was going through the files, what the district attorney asked me to do is to give the jury some idea of how we might divide up $700,000. They actually gave me a figure of $720,000. And when he gave me that figure, I just thought to myself, I just thought it was a little bit high. I may have mentioned that. I didn't say anything more about it. As I was going through the file, I found the insurance document in there. And that's when I asked the district attorney whether or not that is where he got the figure from. And when he came back and said that's where we assumed that there were $719,000, I told him that you can't rely on that. And that figure does not indicate the amount of property that is insured under the policy. That's just simply what we call the 70% figure. And it could be significantly less than that.
Okay, and let me ask at that point then, did you ask whether the state had access to any information about what personal property was actually located at 1810 Cedar Street?
Yes, I did. The response I got was that obviously there was personal property there. The question I specifically asked is, had anybody been out to appraise that? Because normally that's what would happen. And at that time I was told apparently the police have got the place closed, or people can't get in there to do that. So, apparently you just can't get in there to to look at those assets.
But somebody from the state indicated that it was physically impossible to do an appraisal of the personal property?
No, I think in talking with the district attorney, I kind of got the impression that from the time the decedent died, right up until a short while ago, that the ability to get in there and to do things might have been curtailed by the fact that the police were trying to limit maybe access to the building or what have you.
Were you given to understand that the police had unfettered access to that for several days after Kathleen Peterson's death?
I have no idea what the police did. The only thing that I'm aware of is I got the impression that people couldn't just walk in there and do an appraisal if that's what they wanted to do.
Now, was it your understanding that I'm trying to understand that the police were restricting access to this house until fairly recently?
No, it would have been restricted at the time that you would normally do an inventory. You have a 90-day inventory. You have a preliminary inventory that's due when you actually file your application for letters of administration. They're usually within a few weeks of death. The 90-day inventory is 90 days after death. And so apparently during that period of time, it's my understanding that people could not move in and out of the house and get a gauge of what those assets were.
Somebody from the state suggested to you that during the period a 90-day inventory was supposed to be prepared, that there wasn't the ability to get into the house and look at them?
When I looked at the estate file, I noticed from the estate file that the inventory seemed to be rather incomplete and it was a very small figure. We're talking about $1 million house with assets listed in the house, which was a very small figure. It might have been $40,000 as I recall. And I thought that was kind of unusual. So I just simply asked a question and I kind of got the impression that maybe that's why a complete inventory had not been done.
Well, the person who is responsible for making sure things like inventories is done is whoever is a representative of the estate, correct?
Well, not really. In actuality, it's going to be the law firm that is representing that person. Very, very few people that are administrators or executors would ever do anything that is done to administer an estate. It's the law firm that they hire.
The law firm acts as their agent in essence, in helping them fulfill their obligations, correct?
That's correct.
And in making sure that their powers that they have are properly exercised.
They should do that. That's correct.
And the person who was the administrator and is the administrator of the estate in this case is Caitlin Atwater.
That's my understanding.
And she's represented by a law firm.
That's correct.
And so if they want to be able to gain access to the house to get an inventory, they can do that, correct?
Assuming generally that's true. If for some reason or other they can't get in the house, then they can't. I don't know if the police say they don't want people in there, then they obviously would not be able to get in there.
Well, I mean, if the police have released the house and Caitlin Atwater through her law firm wants to get an inventory, she can do that,
yeah,
correct?
If that's the case, if they had released the house and there was no restrictions on it, they could certainly get into the house and do an inventory if they wanted to.
And in fact, it's not just that they can, the administrator has an obligation to do certain things, such as take an inventory of personal property.
I think that's certainly one thing they would want to do.
Well, it's not just want to do, they have to do it, don't they? And now, you mentioned early on about how, if I may approach, the administrator or representative is selected and how typically it would be the spouse of the deceased. Is that what I heard you say earlier?
It would typically be the spouse, yes.
And the spouse, of course, is Michael Peterson.
That's correct.
Okay, now, it wasn't that he didn't qualify as administrator, was it?
Well, he could certainly qualify. There would be no reason. In other words, the day after Mrs. Peterson died, there would be no reason at all that Mr. Peterson couldn't qualify as the administrator of the estate.
In fact, what he did was he signed a renunciation of his right, didn't he?
This was done in January of 2002, which was, I believe, shortly after death. And it appears that he did sign a renunciation form to appoint another individual. And I don't know that I can, well, let's see. It was witnessed, and then Caitlin Atwater was then substituted in.
Right. In fact, the date that this was signed was 12/31 of 01, correct?
That's correct.
And what happened then was that Michael Peterson nominated Caitlin Atwater and gave up any right he'd have to be administrator.
He did sign a renunciation indicating that he would not go forward being the administrator, and he did appoint Kathleen. The reason for that I do not know, but that is what happened.
And then she became the person acting either on her own or through a law firm who had the power and the duty to do things like get inventories.
That's correct.
And you didn't see any sign that a complete inventory had been done within 90 days, did you?
You wouldn't necessarily have a complete inventory done within 90 days. You would have an inventory that was probably more complete than an inventory that was done with the preliminary application, certainly.
And in talking to the state about this insurance policy, did you ask, well, do you have any photographs that would at least show the types of items that may be in this house?
When you're seeing insurance policy, which one are we talking about? We're talking about the USAA HO2 policy.
Right, the one with the $700,000 figure on it.
Yes. When I got that, I asked, do you have the rest of the policy? If you do, that would help me determine whether or not there are any riders, any additional coverage. It would also give me some idea of whether or not other things were insured. And the response I got is that the district attorney's office did not have the rest of the policy. And I don't know if anybody who would have it, but he did not have it.
And did you ask that they inquire of Mr. Peterson whether he had the rest of the policy?
No, I did not ask that.
It was clear. Let me approach if I may. Do you have that one page up there? I'm sorry, Mr. Hart may have it right there. This right here. Defendant's Exhibit 44. You assume that there was more to that policy than that one page?
This is the declaration page. The remaining portion of the policy would consist of two things. It would consist of the master policy, which is virtually identical for everybody in North Carolina. It's controlled by the insurance commissioner's office. And then attached to that would be individual riders for individual assets that somebody may have owned.
And I'm letting the state look at it real briefly, then I'll approach with the document. Yeah, I'm sorry, I did. Your Honor, while Mr. Hart's looking at that, I don't think I put on the record the renunciation that I showed the witness is Exhibit 108, and I would move that into evidence. And while Ms. Hart's looking at that, if we could not take this scheme. Okay, in this, if we can exhibit this to the jury through the screen. This is the form that I showed you that Mr. Peterson signed back on the 31st of December.
That's correct.
Okay, and there's two different boxes that one can check. The first one says that the person simply renounces their right to qualify as executor. And then there's a second box where they renounce their right and that they respectfully ask that some other nominee be the administrator of the estate, correct?
There are two boxes that are checked for different reasons, yes.
And so in this case, what this form does is both renounce Mr. Peterson's right and respectfully request that Caitlin Atwater become the representative for the estate.
Well, not exactly. There's not an option. You can't pick one or the other. The first one deals with a testate estate. If you'll notice, it's talking about the right to qualify as an executor, which would only have the testate estate. The second one deals with being an administrator, which is only with an intestate estate. North Carolina is a little bit unusual in that if a will is involved and you check the first block, technically in North Carolina, the executor may not name a substitute. If you check the second box in an intestate situation, which is what this was, then you have the right, if you want to name a substitute administrator. In this case, Caitlin Atwater was nominated as the substitute.
But that, as I understand what you said, that box where he nominates Caitlin could have just been left blank.
If she were left blank, the clerk would not accept it without plugging somebody in there. So someone would be plugged in there, certainly.
Now, let me approach and hand you Mr. Marcus Defendant's Exhibit 109 and ask if this appears to be more of the documents that go with the Defendant's Exhibit 44 that you were shown earlier.
Yes, it looks as though it's the exact same document. It's got some basic cover sheets on it. It has the declaration page, which we've testified about, and then it does have some additional documents on here that would pertain to different coverages and for these properties.
And this was, in essence, at least some of the document that you had asked the state whether you could have access to, and they indicated they didn't have it.
When I got the cover sheet, I just asked if anybody knew where the remaining portion of the policy was, and at that time, I think it was somebody had just made the statement that they did not know if they had it or not.
Okay, now let me turn to the personal property replacement cost page as an endorsement. And does this page, for example, set out for different types of property the type of coverage that is given?
No. What it does is it just indicates that you're going to have coverage under what we call replacement cost rather than what we call ACV or actual cash value, which is something slightly different. You pay a rider, an additional premium to get this type of coverage.
Okay. And certain property, you get replacement cost, and certain property, you don't get replacement cost, you get the actual cash value or repair cost.
That's correct.
So what I was asking, maybe I didn't make it clear, is what this sets out is categories of property and how they will be treated if there's a loss.
Exactly.
Okay, so for example, jewelry, you would get replacement cost.
Up to the limit of the policy, which is very, very small, but you're right. Yeah.
And same for furs and garments,
yes,
things like that. For other property that's not eligible for this replacement cost, what you get is the actual cash value, or I guess there's a cost of repair if it's something that can be repaired.
No. If the property is not eligible for replacement cost, then it would be eligible for either replacement or ACV if there's an additional premium paid and additional rider. They're listing the various things I mentioned this morning that are not covered in the HO2 policy: artwork, antiques, paintings, collections, etc. Unless these are separately scheduled on a separate premium paid, they would not be covered under any circumstances.
What we're pointing to is, for example, antiques, fine arts, paintings. Under this, if they're covered at actual cash value.
I believe they would be, yes.
Okay.
If they're covered.
Correct.
They would only be covered for ACV. That's correct.
Okay. Now, you weren't provided any further information.
Objection, ambiguous question.
I don't think I finished my question. So it probably is ambiguous. You were not provided any further documentation about insurance. And you, of course, have never actually been to the house yourself.
I've never been to the house.
But you're not assuming from the insurance document that you had that there were no valuable antiques or art or furnishing, were you?
No, I would expect from the value of this house, it would not surprise me at all that there would indeed be artwork or antiques. That would not surprise me at all.
And in fact, you'd have to look at the types of things there to see how much of up to or over or under the $700,000 figure there would be for items in the house.
Well, that would be correct, except for the fact that this coverage here, again, would not cover antiques and artwork. It would cover basic property.
Okay, but of course, insurance coverage has nothing to do with how things are divided for intestate succession, does it?
Generally, no.
So, for example, if Kathleen Peterson owned an expensive antique that was not properly insured, it goes into the estate, correct?
It would go into the estate. That's
right.
correct.
And if Michael Peterson owned valuable art that wasn't properly insured, it would be his personal property and would not go into the estate.
That's correct.
So in terms of what effect the death of Kathleen Peterson would have on Mr. Peterson's ability to continue to enjoy art or furniture in the house, whether it's properly insured is not controlled.
That's true. It can be totally uninsured. It would not impact how we divide the property up.
Okay. And in fact, did the state indicate to you that they had taken numerous pictures inside the house, both in December of 2001 and then back in June of 2002?
They did not specifically tell me that they had taken pictures.
Okay. Well, let me go through some. And what I'd like to do, you have the... Your Honor, what we have here, I'm going to project, we were provided a number of photographs in digital format by the state. We selected a few of them, and we've got a DVD and a CD that we'll mark in a moment and leave it as an exhibit so that it's actually in the court record. But what I want to show you, sir, is a number of photographs from inside the house and see if they're the type. Here, I can mark this as defense exhibit 110. I'll keep this with the clerk so there's a record of the picture. What I'd like to do is show these up here and go through with the witness the various items and see if they're the types of things that would be potentially affected by the death of Kathleen Peterson. If we could project this first picture up. Now, I'll represent to you that this is the living room in 1810 Cedar Street. Have you ever seen any pictures?
Have not.
Did the state volunteer to you that they in fact had pictures showing property in the house?
They did not mention that. No.
Okay, and they didn't mention, for example, that they'd taken a videotape of the house.
I was not aware of the videotape.
Okay. If you were handling an estate for Kathleen Peterson, would you be interested in finding out the ownership and value of various items that were located in the house?
Typically, what we would do is send out an independent appraiser. If we knew there were antiques and artwork, we would get a specialist in that area and have them go in and do an inventory. Certainly.
Okay, so for example, you don't have any idea of what that item is or whether it's worth anything, correct?
Haven't the slightest idea.
But let me approach, if I may, mark this as Exhibit 111. If I may approach with Exhibit 111, to your knowledge, when an appraiser tries to set out to determine the value of something that may be unique, like art or jewelry, I take it they'd be interested in who created it, the provenance, so to speak, of the piece, in helping determine its value.
That would be my guess.
Okay, so for example, on a piece like that, to determine whether it's worth something, you'd want to know who created it, because that would affect its market value.
That would be correct.
Okay, so for example, they might, if they knew it was by, and I'm going to mispronounce his name, Pino Signoretto, and that there was in fact catalog information about the item. Let me hand you Exhibit 111. Does that piece at least appear to be the same piece that's reflected up in the photograph in the Peterson house?
Okay, it appears to me that it easily could be. Again, it's very, very difficult to tell, but I'll take your word for it. That's one and the same.
Okay, so an appraiser, for example, then seeing that that piece is there would go and do what research they needed to determine who created it and what value it is.
Certainly.
And certainly unique art created by artists with a reputation can be worth a fair amount of money.
I've seen pieces of art done by famous artists that are not incredibly expensive. I've seen pieces of artwork by individuals that no one has ever heard their name for that would be staggering in price. So
it can be worth a whole range.
Certainly.
And certainly even a single piece of art like that could be worth thousands of dollars.
Could be.
Or more.
Could be.
Now, of course, in addition, furniture can be valuable, correct? Not all furniture comes from IKEA or so, for example, you would want, if you were handling an estate, to know what an item like that is worth, whether that's an antique worth money or whether it's just a piece of furniture, correct?
That would be true.
Same with this item, correct?
That's correct.
And for example, over here, we have a vase and we have what appears to be an oriental piece of furniture, correct?
Correct.
And these are all pieces of furniture, depending upon who owned them, that would be part of an estate or not.
That's correct.
Okay, if we could go to that. Now, for example, a rug too, if it had value, would be part of the estate.
Which item, please?
The rug. We have an oriental rug down here.
Okay.
Or even some chess sets, for example,
sure,
are just for playing, and some, in fact, are collector pieces, correct?
That's correct.
Okay. If we could go on to the next. Now, we have here another shot. Once again, you've got another, I'm sorry. Oriental rug shown in the picture. Once again, you'd need to know the value of that in evaluating an estate, correct?
That's correct.
You've got what appears to be potentially antique furniture with ceramic plates on the top. Once again, something that would need to be inventoried and valued, correct?
Well, regardless of whether it's antique or not, you'd want to go in and do an inventory. The inventory will tell you whether it's an antique or not. But if it is, then what you're saying is correct about how you would value it.
Same with, a vase or another piece of furniture. If that was antique, you might need an appraiser for it before you had any idea of what it was worth, correct? Okay, the same thing, of course, applies for artwork. If that's part of the estate?
That's correct. It would be part of the estate. What its value would be, I would have no idea.
Well, when you say it'd be part of the estate, if those were owned solely by Michael Peterson, then they wouldn't go through the estate.
They would not be.
Okay. And the reason for that, let me just touch on briefly, is because he already owned them, correct?
That's correct.
So he's not getting them. He's just being allowed to keep what was already his.
That's correct.
Okay. And if Kathleen Peterson was the owner of these various items, what would happen is they'd become the property. They'd go through the estate, correct?
That's correct.
And they might, in fact, be sold to pay claims.
They could.
In addition, of course, the administrator decides whether to sell pieces of property, correct?
That's correct.
So if Michael Peterson, prior to Kathleen Peterson's death, was living...
But how do you know? Like, this is something I wonder about because I got married later in life. So I have a lot of stuff that I've had for years and years and years before I met Travis. Nothing worth a lot of money or anything like that, I don't think. But if he was to die or I was to die, like, who would know what was his and what was mine? And this house is mine. I inherited it from my dad. It's in my name. Who's going to know? He's going to keep living here and all my stuff is going to be in this house. Like, how does that work? I imagine with them having kids, though, the kids would maybe know what was dad's and what was mom's. But in our case, you know what I mean? Like, how do they figure out what is part of her estate and what a part of his estate? Like, that's not something that you think about when you're young and you get married. Like, because everything is yours together. But when you're married later in life, you have stuff that's just the husband's or the wife's. Unless you, like, actually have a document that's inventoried your stuff, like, which reminds me of my mom's, not at the funeral, but, when the family was gathering at the house, my aunts were, like, looking at stuff that my grandmother had given my mom or made for my mom and was arguing over who was going to get it. And so I'm just sitting there watching them thinking, y'all aren't getting that. That's mine. So, like, how do they figure that if you don't have a document that says who's, what is whose, how do they know? Like, how are they going to know? My biggest fear is if I was to die first, I guess we need to do a will. I don't know how much it costs. We have no money for lawyers, but I think you can do it online now, though. But we need to do a will because if anything happens to me, I don't want Travis to end up homeless. And he's not on. I guess I could just put him on the deed to the house because he's not on it.
In this house, enjoying the artwork, using the furniture, and it was Kathleen's. Upon her death, now that property is subject to claims and the obligations of the estate. Isn't that correct?
It's possible, but not absolute. Not every asset is going to be subject to the claims of creditors. If you have an estate that is worth $500,000 and you only owe $100,000, then there's going to be an awful lot that's not subject to the claims of creditors.
Right, but then the remainder goes to the people who take under intestate succession. Correct?
That's correct.
And in this case, what we have is Michael Peterson and Caitlin Atwood, correct?
That's correct.
And just so we're clear, when we talk about children who take under intestate succession, we're talking about natural children,
Not
aren't we?
expensive at all.
Yes.
Okay, so for example, if there were stepsons or daughters who Kathleen loved and helped raise and take care of, if there's no will, they take nothing under intestate succession, correct?
The general rule is stepchildren would be treated as strangers and would not share in the estate of the decedent.
Okay, so what we're talking about here, because there are different rules if you have more children than one.
Certainly.
It's this 50% rule applies when you've got, in this case, a natural child and a spouse.
That's correct.
And you did a bunch of different calculations, but the calculation is always fairly simple. You subtract $30,000 and divide in half, correct?
That's correct.
But when you say that, for example, if Kathleen Peterson owned $700,000 worth of property, that Michael Peterson would get $30,000 plus half of the remaining $670,000, well, that's stuff that was already in the house, correct?
That's correct.
And the remainder now goes to the estate, correct?
Correct.
And so the state can sell things that were in the house or physically take them out, distribute them to the other heir.
Correct.
And of course, there's an expense in getting appraisers in for an intestate succession.
Certainly the appraisers are going to charge something for doing that.
And the attorneys don't work for free, do they?
I don't think so.
No. And in fact, I think you mentioned in your direct examination that intestate succession is often more expensive than a will.
In many cases it is.
Right. Now, is it typical for married couples when they have a will to generally provide that the bulk of the estate goes to the other spouse upon their death?
It is in a single situation. That's where you have a marriage that is what we term a first or primary marriage. In other words, the two individuals have never been married before. You'd be correct in that case.
So, but regardless of the wishes of the deceased spouse, in intestate succession, the legislature determines where things go.
That's correct.
Now let's go on to the next picture. This, once again, would appear to be an item that is potentially an antique or valuable piece of furniture. Once again, that a determination would have to be made whether that was part of the estate and what value it had.
Both those determinations would have to be made. The first determination is what is its value, and then the value really becomes immaterial if we determine that it's not part of the estate. If it belongs to someone else, for example, if you've borrowed a piece of property from a neighbor, regardless of its value, it's not part of the estate, so it becomes immaterial.
Okay.
But,
But items, for example, here, you don't know whether that's a potentially valuable piece of art created by an important artist or just a piece of glass sculpture, correct?
We not only don't know that, we don't know who owned it. It could be the husband, the wife, it could be on loan, it could belong to a friend. We just simply don't know that.
And if Michael Peterson owned it, he didn't gain it by Kathleen's death because he already owned it, correct?
That's correct.
If Kathleen owned it, now that has to go through the estate, and the estate will determine whether it's sold or where it goes, and it may, in fact, no longer be in the house, correct?
It's possible. It's not likely. Typically what's done with antiques and artwork is if there are debts owed in a decedent's estate, they're usually paid with liquid assets such as bank accounts and things such as that. Artwork is very rarely liquidated to pay debts.
But it is divided up among the heirs.
Yes.
Okay, so assuming that debts were paid without getting into selling things like art or antiques, roughly 50% of the property, I realize the first $30,000 stays with Mr. Peterson, but 50% of everything after that goes to the other heir, in this case, Caitlin Atwood, correct?
That's correct.
And she would have the absolute right to take these things, they'd have to apportion them somehow.
That's correct.
But then take her roughly 50% and do with it as she wishes.
Yes, but the one thing you're missing is that once the division is made 50-50, the surviving spouse then has assets that are now his, and you can take them out and sell them, give them away. You now have an ownership interest, whereas before you only had the right to enjoy it. So there is a difference.
So for example, if you were sitting on a nice couch looking at nice art, you have the absolute right to enjoy that as long as your wife is alive and that she's willing to leave the material in the house. But if she dies, some of that is going to be taken out of the house, correct?
Some of it will be taken out of the house, but what's left and what passes to the surviving spouse would then be an asset that they would have an ownership interest in.
Right, and it was an asset that they had an enjoyment interest in before.
Prior to that, an enjoyment interest, that's
right,
correct.
And of course, if they already owned it, it was already theirs to begin with.
That's correct.
Okay, let's take a look at the next picture. Now here, for example, you'd want to know, sorry. With this item, whether that was a valuable antique and whether these pieces were valuable, correct?
Those items and probably every item in the house, somebody would want to look at and do an appraisal on. There's no question to find out whether or not they're valuable or not. But at the same time, we want to find out if they belong to the decedent or not. If they didn't, then the value again becomes.
If I had a house that big, I wouldn't have weird things like this looks like a crystal ball. What the heck? I'd have Star Wars stuff all over my house, which probably would not be valuable now, but would be valuable years from now. If and a lot of my stuff is still in the box and like mint condition. So what is part of the handrail missing from the stairs right there? That's weird.
Immaterial.
Right, because once again, those are simply things that Michael Peterson or whoever already owned. That's correct?
Mm-hmm.
And let me approach, in terms of the types of items that might be there.
Yeah. Get the suit off standing or in my chat. I'm down to
Let me
3.
approach with the group exhibit, which I've labeled as Exhibit 112, and ask, and I realize you haven't seen these documents before, but if you were handling an estate, whether you would want to know information such as reflected in these, that an item, for example, might be over 100 years old, and the dates that antiques, for example, dated from.
Yeah, certainly, I would want to know some information about it, and we would probably rely on an independent appraiser, somebody that had some knowledge in this area that could give a value. But again, having done enough of this, the mere fact that a Chinese artifact is 100 years old, again, does not mean that it has a significant value. On the other hand, it could have a significant value.
And you certainly wouldn't just pass that item on without taking a look and determining whether it had significant value.
Yeah, unless you had the expertise, you'd want to talk with an independent appraiser, certainly.
Let's go on to the next. Now, this picture, I'll just do this briefly, is another view of the same room closer. Once again, items such as these, you'd want to determine whether they had value and who owned them, correct?
Yes, as would any item in that room.
Now, let me ask you, if items that we've been talking about here had value and they were acquired during the marriage by both Michael and Kathleen Peterson, are they then treated as jointly owned in terms of the estate?
Generally, what you're supposed to do is if you have evidence that the asset was jointly purchased, then you would want to treat it as a joint asset. Half would be owned by each, and only half of it would be in the estate. We'll tell you, as a matter of practice, sometimes that's not done for tax reasons.
But under the rules of the estate, and this would be more important for a valuable item than a non-valuable item, if Michael and Kathleen bought a valuable piece of art or a valuable piece of furniture together, and they jointly were able to enjoy it during their life, upon her death, her half is part of the estate, and then half of that, once other things are met, goes on to the other heir.
That's correct.
And of course, if you could either end up divvying up some of the property, or if necessary, even selling property if an agreement couldn't be reached about how property would otherwise be divided.
Well, on balance, it cuts the other way also. There would be several assets that he may only have a 0.75% interest in or a 0.75% interest in, and those assets would be given up so he'd get the entire thing. As you mentioned a minute ago, you allocate this stuff. So in some cases, the ownership interest will go up in some assets, down in others.
And of course, you allocate it if you can reach an agreement, correct?
That's correct.
But ultimately, the administrator has some powers in deciding what the value of an item is and how distributions can be made when there's a contest over a given item.
They have the statutory power to determine distribution. They don't have the power to determine value. They have to get somebody that knows something about the assets to do that. They can't do that themselves unless they have that expertise.
Right, but in terms of if no agreement can be reached as to how a given item is distributed, it's the administrator that has the ultimate power as to how it's distributed.
No, that's correct.
Okay, so Caitlin Atwater, in essence, would have the power to decide, given the values, how assets were going to be distributed between herself and Mr. Peterson pursuant to the division.
She could not do it in any way that would appear that she was benefiting herself over someone else. In other words, you couldn't say, I'll keep the good artwork that's going to appreciate in value and give you the artwork that's not. So as long as it was done fairly, and typically when you're talking about expensive pieces of artwork and antiques, it usually results in a hearing before the clerk, and the clerk will get involved in it if there's any possibility that the allocation would not be equitable.
Right, but if you've got two valuable pieces of art, well, let's just assume you agree that they're both roughly equally valuable.
Yeah.
The administrator gets to decide which piece of art goes where in terms of the ultimate distribution.
Well, if they're identical in value, it wouldn't make any difference. So one piece would go to Mr. Peterson, and one piece would go to the other beneficiary.
Of course, property sometimes says value beyond monetary value, correct?
Well, and that would be very difficult to get by the probate clerk.
Well, I'm saying, for example, if Mr. Peterson had a sentimental attachment to a particular piece of property, that doesn't give him an absolute right to insist upon getting that piece of property.
It would not.
Let's go on to the next. Now, once again, you've got items such as this clock and the vase, this item here, all of which would have to be the same determination, have to be made who owned it. And if Kathleen Peterson had an ownership interest of whatever percent, then what value would have to be determined.
That's correct.
Okay. And for example, this item here, which you can't see clearly, or these, same thing would have to be done. Correct?
That's correct.
Okay, let's go on to the next one. Now here, for example, we have what appear to be a series of, they look to be Oriental artwork on top of this table. Same analysis would have to be done. Somebody would have to come in essence, catalog them, determine who owned them, determine their value, and all that would need to be done before these calculations that you went through in front of the jury would actually have any real meaning.
Not necessarily. We would certainly want to have values so we can determine what debts needed to be paid and what would be left over to give to beneficiaries. But in order to determine what the laws of intestacy do as far as dividing up an asset, you do not need to know its value. You can do it on a percentage or a fractional basis.
But in determining what that fraction equates to in terms of monetary value, what I've discussed would have to be done.
The monetary value will always change. The percentage or the fraction will never change.
Right. And once you get to the 30,000 level, in this case, it's always going to be 50-50.
Exactly.
The real question is, what 50-50 of what?
That's correct.
Okay. And these are the types of items you'd have to go to the next one. You have to, in essence, catalog and evaluate to determine the pie we're talking about. Well, I'm going to, and so the same thing would take place for pieces of art or other items that might be in the house, correct?
As I testified before, anything in the house, whether it's art, antiques, a chair, we don't know if it's artwork or antiques, but everything in the house would have to be valued by somebody that would have some knowledge as to its value, certainly.
I'm not going to go through every room, but we've looked at, I think, what was the living room, and we moved into the dining room. Did anybody show you, for example, pull it out. Hold it up here. Did anybody show you that E1, the diagram of the residence?
I don't believe I've ever seen that before.
Although you were aware that it was a valuable house,
Oh, no question.
you weren't aware of the various rooms that were in the house?
No.
And presumably, you'd have to go through all of these rooms, looking at items like this, making the same determination, who owns it, what's the value, and that would either put it into the estate or not.
That's correct.
And I'm not going to, you had a flip chart where you were doing some calculations about what Michael Peterson would get, assuming we had a $700,000 pot. And depending upon, of course, if he started off owning all of it, he's where he started, owning all of it, correct?
Correct.
If Kathleen owned all of this, he gets to keep slightly more than 50% of the value of those items, correct?
That's correct.
And the other items which had been in the house he was living in and able to use could be carted off and distributed to the other heirs.
If you're talking about the share that did not pass to him, it would pass to the other heir in this case, which I believe was Caitlin, yes.
Right, so that property equal to that value, in essence, she would have an absolute right to take out of the house and do with as she pleased.
That's correct.
So while his ownership interest in what remained may have changed, the amount that's in the house has been reduced.
Well, again, I think it's significant to understand the difference between an enjoyment interest and an ownership interest. Some people would rather own half of something than have a non-ownership enjoyment interest in all of it. And some people maybe vice versa, but there is a distinction.
Right, but his ability, for example, to use furniture if it's removed is ended, or to enjoy art that's on the wall if it's removed, that ends, correct?
Some of it.
Right, and what? Okay. Now, I'm going to switch to another topic in a moment. If we want to take, I don't know if we want to take a short break at this point and organize the documents and switch over.
Well, actually, I need to talk to you all so we can figure out something. All right, Mr. Maher, what did you ask me before you approached me?
Suggesting that if we wanted to take our short afternoon break at this point, I'd be switching to a new topic.
We'll do that. Members of the jury, let's take a 10-minute break. Remember the instructions I've given you. I'll see you in 10 minutes.
Now, I want to shift in a moment to real estate, but I want to make sure we all understand what the difference is between how real estate is treated for intestate succession and personal property, if I could. And while I'm doing that, let me get a flip chart that dealt with real estate. Real estate that Kathleen Peterson had an ownership in goes through the estate unless it's what's called entirety of property, correct?
Correct.
Okay, we'll talk about that in a moment. All of the real estate that goes to the estate is divvied up 50-50 when you have two heirs in this situation, correct?
Correct.
The difference between that and personal property is that when there's personal property, the surviving spouse gets the first $30,000, and then we're back to 50-50, correct?
Correct.
So with the exception of that $30,000 amount, basically what happens is half of the value of Kathleen's estate goes to her daughter, and half the value goes to Mr. Peterson.
That's correct.
Well, you can get to some niceties about a year's allowance for a spouse, but ignoring that,
Right.
That's the basic rule here. Now, we start with, let me see if you can see this. You talked about some property that did not go through the estate, and there were three pieces of property that Kathleen Peterson did not have an ownership interest at the time of her death, correct?
That's correct.
Her interest was, had Michael Peterson died first, she had the option of electing a life interest in either the residence or 1/3 of the total of the real estate.
That's correct.
Okay. If she dies first, that 1/3 interest becomes an irrelevancy.
That's true.
It's really only relevant if somebody is considering buying or taking some kind of security interest in one of these pieces of property while she is still alive and while he is still alive.
That's correct.
And what has to happen is she has to consent, correct?
That's correct.
If she signs the piece of paper, then he could sell the property or get a mortgage on it.
She would have to either sign the deed or sign the mortgage, one of the two, but that would waive her elective life estate.
And are you aware that in March of 2001 that she in fact signed in a refinancing of 1810 Cedar Street?
She may have. I'm not aware of it. It would not surprise me if it were a small loan or a refinancing. She could have very well signed.
And you're not aware of any evidence that's been presented to you that Kathleen Peterson was telling Michael Peterson that he couldn't sell one of these pieces of property or take a mortgage out?
No.
Okay, let's talk briefly, and I won't go through each of the calculations. You also did some calculations of percentages of property that Kathleen Peterson had an ownership interest that was not tenancies by the entirety.
Correct.
And that, if I'm counting correctly, was 5 pieces of property?
I don't think it was 5.
We've got 1910 Ward.
That's 1.
I'm sorry, Huron, let's talk about that briefly. Huron was tenancies by the entirety, correct?
That's correct.
And what that means is, in essence, they both own the entire piece of property, so when one dies, the other is left with this 100% interest in the property.
That's correct.
And it's a common form of ownership for husbands and wives because of that benefit. Correct?
That's correct.
But there was a piece of property that, although they were husband and wife, was titled tenancies in common.
I think there was one piece of property. I can't remember which one it was.
And you may be right that it's. I think you got it as 1910 Ward.
I think you're correct.
With regard to the address, this one, they didn't have that type of ownership.
That's correct.
So when she died, her half interest goes into the estate. And in that respect, is absolutely the same as the remainder of the other properties. In each case, she had a 1/2 interest as tenants in common. When she died, that interest went into the estate.
All the tenants in common would be treated the same way, yes.
And what that is, because it's just a 50-50 division, her half goes into the estate, half of that goes to one heir, the remaining half goes to Mr. Peterson.
That's correct.
Okay, and by the way, let me show you what Mark is Exhibit 113. Let me show you what I'm marking as Defendant's Exhibit 113 and ask if you, in looking through the estate file, seen that recently appraisals were filed as well as this document which lists what they calculate to be Kathleen Peterson's 1/2 interest in the various pieces of property.
I have seen this document before, and it was in the estate file. I remember seeing it and reviewing it.
Okay, and what it shows, I can approach and just point out, it's a list 4 different pieces of property in which Kathleen Peterson had an ownership interest that was going to the estate. Is that correct?
That's correct.
And the values are actually her half interest, not the total value.
That's correct.
And the total value of her 1/2 interest in those 4 pieces of property was, this is a round figure, but $149,000.
That's correct.
And assuming that that figure is correct, what happens is roughly $75,000 worth of that value goes to Caitlin Outlet.
That's correct.
And if property then would need to be sold or divvied up to satisfy that obligation of the estate, correct?
If there were debts that couldn't be satisfied with personal property or other assets, it's not unusual to see real estate sold to pay debts.
And once again, the administrator would have the power, unless there was an agreement reached, to decide which pieces of property to sell and ultimately make decisions as to what the fair value of those property was, correct?
Well, I don't know that she would have the decision as to the fair value. That'd have to be done by appraisal. She would have the right to select which assets were sold.
Okay, so for example, she would have the power to sell any of that real estate in which Kathleen Peterson had an interest, and then to distribute the proceeds according to the rules of intestate succession.
Yeah, but if that money was used to pay debts, then each of the beneficiaries, the husband and the daughter, would share equally in that economic loss in paying the debt.
Right. So, for example, obviously the mortgage would have to be satisfied.
That's correct.
But the numbers there are net value.
I believe they are. They're usually net values without reference to the mortgage.
Correct. And the estate, obviously, if there are outstanding debts to the estate or claims, those have to be satisfied, correct?
That would be correct.
And it's the amount left afterwards that gets distributed.
That's correct.
And the person who has at least some power in deciding how things are either sold or distributed is the administrator of the estate.
Again, as I testified, the administrator has the initial ability to select that property that's going to be distributed. However, if it appears that the property that's been selected is in any way unfair or biased, then any other interested party can go to the clerk's office and request a hearing on the distribution.
But they would in essence have to challenge this decision and go through having a hearing to have their viewpoint heard.
That's correct.
And of course, if there's two pieces of property which are of basically equal value, the clerk isn't going to get involved in telling the administrator who gets which piece of property.
If they're of equal value and there's nothing unusual between the two of them, then I don't know that the clerk would get involved.
And in that situation, the administrator gets to decide which heir gets which piece of property, or if the property has to be sold for some reason.
Which piece of property would be sold, that's correct.
And Caitlin Atwater has that power in this case.
She would have the power. Again, you've got to realize that most people that are administrators or executors of estates turn these things over to their attorney. So to say that she has the absolute power, I would imagine what she does is simply say to the law firm that's handling the estate, do whatever's necessary to close it out.
Right. But lawyers generally don't decide between two equal pieces of art, for example, or furniture, who would like one piece better than the other. That's not illegal.
I don't think they would do that. They would probably consult with the personal representative. Again, attorneys are very sensitive to the fact that if the property is not of equal value, if there's something that makes it unequal, its location, the fact that you can have two pieces of property that are nearly identical, depending on where they're located in a city. One is obviously an area where the value can go up, and one's in an area where the value goes down. If you're in that situation, then for the administrator to say, I'll take the piece of property that's going to go up, you take the piece of property that's going to go down, that one's going to wind up in front of the clerk.
Okay, but let me follow up on that moment. An administrator, in addition to having certain powers, has obligations as well, correct?
There's certain obligations to being an administrator.
They, in fact, are acting as a fiduciary.
That's correct.
So they can't take items that should go through the estate, such as jewelry, and just keep them for themselves.
That would be very unusual. I have seen situations where administrators are aware of the fact that they are the beneficiaries of a specific bequest or something like that, and they'll take the asset, which is really not the way to do it. It still should be run through the court, but they ultimately wind up with the asset.
But I'm talking, and I may not have been clear, in an intestate succession, there is no specific bequest.
That's correct.
So they would never be justified in taking jewelry or anything else and just keeping it for themselves without it going through the proper probate process.
It would be unusual. Again, a lot of people that are administrators that are lay people, they're not professionals. Sometimes they don't understand that. And it's very, very common in an estate to have to go back to a lay person that is an administrator or a beneficiary and ask them, did you take this? And if so, return it. And they typically do.
And as we've shown on the exhibit, in December 31st, Michael Peterson renounced his right to seek those powers as an administrator and nominated Caitlin Atwater.
Well, you need to be very careful with that. North Carolina has a statute that sets out who can be a personal representative or an administrator. Our statute in North Carolina gives the top priority to the spouse. If for any reason the spouse does not do it, or can't do it, they're disqualified or they decide not to do it, then we go to the second person on the list. And in this case, it would be the daughter. The daughter cannot qualify unless the person with a higher priority, in this case, Mr. Peterson, would renounce. So it's mandatory that he renounce. It's not something that's voluntary. It's absolutely mandatory. And if he refuses to renounce, then the clerk will simply indicate that there's been an implied renunciation and go forward with the appointment.
Sir, if Michael Peterson met the qualifications to be the administrator of the estate, he's not required to renounce that, is he?
He's not required to, no.
And unless he renounces it because he's first in line, Caitlin Atwater would not become the representative of the estate, correct?
That's correct.
So he renounced in December and nominated Miss Atwater, who otherwise would have been second in line, correct?
Well, I have no reason why he chose not to qualify. If he chose for any reason not to qualify and the clerk was looking for somebody to be an administrator, she would have called Mr. Peterson in and asked him to sign that document.
Right, but it was his choice to give up the rights he had to surviving spouse that, in this case, put Caitlin Atwater as representative.
Well, I don't know that. What I do know is he signed the renunciation. How that came about, I do not know.
No further questions.
Yes, I do. May I have that insurance policy, please? Insurance policy. With respect to that last question that Mr. Maher was asking you about, are you aware of the types of reasons why someone would not qualify as an administrator or administratrix?
I'm going to object to the approach.
Yes. Mr. Hubbard, you had an opportunity to look at what is marked as Defendant's Exhibit 109, that being the USA insurance policy. And I think you'd indicated that you did not see any riders own it.
You say Exhibit 1 what?
109.
Okay, I don't have 109. I don't
109.
believe. Okay.
Yes. You'd indicated that there were no riders on that.
I didn't look, but let me just.
I typed all that and I keep trying to type it's so good, but now YouTube thinks I'm spamming the chat and it won't let me type it. But it's really good. All that is just the first episode. I can't wait to watch the rest.
Double check. I did not notice any premiums for any riders. There are a couple of endorsements on here, but again, they're primarily for a replacement value versus actual cash value. It's the policy itself. There is a rider here having to do with rental property that's added to it for an additional premium. They're insuring 4 pieces of rental property, but there's absolutely nothing on here to indicate any personal property has been separately scheduled or insured.
And I think you indicated that, at least with respect to this policy, unusual items like art and expensive jewelry and antiques would not be covered.
They're not covered under the basic HO2, HO3 policy. They've got to be separately scheduled and separately insured,
So
separate premium paid.
So as far as this policy is concerned, regardless of what antiques, expensive jewelry or artwork may or may not be in that home, it doesn't exist, or at least it's not going to be covered, right?
That would be correct.
And in fact, in order to cover those things under an insurance policy like this, you'd have to pay an additional premium for that coverage, wouldn't you?
And have a written schedule, separate schedule for each piece of property. That's correct.
Okay. Now, with respect to what may or may not be in that house as it relates to expensive antiques and artwork and jewelry, we've been talking about what may or may not have been owned by Michael Peterson and Kathleen Peterson, haven't we?
That's correct.
None of this discussion has had anything to do with any artwork or expensive jewelry or antiques that may or may not have been owned by anybody else living in that household, has it?
That is correct.
And those things wouldn't pass through the estate, would they?
They would not.
No other questions?
Very briefly, on the insurance policy, if that didn't cover those items, Michael and Kathleen would have had a problem if there was a fire or a burglary, correct?
I would think that if that property was indeed valuable and if indeed there was a fire or some sort of loss, the insurance company would not cover it. So if those items were very, very valuable, the insurance company would essentially come back and say they fall outside the parameter of our insurance and we're not paying a dime. That's exactly what would happen.
But it would have absolutely no impact on the value of Kathleen Peterson or Michael Peterson's assets in terms of intestate succession.
Well, again, as I testified a moment ago, whether an asset is insured or not has absolutely nothing to do with whether or how it's distributed during intestacy. We're talking about 2 entirely different things.
Thank you. No further questions.
Anything else for Sergeant? All right, sir, you can come down.
Great. Thank you, Your Honor. Appreciate it.
May he be released, please.
Yes.
Yay! We're done with the boring financial stuff.
Name?
Dan George.
And with whom are you employed, sir?
With the City of Durham.
Would you please tell the jury how long you have been employed with either the city or county governments of Durham?
City and the county government since 1993. But that was with 2 years with the county, and the rest of the time being with the city.
Okay. If you would please take a moment and describe what your educational background is and what your experience has been as it relates to specific responsibilities within either city government or county government.
My education background, I was born and raised in Durham, went to grammar school and elementary school and high school in Durham. I started law enforcement in 1972 with Durham County Sheriff's Office as a deputy. I've held several other jobs outside law enforcement since then. I went back in law enforcement in 1993 after a layoff from a major computer company in the Research Triangle.
You're going to have to speak up, please.
Since that time, I was employed back with the county of Durham as a deputy. I was injured and went to work with the county as a dispatcher. And in 96 was employed with the city of Durham as a 911 dispatcher, and in 1998 was hired with the forensic services unit with the Durham City Police Department. My education is, again, with the two times I've been in law enforcement and numerous classes and that I've had and schools that I've had, which have been sponsored by the North Carolina Justice Academy. With the city.
All right. Now, do you have any medical training at all?
I do.
If you would, please describe to the jury what that is and what jobs you've had as it relates to that.
In 1994, I joined a volunteer fire department, and at that time worked building up firefighter 1 and 2 and became a North Carolina emergency medical technician, has maintained both since 1984.
Now, what is your current employment with the city?
Work for the forensic services unit, Durham Police Department, and I'm also a part-time employee with Bethesda Fire Department.
And what do you do with the Bethesda Fire Department?
Firefighter and emergency medical technician.
All right. Now, in particular, with respect to your job with the Forensic Services Unit, please describe exactly what you do and what that unit is all about, if you would, please.
The Forensic Services Unit with the City of Durham, we're paid and hired by the City of Durham through the police department, but we work for every agency within the county that has requested our services. We're responsible for photography, crime scene investigations, which will include anything from break-ins to vehicles, businesses, homes, homicides, rapes, collection and preservation of evidence.
All right. And I think you'd indicated you've been doing that since 1998.
Yes, sir.
Now, let me direct your attention to December the 9th of 2001 and ask whether you were employed with the City of Durham in the Forensic Services Unit during that time period.
Yes, sir, I was.
And exactly what were you doing, and did you have occasion to become involved in a case at 1810 Cedar Street?
Yes, sir, I did.
If you would, please describe for the jury how that came about and what you did.
I was working routine. That was my normal shift to work with the forensic services. And that evening or that morning, I received a call from Communications 911 Center to a Code 5. By Code 5, through Communication Centers, either respiratory arrest or cardiac arrest at 1810 Cedar Street. I responded to the scene of 1810 Cedar Street from police headquarters because that's where our office was located. And you want me to go on from there?
Yeah, if you would, please.
As I arrived at 1810 Cedar Street, I observed, I went in from the Cedar Street side of the residence to a circular driveway, which the back doorway faces Kent Street. As I went up into the circular driveway, I noticed that there were 2 police cars, a fire engine, and an ambulance in the driveway.
And what time, I'm not clear on when you actually received the call.
2:56 in the morning.
Okay. And what time were you able to actually get to the location at 810
I arrived at 3:07, and it's not but just several blocks from the police department headquarters.
Now, if you would please, as you describe how you got there, describe what the surroundings looked like and with whom you came in contact.
The home is located in what's commonly known as Forest Hill subdivision of Durham. The home was a large 2-story home, brick and wood in nature. The first person I came in contact with was a young lady that was standing out in the driveway. In that particular time, I had no idea who this lady was. I later learned that it was one of the neighbors of Mr. Peterson.
Okay, did you have any conversation with her?
I did. I asked because there was no one around. I did ask her as I got out of my automobile. I said, where were the police officers? And they said that they were in the home, that if I knocked on the front door, somebody would answer the door.
Now, at that point, had any crime scene tape been put up to your knowledge?
No, sir.
Did you see any police officers outside in the yard at that point?
I did not.
Did you see any dogs out in the yard at that point?
No, sir, I did not.
If you would, please go ahead and describe what you saw as you approached the residence and then entered the residence.
Well, as I approached the residence, I noticed that the door was locked. Not locked, but the door was closed. I knocked on the door, and there was a voiceman inside, said, "Come in." I walked inside the door, inside the residence, and at that time, I observed 3 firefighters and 2 paramedics. Firefighters, City of Durham paramedics, and Durham County paramedics. I asked where the officers were, and they said that they had been standing in the front hallway guarding the hall, that they knew that.
Excuse me, where were the paramedics and the firefighters?
In the front hallway.
Okay. And what did they indicate to you?
That the officers they thought that one was upstairs and one was in the kitchen.
And what did the firefighters and paramedics indicate to you that they'd been doing?
Well, I asked them what my nature was, and they said, well, there was a victim laying at the bottom of the steps, and not to go northward down the hallway, because that's where the body was.
Okay.
That I should go into the entrance foyer, through the dining room, and into the kitchen to where the officer was.
Okay. And did you do that?
I did.
Go ahead and describe what you saw as you did that.
As I stepped into again, this is close to Christmas time, and the house was being decorated as Christmas. I walked into the entrance foyer, which was a large entrance foyer with a spiral stairway, into a formal dining room and into a kitchen. As I went into the kitchen, Officer Figueroa was standing by the counter, and he was at that time securing the crime scene there. And I asked him
what he was doing. Go ahead and describe what you saw.
He was standing in the kitchen, and I asked him what the nature was, and he said that the body of the victim was around the corner in the stairwell.
Okay. Go ahead and describe what you saw in the kitchen and what you did after you made those observations.
Okay. As I walked around towards the west side of the wall that leads back down the hallway, I observed a white female in a semi-supine seated position in the floor with her head back, and she was completely covered with what appeared to be blood.
Now, exactly where was Officer Figueroa at that point?
He was in the kitchen, in front of a cabinet there at an out-jutted counter for the kitchen.
Okay, and did he indicate to you what he was doing?
He just said he was securing the scene.
Okay. Now go ahead and, if you would please, as we come around in the kitchen and you indicate that you see a body laying in that area, go ahead and describe exactly what you saw.
The victim was dressed in sweats. She had on a a shirt and sweatpants. Again, she was in a semi-seated position. As I leaned over without stepping on one of the two steps that led up into the hallway, I observed that, again, what appeared to be large quantities of blood all over the floor, all over the victim, her hands, feet, her clothing, the walls, the several steps going up into the hallway. At the bottom of her feet, there were shoes, white tennis shoes, socks, a pair of clear gels which were not touching her, or at the bottom. There were paper towels around the body, and there was a towel under her head.
All right. What was the condition of the blood on the floor?
On the floor in the hallway, the condition of the blood was, it was dry.
Okay. Could you tell what the condition of the blood was on the stairs?
It was dry.
Could you tell?
From my point of view, where I could see, it was dry.
What was the condition of the blood on the walls in the stairway, if you could see that?
It appeared to be dry. It appeared to have been either wiped or smeared.
Okay. Now, once you made that observation, what did you do and what did you see?
The first thing that came to me was the amount of training that I've had at this, and it was my understanding too at the time that this was either a cardiac arrest or respiratory arrest, but also, and I don't remember who it was that said something that Mrs. Peterson had fallen down the steps. With the training again that I've had, this did not appear to be what I could.
Go ahead.
From what I observed in the stairwell, this did not appear to be what I would have considered a fall down the steps.
And why is that?
I have been in the 20 years that I have been in the EMS profession, I have been on I've had a chance to go on several occasions where I have personally witnessed injuries from falls on carpeted steps and on wooden steps. And the most severe injury that I've seen was probably a broken bone on the arm.
Okay. Now, based upon your opinion that this wasn't a fall, what other observations did you make? And then with that opinion and those observations, what did you do?
Based on what I had observed, I made a decision to completely leave the residence and have a CID, which Criminal Investigation Division of Durham Police Department contacted. That was my personal choice, was to completely back out of the residence.
Now, before you did that, did you see anybody else in that area?
Yes, sir. As I was backing out, the door facing the Cedar Street side, which is in the kitchen, opened up, and I observed, and I didn't know it at the time, that it was Mr. Peterson come running in through the patio door, and he was moaning and groaning, and he was completely covered in blood.
How was he dressed, if you recall?
He was dressed in shorts and a T-shirt.
Okay. And with the actions that he was making, what did he do based on what you saw?
Again, as I was backing up, Mr. Peterson came running through the home, and he was moaning, and he ran through the home over to Mrs. Peterson's body.
Now, before you get there, did he have any shoes or socks on him?
No, sir, he did not.
Okay.
The only thing I observed him wearing was a pair of shorts and a knit shirt.
Okay. And you say that he went over to Miss Peterson's body?
That's correct.
How did he do that?
He walked over to her, knelt down beside her, and then sat down on the step facing her.
Okay.
And then he put his arms around her, and he was still sobbing.
Your Honor, at this point, I'd ask that Mr. George be allowed to conduct a demonstration of those actions. Let me show you what will mark as State's Exhibit 147 and ask whether you're familiar with what this is.
Yes, it's called a recessa anni, which we in earlier years used as a CPR dummy.
Now, with respect to what you observed of Ms. Peterson's body, would you say that Annie is about the same size overall?
Yes, sir.
Okay. Could you use what's marked here as State's Exhibit 147 to assist you in describing the actions that you saw Mr. Peterson make as it related to Ms. Peterson's body?
Yes, sir, I can.
Your Honor, could it come down, please?
Yes, sir.
Now you go ahead and place Annie as you saw Ms. Peterson's body. If you presume that this is the door jamb, this right here, okay? Place Annie in Ms. Peterson's position.
It'd be kind of hard to get this.
It's kind of hard, isn't it? Okay.
Oh, you know, like for George to stay in the city, so that was.
I think they are. Now, I noticed that you have elevated a little bit. Describe what this area would look like.
This would be the entrance to the stairwell, which the first 3 steps of the stairwell were angled. They weren't straight steps going into the stairwell. So this would be stepping into the stairwell with 3 steps cut at angles prior to the original steps going upstairs.
Okay, now back here, if you would, kind of position yourself to where you were located in relation to Mr. Peterson's actions, if you would, please.
Well, this being a hallway, this being a stairway, there were 2 steps beside Mrs. Peterson that stepped down from a landing into the kitchen. As I entered the residence and came around the counter, probably at this position where there was a hallway with the 2 steps, and I stepped to the side and was able to look in and see the body, the blood, and down there.
Okay. Now, how close did you, at this point, how close did you go to Ms. Peterson's body?
To the body, probably within 4 feet, 4 to 5 feet.
Okay. Now, I think you indicated that once you made those observations, you backed out.
That's correct.
And you were doing that for what reason?
Again, based on my training, this did not appear to be, to me, a fall down the stairwell.
And what did that mean to you?
With the amount of blood that I saw in the bottom of the stairway, that this would have been something that would have been other than a fall.
Okay. Based on your training, was it your decision then that this area needed to be processed?
Yes, it was.
Now, as you backed out, go ahead and describe what you saw as related to the actions of Mr. Peterson.
Well, again, as I was backing out, I was coming back around when to my left I saw Mr. Peterson come running through the patio door.
Okay.
And he ran right past me. I mean, we were brushing one another. He ran past me and he ran over to the body.
Excuse me, let me interrupt you. Where was Officer Figueroa at this point?
He was still in the kitchen, at the point of the kitchen in the cabinet.
Okay.
And Mr. Peterson came running in, went right straight to the body.
And did Officer Figueroa say anything to Mr. Peterson when he did it?
I think that it just happened so fast.
Objection as to what he thinks.
What did Officer Figueroa say anything at that point?
No, sir, it happened so fast. I mean, it was a flash.
Okay.
I didn't even really have a whole lot of time to react because, again, as I was backing out, he came running through the house.
Okay, go ahead and describe what he did.
Well, as I was standing there, and again, as I was backing out.
That is weird. Why would he do that? That is weird. He's already... He's the one that found her. This camera's going to be the death of me. He's the one that found her. Why would he run in and go grab her body like that? He's already found her and seen that she's gone. Why would he wait till the police get there and then run in and grab her again? this man. I swear. That was an act for the cops. Had to be.
He came running up to Mrs. Peterson, and there were 2 steps there with the landing to the hallway. He walked over, he ran over, and he bent down this, similar to this. He turned around, and he grabbed, put his arms around it, and was doing this.
Okay.
At no time did I ever see him pull her head away from the wall, put her in his arms to caress, bring her to him, or make any other motions other than holding her in his arms and crying.
Okay. Well, what period of time did he do that?
Just a minute or two. There were some officers that they had called to get Mr. Peterson, and by the time the officer Figueroa had seen this, he went over, and then finally, I think they'd asked him he would not give away from his wife. So then another gentleman came in, which again at that time I had no idea who he was, which I later learned it was his son Todd.
All right, and what happened? What did you see there?
He was trying to coax his father to leave, and he wouldn't leave, so he physically put his arms around his father and picked him up and moved him around and set him down on the couch that was in front of the fireplace.
Did Officer Figueroa do anything or give any instructions?
I don't recall at this time. I was trying to get out of the home.
Okay. Now you say that Mr. Peterson's son lifted him up, and at that point, where did they go, if you know?
He walked back around through the little hallway there into what was a breakfast nook area there was a fireplace in it, like a den, and he set him on a couch there in the den.
Okay. At that point, what did you do?
I can't help but think, because he had Deaver is a problem because he lied on the stand. But in the documentary, I know I keep referring to the documentary, but I think some of the things that they pointed out in the documentary are important because Deaver lied. There was one scene where they showed he was trying to reproduce some spots that were on the shorts because it was just a mess of blood, obviously, because that's what he was doing. I didn't know that. That's not in the documentary. All they said was that he hugged her. It didn't say like he was laying on top of her like that. I think he must have known that the blood spatter on him was, I'm not going to say the word, the S word, the suspicious word. So he must have looked suspicious. So he decided to lay on her and just get the blood to obscure the pattern. Because in the documentary, Deaver is trying to reproduce the stain. He's got one of those sponges with blood, and he's got, I don't know if it was one of the blow pokes or if it was a crowbar or what, but he kept hitting it with the shorts. I don't know if they were holding them up or if he was wearing them or what, but he kept hitting it, and they kept doing the test over and over and over until they got the result they wanted, which is confirmation bias. You don't do an experiment over and over and over again until you get the desired result. That's not how that works. And then the other person that was helping him, she jumped up and like did a little dance when they finally got it to do what they wanted it to do. So when they got it to do what they wanted to do, it made like the one little pattern on his shorts that made it look like he was standing there, and it was like cast off from that blow poke where he was hitting her with it. So I think maybe that's why he laid on top of her like that, was in case any of the blood on him was like a pattern. and this is just my opinion, but that's what I think. That's why I think he did it. Like Michelle said, he was contaminating the scene on purpose because they said he was covered with it, with the red stuff. So why else? I mean, because he, like I said, he found her. Why would he run in like that and grab her? Like, that's what you do when you first see that your loved one's like that. You know, like, I don't know. This man is just, the hubris is ridiculous. He just thinks he's all that in a bag of chips. It's just.
Went ahead and exited the residence.
If you take your seat first.
Said, hi guys, and I'm all let's up all over the privacy will have to do it on him.
Now, at any point did you see Mr. Peterson actually sitting on Ms. Peterson's legs?
Wasn't really sitting on her legs. No, sir. Her legs were spread apart, but he placed his bottom beside her right leg, and not any time did he ever sit on her. No, sir.
And I realize it's kind of difficult there because we don't have those steps, but you'd indicated that at least to her right there were a couple of steps down. With respect to Mr. Peterson's body, exactly where was he in relation to those steps?
I don't think that is.
He was sitting above the steps on the landing itself. In other words, they were almost practically facing one another.
Okay.
Had she been in a seated position, he would have been practically facing.
But I mean, where were his legs?
His legs were down below the two steps on the floor.
Okay. Now, you say at that point, once you saw Todd Peterson assist his father and place him over in the couch, you backed out of that area.
That's correct.
Okay. And exactly why did you do that, and describe what you did after you made the decision?
Excuse me. As I was exiting through the kitchen, I turned to Patrol Officer Figueroa and I asked him, had CID been notified? And he said, yes, they were en route.
Okay.
So I backed completely on out of the residence at that time.
And what did that mean, CID was en route to you?
That the Criminal Investigation Division from the City Police Department had been called based on a decision, not by myself, but someone else, that they felt that this was more than just a fall down the steps.
Objection. I think the testimony was that said he was called whenever there was that. Well, the question was, what did it mean to you?
Oh, go ahead.
So I exited. As I was exiting, I got back to the front door, and again, the city firefighters and the paramedics were still on the scene. As I stepped out on the front porch, I observed what appeared to me to be a drop of blood.
Okay. Generally, where was that located?
It was on the front porch, a slate porch of the residence leading in from the Kent Street side.
All right.
I also noticed on the interior of the door, there were a set of keys there, and there were blood smears on the back of the door and the door molding.
And this is the front door?
This would be the Kent Street door.
Kent Street door.
Yes, sir. It's a door that we entered and exited.
Okay.
I turned to one of the paramedics, Jay Rose, and he said that he had observed that and wanted to make me aware of the drop of blood that was on the porch. And by exiting the home, I went to my vehicle and I got a flashlight, and we looked for other traces of blood or blood droplets along the walkway.
Did you locate any?
We found one, what appeared to be a droplet of blood that was staining between the two bricks because the front porch was slate and the walkway was brick. We did find one other trace of what appeared to be blood.
Okay. And generally, where was that located?
Approximately 5 to 8 feet from the first droplet. It was in the walkway.
Okay. Now, after you made those observations, what did you do?
I went up to my vehicle and waited for Art Holland to call. Also, Art Holland, he was in route anyway because they had called him, or the investigator. And again, at that time, I didn't know who the investigator was, but I made a contact to communications to notify my on-call supervisor for him to respond to 1810 Cedar Street.
Okay. Now, when you entered the residence, how were you clothed?
That night, I was clothed in a work uniform, a nylon windbreaker jacket, and boots.
When you say boots, what kind of boots?
They were duty boots.
Okay. When you make your initial entry into the house, do you put on any protective clothing at that point?
When I made my initial entry into the home at 1810 Street, I did not put on any type of protective clothing because of the nature of the call that we had received.
Okay. After you had seen what you saw, did you then put on protective clothing when you went in the house again?
When we re-entered the home, yes, sir, we did.
Okay.
Now, we were covered with, at many times we were covered with full Tyvek suits and booties and gloves.
Okay. Now, and why do you put those things on?
So there won't be cross-contamination.
Okay. Now, I think you'd indicated that after you left the residence, you were standing by waiting and you had talked to your supervisor.
That's correct.
Okay. What's the name of the supervisor that you talked with?
Eric Campen was supervisor on call.
Excuse me. And why did you call him?
Anytime that there is a major scene, a supervisor is to be notified and to respond to a scene.
And when you say major scene, what do you mean?
Anything that would be a shooting, a stabbing, anything above and beyond it could be an armed robbery. It could be a shooting, stabbing, homicide, suicide. The supervisor is to be notified.
Okay. And about what time did you call your supervisor?
It was approximately, all this happened in just a matter of minutes. I would say around 3:25.
Okay. Now, go ahead and describe what you were doing. Well, what did you tell your supervisor?
I'm sorry?
What did you tell your supervisor?
Well, it would pass through communications.
Okay.
And he in turn returned his call, and I told him that we had a crime scene at 1810 Cedar Street that, for the information that I had received, that the female had fallen down a set of steps.
Okay.
And that she was deceased at the bottom of the steps.
Okay. Based on your earlier testimony, though, that's not what you believed had happened.
No, sir, it isn't.
Okay. Did you relay that information to him at that point?
Not at that time.
Okay. Did you at some point later?
I did.
Okay. And what did you tell him with respect to that?
That there was a large amount of blood in the hallway. That at the particular time when we looked, I didn't see any injuries on the body. That she was covered in blood, and that I had observed Mr. Peterson also covered in blood when he came running through the house.
Okay. Now, while you were waiting for your supervisor to get there and others to get there, where were you located?
In a circular driveway on Kent Street side.
Okay. And if you would please, at that point, did you see anybody else in the area?
The police officers had, by the time that I had back completely out, they had put crime scene tape up, and they had established a scribe for entry and exit to the area. There were officers around, plus they had brought in the command post and set that up on Kent Street side.
With respect to putting up the crime scene tape and establishing the crime scene, did you help in any way with that?
No, sir, I did not.
Okay.
Well, the only thing that I assisted in was when I was backing out of the residence. Again, I was approached by Officer Kershaw, who had made a request if I had any crime scene tape, and I did get him some crime scene tape out of my car.
Okay. And at that point, you made the observations that the tape had gone up?
Yes, sir.
Okay. I think you indicate that you wait out in the circular drive area waiting for your supervisor to arrive and others, right?
Yes, sir.
At that point, had the mobile command post arrived?
They had been contacted, and I don't know. I don't really remember at what point in time they did arrive. I believe by the time that I got back out, they were pulling up, or shortly after that.
Okay. Now, while you were out in the drive waiting, did you observe any other activity?
No, sir.
At the next point where you do see activity, what time is it? And who would have been involved in that?
Art Holland arrived on the scene.
Okay.
And
approximately what time was that, if you recall?
I don't really remember what time it was.
Okay.
And I advised Art of what I had observed when I had entered the residence. And it was shortly after that that Eric Campen showed up, the supervisor on call showed up to assist.
Okay. And what did you all do when Investigator Holland and Mr. Campen got there?
He stated that he would have to leave, and after I explained to him.
Who's he?
I'm sorry, it was Investigator Holland. Art Holland said that he would have to go and obtain a search warrant to enter the home.
Okay. And to your knowledge, did he do that?
Yes, sir, he did. And
now, what did you all do in preparation for that search warrant, if anything?
Due to the size of the residence there and the nature of call in which that we had as far as the crime scene, we started making other calls to other crime scene technicians to assist in the call.
Okay.
The crime scene tape had been put up at the front door, which would have been the Kent Street side of the residence. And so Eric Campen and I rewalked the walkway to the front porch, where I showed him the two droplets of blood. We placed two small pieces of paper beside each one, and then placed a planter on the one on the front porch.
And why'd you do that?
We didn't want it contaminated.
Okay. Yeah, go ahead and describe what you did after you and Mr. Campen took those actions.
Well, we went back to our vehicles and waited for Art Holland to arrive with a search warrant.
Okay.
We were getting our equipment ready to enter the home.
And when you say getting your equipment ready, what kinds of things were you going to be doing?
We knew that we were going to have cameras, fingerprint kit, video cameras, and all of our personal protective equipment that we had. Plus in any case, we have to set up a bag for whenever anyone enters or exits the home, they have to put on booties, and when they exit, they have to take them off and put them in a bag. So we have to have that set up.
And y'all provide all that for
yes,
those
sir,
folks? Okay. Did you do that actually? Now go ahead and describe, if you would, describe any other preparations you made in order so you could go back in and process that scene, if you did that at that time.
We didn't do it at that time.
Okay. At some point, did Investigator Holland come back with the search warrant?
He did.
Approximately what time was that, if you recall?
6 o'clock.
Okay. What did you all do?
In the case that we normally work with our investigators when they arrive back on a scene with a search warrant, the search warrant is served. And once the search warrant is served, then we'll walk through a scene with an investigator. either the lead person or it may be two people who are in our unit that will walk through with an investigator to observe things that are there. There will be points pointed out.
Okay. Now I want to make sure I understand. You're doing this with Investigator Holland and with whom?
Myself.
And anybody else?
Not at that time.
Okay. Now, you'd indicated that you had called your supervisor, Mr. Campen.
That's correct.
Now, once you are there and you make the decision to call your supervisor, when your supervisor gets there, who's in charge of processing the scene?
I'm initially in charge, under his supervision.
Okay. Is one person designated the lead investigator as it relates to the collection of evidence?
Yes, sir.
As opposed to the other?
That's correct.
Describe for the jury how that happens.
We have 13 ID techs in our unit. We work on rotating shifts, and when 911 dispatches a call, usually the person who takes the call and proceeds is usually the person who is in charge, unless the partner that they have or a supervisor or someone else designates someone else to be a lead person on a case.
Now, at that point, you're the lead.
That's correct.
Did Mr. Campen at any point designate anybody else as the lead?
No, sir, he did not.
Scene processing?
No, sir.
Okay. You say that you and Investigator Holland went into the home after the execution of the search warrant and did a walkthrough.
That's correct.
If you would, please describe for the jury how you went about that.
Well, we entered with our booties on at that time, walking into the Kent Street side of the residence. We walked the north wall or the north hall back down to view the body from that side, and we ran back through the kitchen, through the entrance foyer, back around and viewed it from that side. I also went down from the top of the stairway, observed.
Okay. Once you made those observations, what did you do?
I backed out again of the residence, and then we prepared Eric Campen and myself, along with Angie Powell, ID 10, who had arrived on the scene, and we set up a plan to go back into the residence. I went in as videotaping, and Angie went in as a photographer for me.
Okay. Now, when you go in with Investigator Holland to do that walkthrough, exactly why are you doing that?
To view the scene and to observe anything that we think would be out of line or just to get a feel of the crime scene itself.
Okay. Are you trying to make decisions about what you believe may have evidentiary value?
That's correct.
Now, you had indicated at that point that you have yourself and Mr. Campen and Angie Powell. Was anybody else involved that you recall?
I'm not really sure at that time whether Investigator Holland was with us or not.
Okay. And I think you said you were actually conducting the video.
That's correct.
Documentation.
That's correct.
And exactly what was Mr. Campen doing?
He was just in as an observer, and he was directing. Okay. Again, as I stated, we're working under supervision of Eric Campen.
And Ms. Powell, exactly what was she there for?
She was there as a photographer for me at that time.
Okay. Now, with respect to being the lead, is it your primary responsibility to document the collection of evidence?
That could have been anyone. If I could have done that, Eric could have done it, or Angie could have done it. We work as a team.
Okay. With respect to who actually did it, though, whose responsibility did it ultimately fall to?
Mine.
Okay. And did you go about the process of documenting what you did and how you went about collecting evidence?
I did.
Okay. Now, if you would, please go ahead and describe to the jury how you went about processing the scene, and in particular, what you did.
On that particular scene, we went in. I started at the front door because I had already previously videotaped from the driveway to the front door without entering the residence. Once we entered the residence, then I tried to go in and do a 360 at the point of entry, which was again the Kent Street side of the door.
Okay.
Videotaped the entrance foyer and both hallways, showing the body of Mrs. Peterson to the left, which would be the north hall. We went around through the entrance foyer into the dining room, into the kitchen, back around and videotaped there. While I was doing this, Angie Powell was behind me with 35 millimeter photographing. Then we went back around, went upstairs, and came down the stairwell and videotaped from the upper stairway going down.
Okay, once you made the videotape, what did you do?
I think we backed out of the residence and then was making decisions on how to further process the scene.
Okay. And at that point, did all three of you, Ms. Powell and Mr. Campen himself, back out of the
Yes,
residence? We did. Did you have any discussion about how you're going to further process the area?
We were concerned. We were really concerned for the amount of blood that was in the bottom of the stairwell, and I think Eric Campen and I made the decision to see if we could get assistance from the medical examiner's office.
Okay. And what did you do with respect to that thought?
There was contact made with the medical examiner's office. Dr. Schnell was medical examiner, stated that he was on his way home and that he would swing by 1810 Cedar Street to assist us with the examination of the body.
And you did this after you had actually taken the video of the area?
That's correct.
And before you took the video, did y'all move anything?
No, nothing was moved.
After you took the video, did you move anything before Dr. Snell got there?
No, not before he got there, no.
Okay. Go ahead and describe, if you know, what happened when Dr. Snell arrived.
Dr. Snell was met at the command post and briefed of the situation of what we had inside the residence. And once he was briefed, then we left the command post and proceeded to
when you say we, who was involved?
Eric Campen, Dr. Schnell, and myself.
Okay.
We proceeded to the front door where we suited back up again with our personal protective equipment, and we entered the residence. As we approached the body of Mrs. Peterson, Dr. Schnell had a surprised look on his face, and he was very concerned. He was very concerned the amount of blood that was in the bottom of the stairwell.
Did he verbally express that?
Did he normally express that?
No, did he verbally express?
Yes, sir, he did.
Okay. And exactly what did he say, if you recall?
Well, he was just concerned at the amount of blood. We were all concerned because we didn't know where the blood had come from.
Okay.
We went back to the front door. We got a body bag, and we took it and opened it up beside Mrs. Peterson's body. We pulled her forward, leaned her forward to try to examine her body to see where the blood had come from.
Okay.
At that particular time, we found a large laceration in the rear of her scalp. And Dr. Snell had made a statement that he was really concerned about the amount of blood that he had. He did observe approximately a 4-inch laceration to the back of the skull, and that this could have been caused or may have been caused possibly by a fall, but he was not sure, and he would not make a determination until an autopsy had been performed, and that he would personally assist in the autopsy at Chapel Hill.
Okay. Did he indicate any further information to you about any other injuries?
No. He said then that it appeared to be maybe 3 or 4 injuries. He wasn't sure at the time. He wouldn't make a determination until the autopsy was performed.
Okay.
Your Honor, I have a continuing objection to hearsay statements by Dr. Snell.
Yes, Mr. Harden, what's the purpose of the statements?
For this officer to do some of the things that he did, that information would have been relevant.
All right, objections overruled. You have a standing objection.
And we have an instruction to the jury that these statements are not to be taken for the truth of the matter.
So the state of North Carolina is eliciting from this witness statements made by another person. However, the state is not attempting to introduce what the other person said for the truth of the matter asserted, but only to explain to you why this officer why this witness took certain actions as a result of the statements used for. You are to consider it for that purpose and that purpose only.
Now, once Dr. Snell made those comments, and I think you had indicated that you brought a body bag.
Yes, we did.
What'd y'all do?
Well, like I said, we opened the body bag up and placed it in an open position where we could take, because of where the body was positioned in the hallway, we really and truly had no room to work as far as examining the body for further injuries. So we placed the body bag beside her. Once we moved her upper torso away from, that's when we observed the lacerations to the back of her head. And we placed her in the body bag and moved her further out into the hallway to where we had room to examine the body further to see if there were any further injuries that were sustained by Mrs. Peterson.
Go ahead and describe what you all did to make that determination.
She did have medical leads on her, which was placed by either the paramedics or the firefighters. I observed that she did have leads on her. We examined the front part of her body and observed the back part of her body to try to determine if there were any more lacerations or injuries to the body.
Now, with respect to the condition that Ms. Peterson was in, and in particular related to her clothing, did you have to touch her clothing in order to make the examination?
Yes, we did.
Do you recall whether the areas of blood on her clothing was dry or in some state of wetness?
The top of her clothing was damp, but it wasn't wet. The bottom part of her clothing was saturated. I mean, it was dripping with what appeared to be blood.
Okay. Now, when you pull her away, based on what you're saying, it looks like Dr. Snell makes an initial examination, and then you all pull her.
I've had checked to the lead.
Well, it's not necessarily a lead, but you need to ask him questions and not make a statement.
Yes, sir.
If you want to know what the doctor said, I think you can do that. But sustain.
After the initial examination, what did y'all do?
After initial examination, then we did find the laceration to the back of her head. We placed her in the body bag.
Okay.
And moved the body bag with the body further down the hallway for further observation.
And with respect to other examinations, what did y'all do?
We just checked the body for further injuries.
Okay. And about how long did Dr. Snell stay there and conduct that observation or examination?
Probably 10 minutes, no more than 10, 15 minutes.
With respect to how you positioned the body to make those examinations, what did you do?
We laid her in a supine position in the body bag to where we were able to roll her from either side to observe the body.
Okay. Now, once you had made the examination with Dr. Snell, what y'all do?
Mortuary services was called to come and remove the body and take it to Chapel Hill for an autopsy.
Okay. Once that was done, did you stay there at the scene with Ms. Peterson until the mortuary services?
Yes, I did.
And, about what time is this, once this all occurs, if you remember?
8:30.
Okay. Now, you indicate the mortuary services gets there. About what time do they remove Ms. Peterson's body?
I don't recall what time they actually got there.
It was obviously sometime after that.
Yes, it was.
Okay. Now, before Miss Peterson was removed, did you take any personal items from her?
Yes, I did. I took a Rolex watch off of her wrist.
And why did you do that?
It's not our procedure to send or we try to remove all jewelry from bodies before we send them to the medical examiner's office. And that would be, or to a funeral home or wherever they go, and that would be just part of the evidence that we were collecting. It was covered with blood.
Do you recall any other jewelry?
No, sir.
Did you take any other personal items from her body?
Not from her body.
Okay. Now, I think you indicated that you were standing by until the mortuary services got there to remove her.
That's correct.
What were you doing during that time period? Just waiting?
Yes, sir.
Once she was removed, what did you do?
Eric Camp and I started looking the stairwell over from there after the body was removed, because we were able to get in there. Again, we made a decision for someone who was a little bit knowledgeable of blood spatter, for blood spatter interpretation.
Why'd you do that?
Because of the excess amount of blood that was in the stairwell.
Okay. And with respect to the opinion that you'd formulated that was necessary, what did you all do?
We contacted ID3, Rebecca Reed, to assist us on the scene.
Okay. And what happened?
And she later responded to the scene. But due to the excess amount of blood that was in the hallway and on the floors and the door casings and all, she did not feel comfortable. So we then made a determination to contact the State Bureau of Investigation for blood spatter expert to arrive to assist us.
Okay. Did you do that?
Yes, we did.
Do you know who was contacted?
Agent Dwayne Deaver.
Now, did he get there immediately, or was there some time lapse before he was able to arrive?
There was some time lapse. There was maybe an hour or so of time lapse before he got there.
Okay. Now, if you would please go ahead and describe what you did after Ms. Peterson's body was removed, if you recall.
That's when we waited for ID3 to arrive on the scene.
Okay, and once she got there and you made the decision that you needed to call someone from the SBI, what did you do?
We waited for her to get there. And then whenever we made that decision, it was sometime later on that evening, or the night was going into the afternoon, that I told Eric Campen that, and I'd been on the scene since early that morning, that I needed to take a break.
Okay. Now, between the time period where Ms. Peterson's body is removed and Rebecca Reed gets there, and then just after, at that point, other than collecting the Rolex watch from Ms. Peterson's body, did you go about any other collection process?
Yes, I collected the clothing that Mr. Peterson was wearing.
Okay.
I also collected Mr. Peterson's watch, and I collected clothing from Mr. Peterson's son, Todd.
Okay.
The clothing that I collected from Mr. Peterson, I collected from his study, his library. They were in the west windowsill of his study. And his son, Todd, handed me his clothing, and I packaged that up.
Were there any other items that you collected in addition to Mr. Peterson's clothing and Todd Peterson's clothing at that point?
I collected, there were some socks and tennis shoes that were collected that were near the body of Mrs. Peterson.
Okay.
I think that's about all we collected at that particular time.
Now, you indicated that you had collected clothing from Todd Peterson.
That's correct.
Specifically, what items did you collect from him?
From Todd?
Yes.
A pair of jeans, a knit type T-shirt, a dress shirt, pair of socks, and a pair of shoes.
Okay. And you say he gave those to you?
That's correct.
Where were you located when he gave them to you?
In the den, in the study.
Okay. Now, with respect to Mr. Peterson's clothes, I think you indicated that you got those out of the study.
Yes, sir.
What'd you do with those once you recovered them?
Once I packaged the clothing up in a paper bag and placed them in the hallway for that. That was my collection point. And then,
excuse me. Now, in the study, was there an officer in that area?
There were several officers in that area.
Okay. Do you recall who was in the area of the clothing?
No, sir. I don't remember who the officers were. No, sir.
Okay. Was there any indication by any officer there directing you to pick up the clothes at that particular location?
I was just informed that the clothing had been placed in the window, and that's where they were at, and that's where I collected them.
Okay. Now, with respect to that clothing, exactly what did you remove?
A pair of khaki shorts and a knit shirt, the same clothing that he was wearing when I first observed him when he came running through the kitchen.
Okay. And I think you indicated that you also collected some tennis shoes and some socks near Miss Peterson's body.
They were beside Mrs. Peterson's body, yes, sir. They were in the hallway.
Okay. And then you collected Todd Peterson's clothing, and you've already described that.
That's correct.
Did you recall collecting anything else at that point?
No, sir. I don't remember collecting anything else.
Ms. Harden, we'll take a 10-minute break at this time. Members of the jury, remember the instructions I've given you throughout the course of this trial. 10 minutes, Mr. Depp.
We'll stand recess for 10 minutes.
We have a standing objection. I think we're getting ready to start putting in stuff from the search, and I just want to make sure I have a standing objection to the admission of anything obtained during the searches based on our motion to suppress previously ruled upon by the court. And
all right, yeah, that's allowed.
Thank you. So I don't have to continue to make an objection each time.
Right.
Thank you.
All right, sir. All right, further questions, Mr. Hall?
Yes, sir. Now, Mr. George, let me backtrack just a little bit with you. You had indicated that the mortuary service removed Miss Peterson's body, and I think you were describing the condition of her clothing when you observed it. Now, I want to go back over that just a little bit because I don't think I asked you about every aspect of the clothing. Let's just stay with the shirt. With respect to the top of the shirt, I think you'd said that it was damp.
Yes, sir.
Okay. When you say damp, exactly what do you mean?
It was not completely dry, but it was moist to the touch.
Okay.
And that was with the blood that was on the shirt.
Okay. When you say moist to the touch, was blood coming off on your gloves?
No, sir, it wasn't. Well, no. It was dry enough to where it was not coming off.
Okay. Now, with respect to the back of her shirt, did you put your hand back there?
I did.
And what was the condition of the shirt?
It was the same way except for down the center of the shirt.
And what was unusual about the center of the shirt?
It was saturated enough to where that was transferring blood from the clothing to my gloves.
Okay. Now, with respect to the sweatpants, you indicated that the back was dripping.
Yes, sir.
Okay. Exactly where was that, if you recall, on the back of the pants?
Just in the seat of the pants, and where the blood had come down through the back of the shirt into the seat of the pants, and that was just where her bottom was on the steps.
Okay.
And then the bottom of her legs. That was the bloody part of the pants.
And when you say dripping, exactly what? I want you to define that for me.
Well, it was wet enough to where when we picked the body up and set it into the body bag, there were droplets of blood dropping from the clothing, from the pants themselves.
Okay. Now, what about with respect to the top area?
No, sir. It wasn't enough for transfer blood from the clothing to the glove, but it was moist.
Okay. Now, I think you'd indicated that you, once Miss Peterson's body was removed, that you'd gone about the collection process of some items.
That's correct.
You had described collecting Mr. Peterson's clothes and Todd Peterson's clothes. And I want to get a little better handle on about when that was. It was after Miss Peterson was removed, is that right?
Yes, it was. It was between 9 and 9:30.
Okay. Could have been later, could have been earlier?
Yes, sir.
Okay. But it generally in that area?
Yes, sir.
Okay. Now, when you actually took Mr. Peterson's clothes from the windowsill, exactly what did you do with those?
I took them and walked back into the hallway, and they were placed in paper bags, labeled, and put down with the collection of property that I had started there in the entrance foyer of the home.
Now, why would you put items such as that in paper bags as compared to some other bag that you
plastic sweats.
Okay.
Paper is porous to where it breathes, and it won't cause the smear of blood inside the plastic.
With respect to Mr. Peterson's clothes, could you tell what condition they were in?
His clothing was still moist. I mean, it wasn't transferable again to the glove, but his clothes were moist enough that you could feel that they were moist.
Okay. Now, you'd indicated that you put those in a bag. Did you put them together in a bag, or did you put them in two separate bags? How'd you do that?
Well, I put them in the same bag because they were to be taken back to headquarters and placed in our drying cabinet to be completely dried before we packaged them up.
And how did you place them in the bag?
I semi-folded the clothing to put in the bag so that they would go in there neatly, but it wasn't a wadding or a crushing of the clothing.
Okay. Now, with respect to the socks and shoes that you recovered near Ms. Peterson's body, what did you do exactly with those?
They were packaged the same way. They were put in paper bags by themselves. They had blood on them too, so they were to be dried also.
Okay. Did you put the socks in two separate bags, or were they in one bag?
The socks were in one bag and the shoes were in one bag.
Okay. And again, did you put those in a collection point?
Yes, sir. Everything that I collected was placed there at that collection point.
Okay. Now, with respect to Mr. Todd Peterson's clothes, you had indicated you went through the process of describing what you picked up there. If you would, please describe to the jury how you put them in bags and collected them.
Well, his clothes were packaged at that particular point at the same way that I had done with Mr. They were placed in paper bags and placed in the collection point and they were labeled of who I'd received them from and what was there.
Now, when you put all these clothes and various articles in bags, how do you secure that?
They're sealed and have a piece of evidence tape marked across the top of them with my initial.
Okay. Now, when you put the clothing in the bag, in particular, let's start with Mr. Peterson's bag, did you determine whether it was dry or not?
When it was in the bag?
Yes.
From the residence?
Yes.
No, it was moist. It was still moist.
Same situation with Todd Peterson's clothes?
In that particular case, yes, sir, I did the same way with those to make a determination when I got back to headquarters if they were dry enough to repackaged and be completely dried. They had to be checked to make sure they were completely dry.
Now, with respect to picking those things up, I think you indicated that there wasn't any transfer on your gloves.
No, sir, there was not.
Okay. Now, once you had collected those things, put them in the collection point, what did you do?
Eric and I viewed the scene again and back where Mrs. Peterson's body had been lying.
Okay. What'd you do?
Well, we checked the stairwell and the flooring, the steps. We just was searching for anything else that would lead us, to any evidence that we were to collect.
Okay. Did you remain at the scene for the entire day?
No, sir. I left around 2:00.
Okay. And when you left, why were you doing that?
My previous shift had started at 5 p.m. the day before, and I was tired, so I needed to leave to get a little rest.
Yeah, at that point, did you collect any other items?
No, sir.
And what did you do with the clothing when you left the area?
They were placed in my vehicle, and I drove back to headquarters, and they were placed in the drying cabinet for security reasons, for my purpose. That was evidence that I had collected.
Now go ahead and describe to the jury how you put the clothing in the drying cabinet and why you do that.
When I mentioned a drying cabinet with police headquarters, what it is it looks like a large walk-in refrigerator. It's vented. We have running water in there, and we have dividers. It's like a large closet, if you will, that's vented. And what we do with each crime scene, we decontaminate our scene, or decontaminate our cabinet with Clorox water. And our hangers are plastic hangers so that we can decon the hangers. I went back, opened it up, which is in a locked, secured room in the basement of police headquarters. I decontaminated my hangers, wiped them off, and took the clothing that was there. I spread out a clean sheet of paper in the bottom of the cabinet and hung the clothes on clean racks and separated them so that they could dry.
Okay. And after you did that, what did you do?
Then I went home.
Okay. How long did you stay at home?
Probably 5 hours.
At some point, did you come back to the residence?
I did.
And approximately what time was that?
8 o'clock.
Who was there at the residence, if you recall?
Eric Campen was there, and Agent Devers was there. He was inside the stairwell.
Okay.
He was doing blood spatter interpretation. He was doing blood spatter interpretation.
Okay. And were you there and observed while this was going on?
Yes, sir. I assisted.
And if you would, please describe for the jury exactly what you did.
Agent Devers, I'm not really familiar with, I haven't been to a blood spatter interpretation class or school. I just assisted him with pulling string. Pulling strings is he makes points of origin on blood spatter and pulls strings to try to determine the approximate height and area of where he feels that would be the point of impact, the way that the blood was spattered against the walls.
But you don't have any training in that?
No, sir, I do not.
Were you providing just support for him?
That's correct.
And about how long were you involved in that process with Agent Deaver? Was he already there doing it when you
He was. It was a very lengthy process. I'm not really sure how long it took because the stairwell there was a common stairway, but it was not really, it didn't supply us a whole lot of room to do a whole lot of working as far as trying to pull the strings.
Okay.
So it was a lengthy process.
How long did you assist him in that endeavor?
I'm going to say probably 2 hours.
Okay. Now, once he completed that process with your assistance, and who was someone else there assisting as well? Did you say?
Eric Campen was.
Okay. Once you had completed this that process, what did you do
with Agent Devers?
Mm-hmm.
Agent Devers had made a decision and had requested me to go back to police headquarters to view the clothing that I had collected earlier of Mr. Peterson.
And did you in fact do that?
I did.
Were there other articles of clothing there as well that Agent Deaver was interested in?
Yes, sir. The tennis shoes and the socks, as well as Mr. Peterson's clothing.
Okay. Which Mr. Peterson?
Mr. Michael Peterson.
Okay. Did Agent Deaver look at any other clothing?
He looked at all the clothing.
What other clothing are you speaking of?
He looked at Todd Peterson's clothing, and he looked at Mr. Michael Peterson's clothing.
Okay. At that point, did he look at Kathleen Peterson's clothing?
He did, because Angie Powell, after the body was removed, she went to the mortuary. She went to Chapel Hill and viewed the autopsy. So her clothing was there also. Yes, he did.
Okay. Approximately how long did he look at that clothing, if you remember?
Probably an hour.
Okay. And if you would please describe how you lay that clothing out so that he could actually make those observations.
Again, we have like drafting tables inside our blood room. I covered those again with brown paper from a roll to make sure that there was no cross contamination. The clothing was laid out and opened up to where he could view both the front and the back of the clothing. Plus, we turned it inside and outside and viewed the clothing that way also.
Okay.
But each piece was laid on a separate piece of paper to where there wouldn't be any cross contamination.
Once he had completed that process, what did you all do?
Then we cleared for the evening.
And approximately what time was that, if you remember?
It was after midnight. It was early the morning of the 10th.
Okay. Now, with respect to any other search that was conducted of that residence and collection of evidence, were you further involved in that?
I was.
At this point, before I get into that subject area, I'd like to have a videotape shown, please.
All right.
Let me show you what is marked as State's Exhibit 103 and ask whether you can recognize this, please.
Yes, this is a copy of the videotape that I made the evening of the night.
Okay, and I think you've talked about that to the jury. With respect to what is marked as State's Exhibit 103, you actually made the videotape.
I did.
Did you make this copy?
I did not make the copy.
But you've seen the copy?
Yes, sir, I have.
Does it accurately reflect what was on the original?
Yes, sir, it is.
Okay. Now, at this point, we'd move into evidence what is marked as State's Exhibit 103.
I've got no objection to that, but I would like to get the original so I can view the original myself at some point.
All right.
All I have is a copy as well.
Yes, sir, we can do that.
It's allowed.
Thank you.
Doorway. That was a horrible place to stop it. I will cover it up. Hardin has been reminding me of somebody this whole trial. I've been trying to figure it out, and I finally figured it out. He looks like Daniel Roebuck, who was on Matlock. Look, he's in a suit, in a courtroom, and everything. Doesn't he look like Hardin? Except Hardin's a little heavier. See? He was on Matlock. And I have a recent picture. Where'd the recent picture go? I just saw it. That's a recent picture of him. He's heavier now. But he's all gray. He's still a nice looking guy.
Trial, keep an open mind. Don't talk about the case, even among yourselves. Don't watch television. Read the newspapers about this case. No independent investigation. We'll still take come back at our regular time. You get a couple of more minutes extra. 12:45.
To do as we replay the videotape, I want you to narrate the location of the scene. I will be pausing things and I'll ask you to describe what is observed in that scene. And I want you to also relate that back to what is marked as State's Exhibit D2 so that the jury has a full understanding of exactly where everything is. Okay? You understand? Yes, sir.
Okay. I don't feel well. And there's only 3 people here, and one of them's me. So, what time is it? 3? It's almost 3. We're going to end it a little early today because I have a headache and I don't feel good. So, I'm going to go lay down. But I will be back at 8 o'clock in the morning. So, remember, be kind to people. Love your family, and Jesus loves you, and so do I. Bye, guys. I'm sorry. I really don't feel well. And I don't feel like watching a cop narrate a death scene right now. I'm going to go lay down with my bell. Okay, guys. Have a great evening. I will see you tomorrow. Bye.